arbitral award was delivered through KIAC. And out of these 108, 38 awards were challenged to the Commercial High Court of Rwanda, but no award from KIAC was set aside. The only award that the CJ did mention yesterday in his speech was an ad hoc arbitration, which was set aside by the Commercial High Court in Rwanda. For the moment, we have 8 lawyers who are enrolled with KIAC panel of domestic arbitrators and 10 who are enrolled on KIAC panel of international arbitrators. An author called Matthias Plazek said, arbitration is a sensible suggestion which is worth discussing. It's indeed worth discussing topics that are set for this discussion on this second day of the 9th East Africa International Arbitration Conference, like trends, investment protection, and sustainability in Africa's regional blocks, intra-Africa investment treaties and arbitration, curbing improprieties in investment arbitration. Here we'll be talking about especially things like corruption and so on. It's also worth discussing arbitration and technology. These topics were really timely to be discussed at this point and here at this conference. All the above mentioned topics are very important in our time and worth being discussed again by the participants to this conference, especially the practitioners. If I may just talk a little bit about the topic like arbitration and technology. It's clear that technology is changing our lives, including our practice, including arbitration. We have to strike a balance between the traditional way of sitting in a room like this with its advantages like body language and human interactions, and sitting behind screens in Kigali and attend an arbitration hearing in London or Paris without taking hours to travel. And I think this is cost effective, like the way it was mentioned yesterday. Allow me at this point to wish you all a fruitful day of the second day of this conference, and I'm sure that the speakers will enrich our knowledge. I also want to thank the organizers on behalf of the ELS, which is also a strategic partner of this very important conference. I cannot conclude my remarks without thanking GBS Africa and IR for believing in us and choose to partner with Rwanda Bar Association in organizing this important conference. We value our continued partnership and we look forward to keep working with you going forward as we promote arbitration. Again, allow me at this point to invite the Honorable President of the East African Court of Justice to give his remarks. I thank you.
Esteemed delegates from various partners from various countries, international and regional organizations, the organizers of this very important 9th East Africa International Arbitration Conference. I thought when I came here, I thought it was only for East African partners. But when I see there are delegates from Nigeria, from Ghana, so I was surprised, but which is also good. Your Lordship, the Judge of Appeal, your Worships, the Secretary General of the Rwanda, of the Kigali International Arbitration Center, and the President of Rwanda Bar Association. First of all, I wish to thank the organizers for inviting the East African Court of Justice As you may be aware, the East African Court of Justice is the judicial organ of the community, which has been established under Article 9 of the treaty, mandated to ensure interpretation and application in compliance with the treaty, as provided for under Article 23 of the treaty. Since the court was established in 2001, it has decided more than 600 cases. And as we are talking now, we have already received about 6 matters on arbitration. And Article 32 of the treaty, it gives the powers to the East African Court of Justice on dealing with arbitration. And as now, we have also made our arbitration rules. So this is a very important conference on arbitration, and we are happy for being invited to this very important conference. We have gained too much from here. And the matters we are dealing with now, we are also dealing with the matters on environment. You may refer to the famous Serengeti case, which was challenging the construction of a highway in the Serengeti National Park of Tanzania. But the East African Court of Justice gave a permanent injunction against the construction of that highway, because we thought it could be disturbing the ecosystem within the Serengeti National Park. We're also dealing with matters on trade. You remember, you may be aware of the famous BAT case. We're dealing with the matter of investment. And now we are waiting for the protocol, extension of the protocol to give jurisdiction on trade and investment matters. And the protocol is now underway of being ratified by all the partners. So otherwise, we are happy. We have gained too much from this conference. We are enjoying the hospitality from the government of Rwanda and from the people of Rwanda. This is natural justice. And the people of Rwanda, it is from the nature of well-receiving people. So we enjoy the warm welcome from the government, but also from the people of Rwanda. And we have been enjoying this kind of welcome. Otherwise, we wish you all the best. And we think also we will be gaining too much from the presentation of today, because at least they will touch some sort of to our court, because I've seen Justice Anita will be in the panel. So I think maybe it is from that, after the presentation, that I can put much input. Otherwise, I wish you all the best. I wish you also a fruitful deliberation. Asante sana.
Thank you so much, President of the ESCJ. Thank you so much, President of the Rwanda Bar Association, for your insightful remarks. Thank you again, SG, our host, for recognizing the different delegations that are here with us. Without taking much time, may I take this opportunity to welcome the moderator for the 6th session, the session which we moved from yesterday to today morning. And our moderator today is Barrister Alistair Thompson. He doesn't need much introduction because he was here today. Please welcome and welcome your panelists.
Thank you very much for that very kind introduction, and good morning, honourable and esteemed guests. Now, when I first came to Kigali, which was 11 or so years ago now, I couldn't believe that more than a decade later, I would have come to regard Kigali as really a second home. And it's been a great privilege to see Kigali and Rwanda developing into the confident success story that we see today on the brink of hosting this esteemed conference and hosting CHOGM next week. So it really is a real privilege and an honor to have been invited to speak here and now to have been invited to moderate this leadership panel and to introduce you to three of the region's most esteemed lawyers, and in two cases, jurists. They're true stars of the East Africa legal profession, and they're each going to talk about their unique and fascinating journey to the very top of the profession. I'm sure I can't do them full justice by giving details of their incredible careers, but I will just give a summary of each of them. So first of all, we are going to hear from Professor Gitu Muigai. I hope I've pronounced the name correctly, I'm sure I haven't. He is a leading jurist, academic, and practitioner from Kenya. He was the Attorney General of Kenya, and he's also served as a member of the Permanent Court of Arbitration in The Hague. And he's now a senior partner in the firm Mohammed Muigai in Nairobi. Our second esteemed speaker is the Honourable Lady Justice Anita Mugeni. She has had a long and hugely successful career in private practice and academia in Rwanda, and she's truly one of the leading Rwandan lawyers of her generation. She has huge experience of commercial disputes and advisory work, and since February 2021, she has been a judge in the East African Court of Justice Appellate Division. And last but not least, we'll hear from Kamo Karori. He's a hugely experienced arbitrator and counsel, and he's acted in some of the most significant international arbitrations, including the well-known ICSID case of Cortec Mining, in which the Kenyan state prevailed against the investor. Kamo is currently a senior partner and head of dispute resolution practice at DLA Piper in Nairobi. So we are truly privileged to have such an esteemed panel to give us today a fascinating insight into their careers, each of them unique. So please join with me and put your hands together to welcome our speakers today. Sit wherever you It's free seat. So wherever you go. So I think without further ado, and given that I've been reminded that we have to stick to the time schedule today, and just taking it in the order that our panelists have been listed in the conference rubric, I'd like to ask, first of all, Professor Gitu Muigai to talk to us and give us an insight into his remarkable career. Please, Professor, over to you.
Thank you. Thank you very much. I think I'm lost for words when I'm asked to talk about my career, because I consider myself right in the middle of it, not at the end of it. It's been my great fortune to be involved in arbitration in Kenya, East Africa, and indeed globally in a number of cases. I started off as a litigator, and my heart was in litigation, and I thought that this is where I would leave a mark. But somewhere along the way, partly frustrated by the inability of the courts to handle all the disputes with the timeousness that the industry required, I became attracted to arbitration, and I got to get involved with the Institute and took up the very early fellowships. I was reminding one of my colleagues here that in my time, there wasn't a fellowship exam as such if you were an advocate of 15 years standing, I think it was, you were permitted to take the award writing exam only. And in the year that I took that exam, we were 3 of us. I think it bears saying that it was a tough exam, because when the examiners brought back their verdict, 2 of those who took the exam had not satisfied the examiners. Since then, a lot has happened in the profession. It has grown in leaps and bounds. Some of the most distinguished arbitrators in Kenya are present in this room. I think the profession has made a good name for itself largely. I've continued to warn my colleagues by starting to warn myself that the battle is not won. There are still very many lawyers who are very skeptical about arbitration, and there are very many judges who are very skeptical about arbitration. And we need to conduct ourselves in a manner that wins over these pockets of resistance. And how shall we do that? I think we shall do that if we have integrity in the arbitral process, if we have very, very, very high professional standards, so that a good arbitral award must read as well as a good judgment, well-reasoned, and assisting the parties to appreciate what the arbitrator considered and why, and what he concluded and why. One of the big problems we are having, in my view, is that not all arbitrators are expeditious as we would want. And that gives our critics an opportunity to say, look, this process is as slow as the court, but more expensive. So we should take our chances in court. I think there are 2 allies that we have not yet exploited our relationship with. And yesterday we had a very wonderful panel of ladies who are in-house counsel. I think we in the arbitration world have not spent enough time with in-house counsel, sharing with them our experiences and persuading them that arbitration is a worthy process, that it has integrity, it has speed, it has privacy, and so on and so forth. The other group we have not persuaded enough are public sector lawyers, and we will never win if public sector lawyers are not with us. That is, the lawyers who advise government, whether in the state law office or in the various instrumentalities that are owned by the government. We need a dialogue with them. And as a result, I think we will improve the uptake on arbitration generally, but also an uptake on arbitration in our continent by our arbitrators through our arbitral institutions. My friend Kamal yesterday made a comment, a side comment, but which I think is a very, very novel point we should consider, which is this. Every country now has an arbitration center. Nairobi has one, Uganda has one, Tanzania has one, Kigali has one. I do not think we are leveraging sufficiently. So we have 4 arbitration centers that are not as strong and as dynamic as they would be if we had one East Africa International Arbitration Center. And we need to think about that so that we can strengthen the community and the legal order around it. As I was asked to say something about my own personal journey, I would like to comment on what I think is an unhelpful practice that is gaining root. Young arbitrators are coming to the profession, then treating the acquisition of paper qualifications as an end in itself. So a young arbitrator gains his membership, very quickly moves on to fellowship, very quickly moves on to be a chartered arbitrator. In the 10 years or so that he does this, he has only been involved in 3 or 4 arbitrations. I think we should have more emphasis on practical experience and involvement in arbitration work. And I think one of the better things we have done is to introduce some form of pupillage. In my day, there was nobody to mentor you or tutor you. You got your papers and off you went. And if you were appointed an arbitrator, you behaved like a judge. Now, this is another problem, a very serious problem. Because most of our arbitrators are practicing lawyers, when they form an arbitration tribunal, they behave as a judge with everything, including the title, my Lord Chairman. Yeah. And therefore, the procedures that the parties have run from the court to avoid, they are replicated. The tribunal begins to issue order after order on application after application, and soon the file is that huge. I think we should work to make arbitration much more informal, much more simpler, and so on and so forth. And training the new generation much more closely on the practical side, I think is something that I personally have found quite useful. And the other thing that I have found in my experience, non-lawyer arbitrators are intimidated by legal practitioners. So they open this wide latitude where the case never seems to have any direction. It moves in whatever direction the advocates are pushing it. And a firmer control of the arbitral process, in my view, is quite useful. I can return to some of those points if and when you permit me. I'll stop there.
Thank you very much indeed. And what I suggest is that we hear from our other 2 esteemed panelists. Before then, I will ask some questions and then we'll open it up to the floor. So please, Your Ladyship, please tell us about your experience.
Thank you. Good morning. It's not easy to talk about yourself, and it's never easy to talk about your experience because sometimes you don't know how you did different things, how you pursued the career. But as the theme is handing the baton, and I think I'm not yet on the stage of handing the baton. I'm still, but it is time to prepare the process of handing the baton. I'll talk about my experience as a practicing lawyer, and as I've been one of bar leader, and as a managing partner, and now a judge from bar to bench. There is also some changes and some challenges. So as a practicing lawyer, now I think I'm on my 24th years of practicing. I remember when I joined the bar, there was some sort of fear, and I think it is always the same when a young generation came in a profession. It seems to be a threat for seniors, because that's where I saw that the kind of handing the baton, maybe it should have started that period, but there is a kind of a conflict which creates itself. Instead of taking the young lawyers, try to train them, there is a kind of conflict between seniors and the young. That's where I think instead of start preparing that handover. So I've seen that, and through my experience, I got a chance not to meet seniors who I can say who will think or feel that we are a threat, but they took me and they trained me, and that's why I'm here. So I learned from that. I also took some young and I tried to train them as a trainer also and as a lecturer. By the time I used to teach. And from that experience, I think I made as a mission for me to continue to train others so that I continue to train and to prepare the succession. And as bar leader also, I was involved in different trainings and different, not only in trainings, but I was also in charge of discipline. You understand, you can't also share the knowledge without sharing also the discipline of lawyers. Lawyers are the same times arbitrator also. Sometimes they're arbitrators or they're counsel in arbitration. So there is also need of ethic. I remember when I was starting my profession, I had a trainer who gave us a picture of the importance of ethic through our career. He gave us a picture of, all of you, the car wash, these boys in the car wash. The way they are very expert in manipulating, to maneuver the car and at a small space. And he told us, but this guy, when you tell him to leave the compound and go in town and come back, he can't make it. And because of not knowing the rules of the road, the rules of the traffic. So ethic for lawyers is not on lawyers or for arbitrators, not only having the knowledge, not only having the intelligence and what, it's also having the rules on how to behave, how to conduct yourself. That's also, I think, one of most important in a career of a lawyer, to know and to behave so that you can I think, last in a career. And also, as it have not been a long time I've been appointed, now I'm in the second year as a judge, but also it was a kind of challenging. You can imagine from this side of the bar and being in the other side. But when I was appointed at Appellate Division, I came to know that it is not only being as a judge, the Appellate Division has also jurisdiction of arbitration. So I was very happy to learn that not only I'll be as a judge, but I will continue to practice my experience as an arbitrator through the ESCG, and as an arbitrator there, we have some cases going on, and I'm very happy to sit on that and to try to continue, because as a judge, I was thinking now was time to hand over, but it was not. So what are strategies to hand the baton? As I said, handing the baton is not done by surprise. It's a long process. For me, and for maybe if I talk with me and my law firm here in Rwanda, which is one of the big law firm, MRB attorneys, we learned from our elders, and when in civil law, every lawyer is a law firm. You may have like 100 lawyers, and those 100 lawyers, they have all 1,000 lawyers, they have all of them a law firm. And when I used to amaze myself when I see Maitre, because we use sometimes those titles, Maitre Mungeni and associates. Yet you are one, you are not more than one. And when these ideas were merging our small law firm, which I used to call small boutiques, we, in 2009 and 2008, we lost many of our seniors lawyers. They were running not small law firm, their law firm were big, but they were alone. So they didn't prepare the succession. From that experience, me and my partners, we sat down and said, what the legacy we will leave behind. So we're like four, we merged our small boutiques to make a supermarket, if I can say it. So from that, our mission was to train other young lawyers. Now we have, from 4 partners, we are more than 10, 15 lawyers in one law firm. So we trained lawyers from scratch from school. So now we can say the handing pattern is ongoing. So that also is one of my experience and what I think can say another way to prepare. I used to do some trainings to invite my colleague, especially my Rwandan colleague, or to leave these small law firms and to get together. By that, getting together, you learn from each other, and then the succession will come itself. You learn it and you train others who will come after you. And that also is one of the strategies which I can say, you merge those small boutiques, small law firms, and you make it bigger, and you bring on board other young and who will learn from you. Other strategy is to train women. I want to talk about this because in arbitration, especially in Rwanda, we don't have many women in arbitration, especially in international arbitrators. I think, I don't know why, but it also started when I joined, there were less women in practice, and then I think they didn't, there are not many to join also this profession of arbitration. Maybe Victor will tell us if it has on the list, if you have some women, but I don't, they are like 2 or 4, not more than from Rwanda, when I talk from that experience. So I'm trying to, whenever I get a chance to talk to my sisters, I try to encourage them. I try to tell them that gender responsibility, I mean being wives and being mothers, it doesn't stop to pursue the career. So I think they will get confidence. I think they will, but I'll try, and also my other colleagues also try to train youngs to not think that arbitration is just for men, or being international arbitrators is just being for men. Not. So I want them to get some confidence. So, and what other strategies also is that through the education, through mentorship, and the education, I was talking to one of young lawyer in our law firm. He told me that the ADR is an optional course. It's not a compulsory course. So you may find in some like one or two in a group of students who will not take that course. So for that also, we don't find people, they get interested in arbitration when they come in a profession, when they join the bar. I think that also may change, and people may interest some students, some to go in university and interested them. Also, the lecturers who are here, I saw Dr. Kaihura and others, to maybe to try to make ADR as a compulsory course. My last experience, if I can say it, is that handing the baton in arbitration, it has its challenges, because you may train young lawyers in theory, but in practice, it's not so easy. So the practice, no, we all know that arbitration is private, it's confidential, so it doesn't allow a third person to assist. Yet young want to see us in action, whether arbitrator, whether counsel, but they want to see us in action. How to train them practically, it's not so easy. That's what I found, which is very challenging as an arbitrator, to hand the baton. Yes, I'm ready to hand the baton, I'm ready to start, but I think I will not give a full experience, I will not give a full guidance, because I will just give the theory, but the practice is not so easy because of that confidentiality which we have in arbitration. I can't call this without talking about the experience as an arbitrator in ESCG. It's not experience, but Professor Mwigai said that there is a need of, like in East Africa, having one center. But we already have one center, which is not a center, but it's a tribunal, a East African Court of Justice, which has that arbitral jurisdictions. It has its advantages, I think, for people. I'm not advertising, but some people don't know that part of East African Court of Justice, but it's free. The arbitration there is conducted by judges who are not necessarily judges in their country, because we are judged for, if I take my experience, I'm a judge there, but in profession, I'm a practicing lawyer. So you have you have people from different career, judges, academias, and lawyers who can handle your cases or who can handle arbitration cases. So I think I can stop here. And I can get...
Thank you very much, Anissa. Come up, please, over to you.
Thank you very much. And first, may I thank the organizers for putting up together this conference. It's been amazing the last day that we've been here. And I thank you for inviting me. I must confess that when first I saw the scheduled speeches that were to be made, and I saw this particular session, and it was about experiences and handing on the baton. And I saw my good friend, Professor Githu, was one of the speakers. I thought that sounds about right. He was my teacher. So it is very good that he's been appointed. And I was waiting to see who else would be invited, because I was holding on to the baton, having just been given by Professor Githu. Then the next thing I see my name. And I thought, I'm not sure this is very fair. I've just gotten the baton and now I'm handing it over. But having said that, let me just say that unlike my two co-speakers here, who we have had, they are very good experiences. I've never served in the public sector, and I've also obviously not been in academia. And so I thought when I was told to speak on this, I'll give my own experiences from practice. And from it, maybe there will be lessons on what it is that other generations can do. So when I started my practice in Kenya, arbitration was not a very big issue. In fact, I remember that we used to refer to arbitration, and especially arbitration agreement, as the Scott versus Avery clause, because that's the only time you'd find courts would deal with that issue when it came up, especially in insurance-related matters. And so when I started practice, I found that there were only two shops that were available, and one of them was domestic arbitration, and obviously there was international arbitration. But unfortunately, both those two shops were closed by the same people. In domestic arbitration, we had the practitioners that were there then, who were mainly men, more senior practitioners. And then when I looked at the international arbitration, same thing. There were the more senior members of especially the Western Bar. There were no men, there were no young people. And I thought to myself, what can be done about this? And so I classified the problem that I found into two. There were things I could do something about, and there were things that somebody else, I would depend on the goodwill or future events to resolve. And so the one I could do something about was to gain the knowledge and practice of arbitration. And I started the journey of certification and obtaining the relevant training. Now, I agree with Professor Muigai that there is a possibility that all you do is just get the papers and you file them away. But I thought that one of the ways of dealing with the situation of how do you get into these shops that are now closed was to gain experience and knowledge in arbitration. And I trained under the Chartered Institute of Arbitrators. I went through membership because I were able to go straight to membership if you had done at least 5 years training at the time. I went through fellowship, and then I went, I became a chartered arbitrator. And in the process, I would get involved in discussions about arbitration. That knowledge that I gained put me in a situation where when I spoke to the institute, at that time there was only the Chartered Institute of Arbitrators, they would listen because you have knowledge on arbitration, you have researched on it, you know how the processes are undertaken and so on. But there was another problem that I had also realized, which was that the courts were not arbitration friendly at all. And most of the judges did also not understand why arbitration. So what arbitration had become, it had become one step. So you finish with arbitration so that eventually you land in court. And then obviously the court will set aside the award and you will start the litigation in court. And obviously this had to stop. And so what I did is that I offered to partner with the Chartered Institute of Arbitrators, represent them on a pro bono basis so that we could get some of these issues resolved through the litigations that were coming up. I was privileged to do one of the matters. It's called Peter Gashuhi versus School of Nations, which went to the High Court. We finished the arbitration. It was a dispute on about sale of land. We were pleading the defense of frustration. It went to before a judge of the High Court. The High Court judge decided that he will set aside the arbitration on public policy grounds because, according to him, the courts have the power to review. In fact, he says to subject the arbitral award to a searching review to ensure that it complies with the provisions of the Constitution. So that you see what has happened is that now the courts were using the Constitution as a basis for setting aside arbitral awards. And the minute that that decision was rendered, we filed an appeal against it. But at the same time, I had also been instructed by the Chartered Institute of Arbitrators to represent them in another matter, which had arisen much earlier. It's called New to Agrovet versus Airtel. And the question that was arising at that time was whether or not there is a right of appeal from a decision of the High Court on a setting aside of an arbitral award. Now, this was a huge issue because there were so many decisions in the Court of Appeal. Some judges of the Court of Appeal said there's a right of appeal. Others were saying there's no right of appeal. It was necessary, therefore, to get clarity because international observers are looking at this and they're wondering, if I get an award from an international tribunal, will it be enforced in Kenya? Or are you going to use grounds such as your Constitution to set aside the award? So this was a critical issue. And so when we appeared before the Supreme Court, because the Court of Appeal said there's no right of appeal, and the matter was appealed to the Supreme Court. And so when we appeared before the Supreme Court, one of the things that was nagging at me was this question of, now that the Court of Appeal has locked the door and said, whatever decision you get from the High Court, you're stuck with it, however bad it is. And the question that I asked myself, and I think this is a question that people need to look at for a long time, is the arbitral, the matters that are dealt through arbitration, is it a justice system or is it a process? So that you file your claim, the defense is filed, the arbitrator decides whatever it is he decides, and then it goes to a judge who can set aside that arbitral tribunal, the decision of the arbitrator, and leave you without any remedy, just because the judge of the High Court has decided to go rogue and determine or decide to set aside on grounds that are not provided for in the statute. And so when we appeared before the Supreme Court, we advanced this argument, including the reliance on the Constitution. And very fortunately, the Supreme Court said that where a judge sets aside on grounds other than those set out in the statute, which are the usual natural justice provisions, fair hearing, misconduct on the part of the judge, and public policy, then that is a ground on which the Court of Appeal can review the decision of the High Court for purposes of ensuring that obviously the award that was rendered is respected. And so we went back before the Court of Appeal. There was a lot of misunderstanding on what the Supreme Court had decided. Many people thought that the Supreme Court had now thrown open the doors for anybody who is dissatisfied with the decision of the High Court to then go and apply to set aside or to appeal against the decision of the High Court. So to allay those fears, again, we went back before the Court of Appeal on another matter, the Peter Gashuhi matter that I told you about. And we got the Court of Appeal to clarify that the grounds on which you can appeal are very limited. You must be able to satisfy the Court of Appeal that, in fact, the judge went outside of the provisions of the Arbitration Act. And that clarity helped a lot. And so this was a journey to make sure that there was clarity on key components of the law that would allow arbitration to be practiced in Kenya in a manner consistent with international best practices. And so we are still waiting for the Court of Appeal determination on the issue of whether in those circumstances that I referred you to, the judge was right to have set aside that particular arbitral award. And it will be interesting reading what the Court of Appeal will say. But just based on the cases that I've told you, you can see key important clarifications were provided by the Supreme Court and the Court of Appeal on issues that are germane to the practice of arbitration. But then there were things that I couldn't do much about because they're beyond my control. Like, for example, how do you get the international community to start looking at young arbitrators as a component of the international arbitration practice? There's nothing I could do about that. But life has a way of resolving some of these matters. And increasingly, as pressure started to bear, and people started to say that international arbitration needs to open up a little bit more so that we could have women, we could have younger arbitrators to join the arbitration community. Fortunately, as years went by, this pressure started to bring to bear. And what we started seeing is that we started seeing many more women getting into international arbitration space. We started seeing younger arbitrators also getting involved. And then obviously there has been this pressure on diversity so that we can also bring other communities that were not previously represented into that space. Now, I know there's been a lot of discussion on, has that borne fruit? Do we have many more African arbitrators, for example, being involved? It's a debate that is going on. I was just mentioning to Dr. Mwigu and Professor Muigai that we need to be careful that this does not become a talking point, so that every time we have an arbitration conference, we talk about it, then we wrap up our papers and go away and nothing happens. I think that the importance of this is that if we can make sure that those who attend these conferences, those who are in a position to do something about it, the people who practice international arbitration, if they are asked, if every one of them is asked, what have you done to ensure that there is diversity? Have you appointed an African arbitrator, for example? Have you as a person recommended counsel from an African country in a matter that you're dealing with? So that we stop talking about the institutions themselves, because ICSID can only appoint, maybe it only gets to appoint one or two. Most of the times the appointments are made by the parties themselves. Appointments are made by the states themselves. So do we have the practitioners themselves saying that I myself charge myself to make sure that I make a recommendation, at least in one matter, for the appointment of an African arbitrator or for the appointment of counsel from Africa? That is the only way that we'll actually be able to say that diversity is actually taking place. So I said that is the one which I couldn't do much about, but I think we can be able to charge people here to do it. You know, so I think it's a takeaway from here on what can be done now. The button that I was hanging on to when passing it, what are the things that I would want to see happening? So majority of the young people believe that all you need to do is you need to get some qualifications and then that's it. You don't read, like the issues that have been raised here about ESG, for example. These are emerging issues. They are issues that affect all countries generally. And these are issues that people should read up a lot about. You should know about them. You cannot sit and wait to be appointed in a matter that involves conflicts on environmental issues or governance issues or social issues, and you haven't read about it. You should be able to give confidence to people who will appoint you or to clients who will come to you that you understand these issues. And they're not novel, they're not difficult. They're things that if you read, you would be able to come to grips with what are the issues that affect them. The institutions themselves, what do you know about ICSID? What do you know about ICC? What do you know about these other processes? Do you know what their rules say? So for the young people, the only way that you can get truly involved in international arbitration or even domestic arbitration is to learn as much as you can about them. Then you can be able to challenge those who are in positions to assist you by telling them that I know these things, I challenge you to give me the opportunity, and you will see that I will deliver. Lastly, one of the things that I've had, obviously being discussed a lot, is that the reason why we have a problem with ensuring diversity actually happens is because there is a view that either A, there's not enough experience among the arbitrators that have been appointed, or there is the fear of that there might be corruption or stuff like that with these other arbitrators. My parting shot on this is that people or arbitrators are not corrupt because of the area they come from. An arbitrator is corrupt because that is his character. So you cannot use the same brush to say everybody from that region, we are afraid that they could be corrupt. A region does not make you corrupt. It's just your character. Thank you very much.
Kama, thank you very much for that. And thank you, all three of you, for those fascinating insights and thoughts. Before I open it up to the floor, just conscious of the time, there's one question I wanted to ask actually to you, Anita, and to you, Kamal. Professor Gitu raised the prospect of leveraging the power of arbitration within East Africa by sort of combining forces with the various arbitration centres in East Africa. What do the two of you think about that, and do you think that's a possible development that we might see over the next few years? Anissa first, perhaps.
Thank you. I think it's a good idea. Instead of having crystallized centers and having one strong center in the East African as an East African Center of Arbitration. But in the meantime, as I said, we already have one. Maybe if we can institutionalize the arbitration through ESCG, that can also be one way of making that. I think I've responded that.
Thank you. Kamal?
Yeah, I agree that a regional center would be a powerful tool in attracting business to this region, because you always look at it from even a point of view of numbers. If you have an East African-wide institution, and we're not looking just at Kenya, Uganda, Tanzania, we are looking at Rwanda, Burundi, Ethiopia, Sudan, and probably DRC and other countries nearby. It is a start towards making a more strong region, so that when this region speaks, or when it's looked at, people are looking at a region more than countries. But as I was speaking to Lawrence, and he was telling me that, or we're discussing, one of the benefits of some of these national institutions is that where, for example, a dispute arises in Kenya and the investor feels uncomfortable about having the arbitration conducted in Kenya, then it's much easier to then say that we have another institute or institution in Kigali that can be able to run the arbitration, and probably that might make it more comfortable and attract business, or ensure that the arbitration is conducted in Africa rather than them exporting it outside. So obviously there's a benefit and there is a demerit in each of these, but it's a conversation we should have, because we need, the idea is that this region must work as one in attracting international arbitration business to come to the region. And when it does, the entire region benefits. We shouldn't have a situation where people may feel that I would rather that I benefit as Kenya, and as long as I'm benefiting, I'm okay. I think people should realize that the more you are able to attract us, when you kill an elephant, you have much more meat to eat than when you kill a hare and you just have meat for a single day. Thank you.
Thank you. And just one final brief question to each of you, or brief answer. And just if you could answer in one sentence, and I'm going to put you on the spot. If there was one thing that you could have told, with the benefit of the experience that you have now, your younger selves, when you all started out on your journey in the legal profession, what would that one thing be? Professor Gitu.
Competence, competence, competence. You need to be an arbitrator that people can rely on, because your command of the subject matter is solid. I wish I had told myself that at the beginning.
Thank you. Kamal?
I think what I would say is, at the time I started, I thought this would not work. I would just say fidelity and hope. Just have fidelity towards the practice and make sure that you contribute towards changing.
Thank you. Anita?
Yes, I think for me it's continue to train yourself, reading, and work hard.
Thank you. I hope we've got some time just to take a few questions from the floor. I'm sure there are lots of guys, I see lots of hands going up already. So perhaps we can take a question from the gentleman here, first of all.
Thank you. And, I don't have a question, but I have a small comment on the statement of Honorable Justice Anita regarding the few number of women arbitrators. And I remember a beautiful statement of our colleague, the Nigerian arbitrator, Durusi. I think it was in either Kenya or Arusha before the pandemic. There was a career day of the women arbitrators. And she said to the women arbitrators, then the sky is wide enough for all birds to fly. Let them hear your voice and you will find a space in that sky. And for that reason, I talked to my friend Agnes that I speak in most of IAC events. This time I'm not going to be a speaker. Let us introduce women speakers so as to encourage them to penetrate in this market of arbitration. So we introduced 5 beautiful ladies, and Mrs. Muna, Mrs. Nada, Mrs. Nawal, who is going to be a speaker, and Mrs. Maida, who is going to be also a speaker, and then the next generation of young women arbitrators, Miss Sophia, I don't know where is she. So that's why we want to encourage the young women arbitrators to penetrate in this matter. I mean, exactly young African arbitrators. And we hope this will be done by all law firms instead. Mr. Kamwam, you said would talk about the next generation of arbitrators, but we need to support them. What shall we do to them? Just, okay, competence and qualification, and that everything could be done by them. But as law firms and as arbitrators, what are we going to do to them as African law firms to support them? We should have a program to support those people to be the next generation of arbitrators in Africa. Thank you very much.
Gentlemen, there, yes, you've already got the microphone.
Good morning, everybody. Thank you, our panelists. My name is David Kagwa. I'm from Uganda. I'm the chairman of the Chartered Institute of Arbitrators, Uganda chapter. My question goes to Mr. Kamau. In Uganda, the Supreme Court has settled the question of whether a decision of the High Court, while setting aside an application, while setting aside an award, whether there is a right of appeal to the Court of Appeal. And our Supreme Court in Babcon versus Mbale Resort held that there is absolutely no right of appeal. And our Supreme Court added that our Arbitration and Conciliation Act, which, just like the Kenyan Arbitration Act, is based on the unicitral model law, is self-sustaining in as far as any application to do with an arbitration award is concerned. In essence, there cannot be any other law under which a judge can base their decision to set aside an arbitration award. So, by the Kenyan Supreme Court saying that there is a right of appeal if a judge of the High Court relied on another law, there ought not to be any other law. They can only rely on the Arbitration Act to either set aside or enforce an arbitration award. So my question to you, Mr. Kamau, I have 2 questions. One, do you agree with the Supreme Court decision? If not, that matter which is pending in the Court of Appeal, would it be advisable that in the event doesn't go well, that you take it to the Supreme Court and you persuade them based on the Ugandan jurisprudence that our neighbors here have said there's absolutely no right of appeal? Those are my questions. Thank you.
Well, would you like to answer that, and then we'll take it.
All right. Yeah. So the situation that you say, what the Supreme Court of Uganda say, it's a very interesting statement by itself, because it says the judge of the High Court has no power to set aside on grounds other than those set out in the Arbitration Act. The question becomes, what happens if he goes outside of the Arbitration Act? So if you then say there's no right of appeal, it means the person whose award has been set aside on grounds other than those set out in the Arbitration Act is stuck with that decision. And that is why I say we need to be careful, in my own view, and this is my view, we need to be careful not to convert arbitration into just a mere process where, whatever the judge judge makes a totally wrong decision, does not rely on the Arbitration Act, bases it on his own perception for whatever reason, like the example I gave where the judge says that the Constitution gives him a blank check to subject the award to a testing review and come up with his own view. So I think, I have not read the decision in Uganda, but I think the very fact that they say that the hands of the judge are tied in relation to what he can do also means that there must be a way of resolving a situation where the judge completely ignores the Arbitration Act, goes outside this and makes his own decision. In those circumstances, there must be somebody then who can be able to say that that's wrong. And let me just say this. I think we also need to look at when we say in arbitration that there needs to be finality, or the award that is rendered is final, what are we giving finality to? Are we giving finality to the arbitral award, or are we giving finality to the decision of the High Court, however wrong it is? So my own view is that I think it would be wrong, in my view, to close our eyes to the fact that a judge can get it completely wrong. If you look at the situation in most countries, in France, in UK, in other countries, they have limited circumstances under which an appeal can be preferred from a decision of the High Court. So the idea that you can insulate a judgment of the High Court from being relooked at, but you cannot insulate an award because an award can be set aside by a judge, I think would be a very dangerous route to take. So my own view is that the Supreme Court of Kenya got it right.
Kaman and David, just a follow-up question from that. I mean, surely if the judge has gone outside the Arbitration Act, he's misdirected himself as the appropriate law. And that generally in most jurisdictions would allow you to appeal, because you're appealing on a point of law rather than just an exercise of discretion by the judge.
Correct. That's actually what the Supreme Court basically said.
Thank you. I think there was one more question. Yes, gentleman right at the back. Do you have the microphone? Thank you. Yes, sir, please. Oh.
My name is James Kalokoni, and I'm from Zambia. My question is directed to the professor.
Oh, sorry, I think your microphone's gone off. If you could turn it back on.
Professor, I enjoyed your presentation, and one of the takeaways from your presentation is that for young arbitrators, emphasis must be placed not on paper qualifications, but on gaining practical experience. That was a very good emphasis, Prof. Now, the question is, in Chinese, there is a saying that, tell me, and I will forget. Show me, I may remember. Involve me, I will never forget. So that is actually highlighting the importance of training young arbitrators so that they can become pragmatic arbitrators, just as you are, Prof, and the panelists. Now, my question is, what deliberate policies are we putting in place to ensure that every arbitration which takes place incorporates young arbitrators so that they can gain experience? We have to bear in mind cliques in arbitration. That is the reality. And if these young arbitrators are to be trained to become pragmatic and experienced, competent arbitrators, we must incorporate them in every arbitration that is taking place, and also to fight the cliques in arbitration. So, Prof, that's my question to you. What deliberate policies can we put in place to ensure that young arbitrators are incorporated in every arbitration that is taking place? Thank you.
Please, Professor.
Yeah, I think Dr. Mwigwa, who is in this room and who's been chairman of our institute in Nairobi, maybe he would get 1 minute to answer that. But what I do know is that I have had requests each time I am asked to sit as an arbitrator. It is followed by a request from the institution saying, we are sending you a pupil who will sit with you during the conduct of this so that she or he may acquire the practical skills. And I have found it quite useful. And the way I train young arbitrators is by converting them into the secretariat of my tribunal. And they learn how to draft the orders, to communicate with the parties, to secure the documents, and so on and so forth. And I think that it is a very, very critical, very critical function. No amount of passing exams prepares one, a young arbitrator, to control the tribunal. As I said earlier, some people who appear before the tribunal are very unfocused, and it's not useful for the process, that you cannot keep to timelines. And I think we in East Africa, one of the problems we struggle with is expeditious disposal of disputes, both in the court system and unfortunately now creeping into the arbitration sector. And we need to do more. And that's why I'm very excited at the possibility of the discussion we are going to have on technology. Dr. Mwigwa, can you use 1 minute to say what we have done?
A very quick minute, please, because I'm being told that time is up, but please, just very quick. Thank you.
Good morning, everyone. My name is Kariuki Mwigwa. I've been asked to say a few words in respect of that one topic. How do we mentor our young ones? We operate at several levels. Professor Muigai and I teach in a university, and within that university, we have an agreement with the Chartered Institute of Arbitrators UK that if you take this course, an LLM course called GPR 625, International Commercial Arbitration, you automatically become a member, an associate member. That's the first point. And then ADR is taught in third year, every year. But at the institute level, for several years now, we are running a mentorship program so that when there are live arbitrations, we attach students. And in fact, we insist that we attach students. At a personal level, what I do, anything I write, I'm a writer. And anything I write, I give to students for free online. I haven't made even 1 shilling out of my writing, including my latest book, The Fourth Edition, Settling Disputes Through Arbitration in Kenya, is available to every student in the world. So what they need to do is read the theory, then we attach them and we work with them. I have personally worked with many, many, many students, and we are committed to it. Thank you.
Thank you very much. Just finally to say then to our 3 panelists, thank you so much for...
Sorry.
Oh, I'm sorry.
I'm going to ask a question, but of course, because of the time is almost out. So let's think of it. Just keep it in your mind. And I think it would be good to take it in our closing session. So first of all, that's very much insightful speech on the qualities of good arbitrator. But the thing here, let's take it from the lens of women. The question is, what is needed from women to be rightly fit in arbitration in this field? I see that need to have, it's more of a call for action. It would be good to see the conference coming out with a clear outtake in this specific part. Thank you. And again, no pressure, no need to answer, but we can take it please in the closing part. Thank you.
Thank you very much. thank you, all three of you. That's been valuable, thought-provoking, and inspiring. I'm sure we'll all agree that we've learned an awful lot and we'll take an awful lot away from everything that the three of you said. So please, would you all put your hands together for our wonderful panelists? Thank you.
Dear participants, can we again appreciate the leadership panel? Very insightful, very thank you so much, the leadership panel. We really learned a lot from you, and we believe that you're really handing the baton rightly, because you've given the right guiding principles, your wisdom. I believe everyone is taking something from the discussions. I believe the discussion will continue after, during the breaks. But this was very, very, very important. Thank you so much. And time is not on our side. Let's quickly welcome the 7th session. And the 7th session is on trends, investment, protection, and sustainability in Africa's regional blocks. And may I take this opportunity to welcome the moderator for the session to also introduce the panelists. The moderator is Dr. Kenneth Waini Mutume, Chairman, Education Committee, SIAB Kenya. Welcome, Doctor. Thank you.
Well, certainly time is not on our side. I always get amazed by our well-thought programs. We're actually meant to be going into the tea break now, but we're in the 2nd session. So we have to find a way to recover that time. I'm hoping my panelists for this session will be able to assist me in that regard. I also recognize the wealth that is inside the room. And I'd like us particularly to tap into that wealth by having a very lively plenary session. So we will have less from this side and probably more from that side to hear what the delegates have. That's very important because we are talking about trends, investment, protection, and sustainability. In our mind, of course, is the different areas on the continent, West Africa, Southern Africa, the Lusophone world, the Francophone world, and what they have to say about these trends. The background, of course, is heightened economic activity that's taken place on the continent, and what that has looked like when it comes to the world of arbitration. Already earlier on, Professor Githu Muigai spoke about the proliferation of arbitral institutions and what opportunities, dilemmas that presents. I think we've had earlier on, of course, of the tensions between the desire for greater investments, bilateral investments, multilateral investments, but of course the rising concerns associated with the environment, with ESG governance, and some of the challenges that have been presented by the SDG and the focus in that regard. So I would like, without any further ado, to invite a very special group of panelists to the podium that will shed light from each of these regions. We have with us, and I suspect Nawal, Sudan was not mentioned amongst the group of countries, but Nawal is from Sudan and she has a rich experience in infrastructure, construction, arbitration. I will highlight, panelists have asked me to be very brief with their bios, and all very well because of our time constraints. One of the major areas that you might want to know about Nawal's high involvement in the Dubai Chamber of Commerce, and a particular mega project that's been profiled in the Guinness Book of Records, the Dubai Metro Project. Congratulations for the role that you played in that regard. We also have Dr. Jimmy Kodo, who will be giving us a perspective from French West Africa. Many of us are acquainted with him. He sits on various forums, including the PCA, the Permanent Court of Arbitration. He's a fellow of the Chartered Institute of Arbitrators, and he plays a particular role in the context of the Common Court for Justice and Arbitration in West, addressing concerns from the Francophone perspective. I was about to say last but not least, but we also have Jonathan Ripley Evans, a partner of Harvard Smith, a firm in South Africa. He has extensive experience and particularly focuses on different ADR matters, mediation and arbitration at the forefront. He's been a member of the core drafting committee responsible for the revision of the AFSA, International Commercial Arbitration Rules. We will see how AFSA has particularly made inroads when it comes to bringing synergy in terms of different arbitral institutions. Jonathan will also give us a very unique look into the Southern Africa perspective, different countries, the tensions that those countries have had to balance between the idea of the investor's right as far as arbitration investment disputes are concerned, and of course the state's right in terms of protecting its regulatory regime in public interest. Last but not least, we have Itueva Nogueira from Angola, who has enormous experience in the oil and gas sector. She will be sharing with us certain viewpoints given this experience and also the experience that she has in technology, media, and telecommunication. It is my great delight to have the panelists join us at this moment. A round of applause for them. Thank you. Okay. Very welcome. Very good to see you.
Sorry, it's a quick one. This is to recognize the online audience. We have about 50 people following us online. And this is to recognize their presence and also to let them know that if they want to participate in asking a question or comment, there's somebody following, they should be able to do that. Otherwise, back to you, moderator. Doctor, over to you. Thank you.
All right, thank you very much. Please, online guests, please feel free to signal us during the plenary session when we interact on the subject. We have 2 PowerPoint presentations, and I'm not sure whether they're up yet. We had requested Jonathan's presentation to be up, and then of course followed shortly after by Itueva's presentation. Just confirming with the technical team whether the presentations are up. Nonetheless, I think, Jonathan, please feel free to start without the presentation. He will be speaking to us about the South African experience. And I have prodded him because South Africa is a very unique country amongst all the other South African countries when it comes to questions of protection investment and how they've gone about striking that balance. Very much welcome, Jonathan.
Thank you very much. Without a doubt, I think the biggest challenge facing us today is not sustainable development. It's not even COVID. It's really keeping to our time limits. So I'm going to really try my best. I'm even going to set myself a timer, and I will try and stick to the allotted 10 minutes, but that will mean that I won't be able to discuss absolutely everything. I'm hoping that we can have quite an interactive debate afterwards. I know this group of people quite like a good debate, so let's look forward to that. Okay, I don't see the presentation up, but not a problem. Let's get started. I have been tasked to address developments in the SADC region. And yesterday we heard a lot about sustainability and what is required of nations to achieve the goals that many of our countries have committed to. And I just thought a nice point to start with is a little extract from the report from the Secretary General on the progress towards Sustainable Development Goals, which was published this year. The multiple and interlinked global crises we are facing, the COVID-19 pandemic, the climate crisis, and the impacts of the conflict in Ukraine and elsewhere are putting the very viability in achieving the SDGs by 2030 at great risk. An urgent rescue effort is needed to rapidly change course, grounded in a comprehensive response to these interlinked global crises and a renewed commitment to multilateralism and international cooperation as called for in our common agenda. We're really facing some serious problems from a sustainability perspective, but we cannot lose sight of the fact that we as developing nations are facing other challenges as well. And quite often, states, when faced with challenges of reaching their sustainability goals, have to make a very difficult decision. Do we focus on economic recovery or the SDGs? It's often not available to the states to choose a balance between the two. And we just need to bear that in mind when we're focusing on achieving our SDG goals. And I in no way are downplaying the importance of those goals, but improving the economic situations of countries that have really been exacerbated by recent events is normally at the forefront of governments' minds. Okay, I see we have a presentation on. If we could maybe flip through to the third page. Sorry, I lose control. All right, I'm going to give some feedback from the SADC region. For those that you know, it's really just the southern tip of the continent. And when people ask me what is the general attitude towards investment protection in the SADC region, my response is normally what's on the next slide. It's really a difficult one to give. I will start with my experience from South Africa's perspective, not just because it's the country that I know the most about in the region, but also because it's really been the protagonist for what's really happened in our region relating to investment protections. And many nations have looked at what South Africa did previously, some criticizing, some just watching. And in 2010, going to the next slide, in 2010, certain things started happening in South Africa. The first related to the disbanding of the SADC tribunal. A reference was made to it yesterday at the Forestry case. There was also another Steyn case versus the government of Lesotho that prompted the government to start supporting efforts to disband the SADC tribunal, which was set up to protect investments. And at the same time, the government started cancelling or not renewing, as they describe it, certain fundamental BITs. This brought a lot of criticism to the government. And at that stage, it's also important to remember that there were many African states still concluding new BITs. So it certainly wasn't an African attitude. There was very much a South African attitude, but a number of the states, particularly in Southern Africa, took a wait and see approach. If South Africa was going to get away with it, maybe we would do the same. And there was fears of floodgates opening, that insofar as BITs were terminated, would there be unlawful expropriation across the board? And these were the fears that were coming out at the time. We've had the benefit of time having passed, and we now know that that didn't really happen. There really wasn't a dramatic consequence to the termination of South Africa's BITs. I, for one, was quite critical of the termination of those BITs. I didn't fully buy into the rhetoric that was being promulgated at the time. But I can confidently say that the fallout has not been nearly as bad as I'd thought. And when we look at the country's commitments towards the 2030 Sustainable Development Goals, which were signed up for in 2015, the decision to terminate those BITs seems to have been a step in the right direction, because there is a tension between achieving your sustainability goals and your obligations to an investor that you presented to that investor years prior under the treaties. The current status in South Africa is that investments are protected under the Protection of Investment Act. This was the act that really culminated the attitude of the country towards how we as a country were going to deal with foreign investments. It's described as an element to try and balance the rights and obligations that apply to all investments. It affirms the Republic's sovereign right to regulate investments in the public interest. It presents fair administrative treatment and provides for national treatment, that foreign investors must not be treated less favorably than South African investors. It ensured the country's right to regulate its own policies. And very importantly, Article 13 dealt with the dispute resolution, which provided for mediation of investment disputes if notified within 6 months of suffering the loss. The party is not precluded from approaching the state courts for relief, and they're encouraged to do so. The Act says that the government may consent to international arbitration subject to the exhaustion of domestic remedies, which sounds quite positive. But then the kicker, the arbitration will be conducted between the Republic and the home state of the applicable investor. That largely killed investment arbitration as we know it for purposes of modern South Africa. And whilst the country is making big noises about the value of mediation in investor disputes, and I for one support mediation in investment disputes, the country has not yet signed up to the Singapore Convention. So I think that is a little bit of cold comfort, but we are making efforts to try and get the country to move forward on this. I would like to move forward in the interest of time. There is also another elephant in the room as far as South Africa is concerned. In 2017, a political party, the Economic Freedom Fighters, proposed a motion to amend the constitution to allow for expropriation without compensation. Now, this was largely described as a political tool to drum up support for the political party, but there was a sector of the community in South Africa that really supported this move. The movement was not successful in amending the constitution, but there are amendments to the expropriation bill, which will see regulated expropriation without compensation in certain circumstances. And I should just mention that the current constitution does allow for expropriation without compensation in certain circumstances. But the problem with something like this is it just creates the impression that there is going to be land grabs, property grabs. And this is something that the country is trying to balance at this point in time. The concept of expropriation without compensation is not new. It's always been there in certain circumstances. And the proposals for the bill have provided certain wording to ensure that any such expropriation without compensation must still be just and equitable in those circumstances. Just flipping through to speed things up, I just want to talk just for a moment about commercial arbitrations in the SADC region. In 2021, AFSA launched their revised commercial arbitration rules. I was fortunate enough to have played a role in that process. And those of you that have worked with the previous AFSA international rules will realize that this is quite a big change to the regime that prevailed before. All of a sudden, AFSA has now presented an internationally accepted standard of rules, and we believe it's at least trend setting for the region. The focus of the rules is on efficiency, expedited procedures, early dismissals of claims, which has been quite controversial of late, but we think it was quite a good development. It establishes the AFSA court. It provides for joint emergency arbitrator, third-party funding, remote hearings, multi-party contract provisions, everything you would expect to see in an international set of rules. So we think that this is quite a positive step in the right direction. And it is a step that has been embraced by the SADC region quite recently. The SADC Lawyers Association have adopted the AFSA international rules as the standard for the region. We're in the process of setting up a separate SADC court to deal with SADC matters. And this is in an effort to try and regularize or standardize international arbitration in the region. We've still got a long way to go in this regard, and we will face a number of bumps, but if we can establish some form of uniformity in how we address international commercial arbitration in the region, I think we're going in the right direction. I don't think treaty arbitration will be as successful in getting unanimous support. The last little topic that I wanted to just discuss was something that was just quite unique, which I think is going to get a little bit more attention in South Africa and possibly in the region as well. And this is just the topic of statutory arbitration. It's something that's not new for common law countries, where we have a statute which forces parties to actually go to arbitration for particular types of disputes. I've always had a problem with that type of arbitration because it's not the arbitration that we all know. It misses the fundamental aspect of agreement, but it has formed part of the common law around the world for many years. There was a recent development in the Petroleum Products Act in South Africa, which saw the referral of certain disputes to a tribunal, an arbitral tribunal under the Act. And very interestingly, those types of disputes focused more on equity. So it was more unfair practices, and it was aimed at giving retailers recourse against big oil companies that were imposing rather onerous terms in their franchise agreements. So the purpose of it was quite laudable, but the structure of it is going to present problems. It is forced arbitration under the Act. The retailer may then request that the oil company submits itself to an arbitration. If they do not agree on rules with the arbitrator, the controller then appoints an arbitrator who will then determine the rules. So you have the situation where you can have a full arbitration without the agreement on anything between the parties. And you will have a binding award on principles of equity and fairness without the agreement between the parties. And so my concern is that that is probably not going to be enforceable under the New York Convention, and it may do damage to the institution of arbitration itself. But it's something that we're starting to see coming up where countries are trying to give consumers a little bit more protection by referring them to tribunals or arbitration tribunals instead of the state courts. But there is a risk of the blurring of the line of the concept of arbitration then. I think it's just something that we should keep an eye on. I think that that's all that my time allows for today, so I'll stop there, but I'm sure we have a lot to talk about. Thanks.
Thank you very much, Jonathan. So as I invite Itweva, I believe your PowerPoint presentation is going up. 2 questions for very quick reflection from you, Jonathan. One, of course, is South Africa has a very unique environment from a human rights perspective because of its past. And I guess the attitude the government has shown when it comes to BITs and the new act is framed by that. To what extent does the new act then transpose into these other contexts in SADC? The other question that's quite important in light of the earlier discussions that we've had is AFSA's work across the region. And AFSA's done some stunning work in terms of collaborating with different arbitral centers. To what extent has that work impacted capacity development issues, particularly in light of the diversity gap that was spoken to earlier? Itweva, I was buying time for you to actually take the floor. I believe the presentation is up. The floor is yours. Thank you.
Thank you so much. I was here lost. Because suddenly I lost my presentation, but I think it's already here. Okay, good morning, everyone. I'm here to talk a little bit about the investment protection from the Lusophone part or point of view. Of course, I will focus more, I think they are not in the first slide. I will focus much more on the Angolan experience and then talk a little bit about the other Lusophone countries. So from the first slide, you will see, I will try to create a map, a route for you to understand how our investment laws in Angola has been dealing with the investors, the investment protection. For instance, I've started this presentation only focusing starting from 2011, and our investment law at the time would establish, of course, a protection of the investors, and what they would say is that any kind of expropriation of the rights of the investor would be duly compensated and would be done in a just and fair manner. So at that time, we wouldn't see any reference to arbitration itself. Even when we were negotiating some investment projects at the time, when we were about to sign the investment contract, the dispute resolution clause would always go through courts and not mention arbitration. So it was not even open to that. Of course, at that time, it wouldn't how can it slow down the investors, especially because we were at the time that the amounts required for investments was so low. Investors could apply or start their projects of investment with only $100,000. Then with change, the government program changed and the views around foreign investment changed, especially because we went from a position of having all type of investments that we could have because we needed development, especially after the long civil war that we had. So the investments were open and there was not a huge amount required for those investments. But then in 2007 and 15, we had a new investment law, which had exactly the same text or the same writing, they just changed the numeration of the articles and things like that. But at that time, we had a difference. The minimum amount of our investments came from 100,000 to 1 million. Of course, at that time, we felt a slowdown in the amount of foreign direct investment that we were having in the country. And the main reason was that we wanted qualified investments and not just, every type of investment that, the platform had been created at the time. So it was time to start protecting or to not, if not protecting, but to give more opportunities to local companies, even small, medium enterprises, because it was enough time to understand that they had opportunity to create their own experiences, to get involved in the market and to start competing with foreign companies. In 2018, moving, I think, to the third slide, we had a change in our investment law in Angola. And accordingly to that law, any eventual conflicts related to available rights that should be resolved through alternative dispute resolution methods. So here we had the first open door to the dispute resolutions in terms of investment protection. I'm talking not commercial, because we had our Arbitration Act from 1996. So in terms of investment protection established in the law, in an investment law, in 2018, we had the open door to alternative methods of dispute resolution. So it was a great opportunity now, and especially because we had gone through a crisis, a financial crisis in the country. We had a reduction of investments. And of course, it was essential to send the right message to investors: your investments will be protected. Additionally, there was a lot of pressure in the country, which we have seen the last years, in terms of fighting corruption. So many investors that were connected with some political exposure entities or people was now in a position that, okay, if you want to come and invest by yourself, because that was also a change that we had. Priorly, the investments should be done as in JVs or joint ventures with local companies, but now foreign companies could come and invest by themselves, not creating any type of partnership if they didn't want to with a local company. So it was a new position. The local framework was created. The opportunities for local companies were on place now, but also the opportunity to fight or defend their rights and their investments using arbitration, mediation, or conciliation. We can say it was a little bit late, but probably it was just a matter of agenda. Then we had in 2021 a new investment act, but didn't change anything or many things regarding the investment protection. And then I would jump for 2 slides where it says treaties that Angola was part of. For instance, we could see that during far amount of time, Angola was not part of many investment treaties. Although we had a lot of investment in the oil and gas industry, but for treaties themselves, one more slide, please. For treaties themselves, we start much later. For instance, going back in 1997, we have with Portugal for obvious reasons. The connection between Angola and Portugal was very close. Angola is a former colony of Portugal, and although the separation after the colonization, the Portuguese investment in Angola was really high and substantial, especially because we had the barriers of the language and everything. So they were one of the biggest investors aside from the UK, France, and United States. We had this treaty amended only in 2021, but after that we had treaties with Italy, Germany, which are still in force, United Kingdom, Spain, and United Arab Emirates signed the treaty with Angola in 2021. I would say that there is a difference. The majority of them share the same substantial rights for protection of investors, but the UAE treaty made some changes and some difference, created some difference because they did not wanted to apply the most favorable nation principle in terms of procedural and judicial matters. So apart from that, all other investment treaties were exactly the same. So this shows us the tendency or the views that investment treaties are important if you want to attract investors, foreign investors, especially because of the protections that they would be established. Investors didn't want to come into the country, invest just by themselves and then try to find a way to solve problems, but the protection that would come through, especially the umbrella clauses, we can go to the next slide, were essential to have this new type of investments. So in the next slide, I mentioned a little bit about the clauses, the umbrella clauses on those treaties, and the majority of them refer or to ad hoc arbitration or to exceed arbitration, which was a little bit strange because although they mentioned that Angola was not part, and officially it hasn't concluded the process with the signature of the Exceed Convention. But because the other parties were already members or signatories of the convention, then it was established on those umbrella clauses. In terms of another important convention in terms of protection of investors, I would go now to talk a little bit about the New York Convention, and not just focus on Angola, but also because the signal that it gives to investors. Okay, you have treaties, you have a very good investment law now giving rights, or open the door to ad hoc arbitration or even institutional arbitrations. But now the New York Convention, which is important also for the recognition of foreign awards. Well, Guinea-Bissau, which is one of the, we call it Lusophone or PALOPS countries, so the Portuguese African Portuguese speakers countries. Guinea-Bissau was the first one in 1991, and after that Mozambique. And to talk about Angola, we only became signatories of the convention in 2017. So it shows like although we had the interest in foreign investment, but the country was a little bit relying on the amount of power and resources that the country had. So whoever wants to come and whoever wants to invest, we don't need to be part of these international conventions. You come, you invest, and you deal with any problems that you have, you deal directly with us. Of course, this is not what foreign investors want. Of course, that they don't trust, and to be honest, we can blame them sometimes. Some of them don't trust in the judicial forum for already very well explored reasons. But at some point, especially because the rankings and the perception of being an arbitration-friendly country, was putting in danger our position as a country which was business friendly. We had very bad reports in the last years from the World Bank in terms of our position for foreign investors or to countries to invest. So things needed to change, and of course, this one of the ways to change this perception would be become part of these international conventions in terms of dispute resolution. So it's not, we can say that we relied for so long in our own natural resources, and we were so sure that it doesn't matter because you won't find this amount of resources in so many countries as you find in ours, but at some point we was forced to take an action, which is fair enough. To finalize, I will just focus on the arbitral centers in the Lusophone countries. So in Angola, I can talk about two main centers. One that was created by the Ministry of Justice, which is CREL, the Center for Resolution the Luanda Center for Resolution of Disputes, and then a private one, at least two, but I will focus on one of them, which is a Center Harmonia, which is a new center that is creating and is making their path in terms of options for dispute resolution for not just investment, but also commercial arbitration. If we try to find in Mozambique, of course, they have one, the Center for Arbitration, Conciliation, and Mediation. I'm not sure if it's also one promoted by the Ministry of Justice or particular, but I believe it might be the same type of center like the Angolan one. And for Cape Verde, São Tomé, Príncipe, and Guinea-Bissau, I will admit if they are, but is not easily found. And it's something that, if you want to promote arbitration, locally, or you want to promote arbitration in our countries and not just go to Paris, London, Lisbon, whatever, you need to have these institutions in place. And you need to promote capacity building, which I'm a great advocate, and whatever I can do, and whenever I can do, I'm always looking after opportunities to connect with international centers and professionals to do this capacity building. At this point of life, saying that the language is a barrier is not a barrier anymore. We have a lot of technology, we have translators, we have opportunities. So what can we do to increase our position in terms of business-friendly countries, not just creating more centers, but also the capacity building for our councils and our arbitrators is something that is very important. So the framework is created, and especially now, and it will never stop. It will never stop the necessity of doing more and learning more. We were talking a little bit about environmental disputes that are coming now because of ESG. So there is always a lot to learn, and Agnes is already there flagging. My time is up. Thank you very much.
Thank you very much for that, Itweva. You actually sort of mentioned something I imagine is at the forefront of quite a number of us in the room. Angola obviously has a very rich extractive industry. And I know you talked about the minimum threshold that, focused on SMEs, but I'd be very curious to hear about what the experience has been with SDGs and those public interest issues. Protecting, but we will come to that. And Nawal, it is a pleasure to invite you to take the podium. Nawal will be sharing with us experiences from Sudan. As we know, Sudan has gone through quite some recent legal reforms in this area. Very much welcome, Nawal.
Thank you very much. First of all, I would like to thank all of you and the organizers for having me today here in this beautiful country with its beautiful people. Let me start with a statement made by one of the officials in African Development Bank regarding the integration in North Africa. So mainly the topic I'm going to point out is relating to North Africa. The statement say that the regional integration is highly relevant for North Africa, a region which has greatly benefited from the integration with Europe, but is yet to take full advantage of cooperation among its members. Despite strong ties due to a common history, religion, language in North Africa region remains poorly integrated. The economic cost of this lack of integration is estimated to be around 2 to 3% GDP. That statement is very seriously, and we have to take it into consideration whenever we consider review of the legislation and promotion of arbitration or our investment in the region. The ties of North Africa with the Arab and Gulf country and Western countries is more close than the African countries, and that is correct. The African Development Bank, through its regional integration policy and strategy for 2014-2023, urged national governments to emphasize on Africa economic integration while monitoring and reviewing their internal policies and relevant legislations. So this is by referring to a national development, African National or African Development Bank recommendation and references. I'm going to go through the situation in Sudan and what have been happening there since, let us say, 2016, where the government in Sudan started to make some legal reforms in the legal system, and they have reviewed many key laws that governing the investment. The most important one is that the recently enacted law, which is the Investment Encouragement Act in Sudan. This law has been published last year, maybe in September. It is one of the main law which provided for the protection of the investment and also provided for arbitration as a means of dispute resolution for any investment disputes. The main aim of this law also, one of the main principles of this law is to satisfy domestic and regional market needs and realize economic diversification. Based on that, if we refer to the objectives of the law, it mainly refers to preparation of in preparation of an environment to attract investment, foreign investment, boost the rate of economic growth, raise the awareness of importance of the local and foreign investment, expansion, diversification, and localization of the production base, and raise the rates of local production, human capacity building by transferring localization of knowledge, technology, method of modern administration, scientific, technical, and marketing expertise. The Sudanese Investment Act provides for means of dispute resolution, and for the first time call for a special or establishment of a special court and a special prosecution bureau to resolve all matters relating to investment. Besides that, the law recognized the execution and enforcement of arbitration and conciliation agreements. This conciliation, the law made reference to a number of treaties, but at the end referred to any other treaty with respect to which Sudan is a party thereto. So that means any treaty Sudan has been recognized or endorsed by Sudan relating to the investment is protected, is enforced and recognized by the new Investment Encouragement Act. Another, if we look at the aspect of protection of the investment under the law, mainly the law provides for establishment of a company, an insurance company, is specifically called Insurance, Security or National and Foreign Investment Company. The purpose of this company is to ensure among other objectives, or risk related to investment. Those risks include restriction on currency remittance, appropriation of nationalization, war, domestic conflict, and civil obedience, rescission of contract on contravention of the provision of the law or violation of the law, non-commercial risk as relevant to international agreement. The investor, unique provision that the investor may insure the project and pay an annual premium, while the government itself had the option to contribute in the premium, and also that contribution will be deducted from the obligation of the government towards such project. Another key law which has been reviewed in the recent year, which is the arbitration law, issued on or reviewed on 2016. That law now in line with the principles of UNISTRAL. On the side of arbitration in Sudan, although we have considerable number of arbitration cases, all these cases easily the parties agree to refer to arbitration. The courts in Sudan recognize the arbitration process, that we have no issue of implementation, the process or the proceedings of arbitration on ad hoc basis. Unfortunately, Sudan still has no institution of arbitration. Therefore, all that the arbitration cases are resolved through ad hoc arbitration, and unfortunately in a law firm offices or hotel halls and meeting rooms, or sometimes in public area, which is a little bit of concern. This is why we in a Stan law firm, from practice, we can highlight that it is a high time we need in Sudan an arbitration institution, not only for conducting the arbitration process, but also for building the human capacity that we need to raise the competency of the people there, of the arbitrator, especially that if we consider in our mind or take in mind always, arbitrators may not be a lawyer. So most of the cases construction, it's referred, or the arbitrators there are appointed from engineering side or technical side. Those engineers or those are specialized arbitrators definitely need to be also cope up with the arbitration rules, procedure, principles, and also to be updated from time to time of the precedents and to see the impact of any action they take against in action they take, and what the risk they are putting the parties in by their behavior. For example, maybe it's good to mention that in this area, we have in, time is okay. Okay, it's just from practice. Let me just mention one of the cases that we in Astan face an issue with regarding the enforcement of arbitration award. That case has been conducted, foreign arbitration award is issued, and the enforcement should be in one of African countries, and that we failed to execute the arbitration award. It took from us years to trace the assets of the judgment debtor outside that jurisdiction and catch it, seize, and then enforce it outside the jurisdiction of the place where the arbitration should be enforced. This is a very serious case, and this is amongst the number of African countries which need always to consider while we are talking about promotion of the area African area as hub for arbitration. Thank you very much.
Thank you very much. Last but not least, I would like to welcome Dr. Jimmy Kodo. Timekeeper, you're helping us very much from the front there. I'm unable to get to make eye contact with my panelists, so I'm very thankful for what you're doing. Thankfully, this gentleman helped me find my way to the right venue. If we hadn't met for breakfast, I think the hotel was going to send me to a different venue. So you deserve a special round of appreciation for that. He's going to speak to us about Francophone world, the experiences. I know there's been a lot of debate around the litigation that emerged with the Guinea case. I imagine he may speak about that when talking about arbitral institutions and his role within the CCAJ and so forth. Very much welcome, Dr. Kodo.
Thank you. First, I will start by saying that I'm very happy to be here. I'm happy for 3 reasons. The first reason is that this is my first time in your beautiful country. Second reason, it is the first time that I'm meeting many of you, and I'm catching up with some of friends that I already known for a few years. And the third reason, I am always passionate about arbitration topics. So let's go into the topic. I am here to talk to you about some of the recent trends in arbitration under the rules of OHADA, basically in the 17 African states that are part of the OHADA Treaty. And I have mainly 4 points, 4, maybe 5 that I will be talking briefly about. I did not plan specifically to talk about the Guinea case, but maybe during the questions, we may talk about that briefly if we have time. Mm-hmm. And I also wanted to mention that I'm no more member of the OHADA court. Basically, I served in the past as an advisor to the president of the court, but since the end of 2017, I've moved back into practice. Mm-hmm. So now I'm again a lawyer and an arbitrator. So I just wanted to make the precision. So with regard to the recent trends, the first point that I would like to mention is that since 2017, there has been a lot of changes in the arbitration rules within the OHADA region. First, at the regional level, you have the Uniform Act on Arbitration, which has been revised, as well as the CCGA arbitration rules. As I said yesterday during the comments, you have OHADA arbitration is twofold. You have on one hand an institutional arbitration, which is governed by the rules of the Common Court of Justice and Arbitration. And then on the other hand, you have a specific set of rules, Uniform Act on Arbitration, which can be used in any of the 17 countries for resolution of disputes. So those 2 sets of rules have been revised in 2017. And very quickly, some of the new features of some of these rules are, for instance, that now it is possible for the parties to waive their right to challenge an arbitral award, which was not clear before in the rules. It is possible now to intervene in arbitral proceedings, which was not clear before as well. It is possible now to, first, the court, whether a local court or the Common Court of Justice and Arbitration, they have a limited time now within which they need to rule whenever there is a challenge to an arbitral award. And also a local court to which an application is made for the appointment of an arbitrator. Let's say someone initiates arbitral proceedings and then one party is using some kind of dilatory tactics, does not want to appoint the arbitrator. There is a time limit within which the local court has to appoint an arbitrator, which is 15 days. Also, some issues, if they are not resolved within a certain time, limited time, then some of these items may be directly referred to the Common Court of Justice and Arbitration. On the national level, you have many countries as well, which have revised the arbitration rules, basically either nationally, these are some like bylaws, because normally the rule that apply normally is the Uniform Act or the CCG arbitration rules. But many countries have revised the local arbitration center, the rules, arbitration rules of the local arbitration centers. And I can give few examples. For instance, for first, Cameroon. And what I would like to notice is that back in late 2019, when they revised the rules, for instance, they introduced a provision allowing for virtual hearing. as if maybe they foresaw that there would be a pandemic and possibly that something will happen and then it would be more difficult to have in-person hearings. So they have that provision in the rules. I can also talk about some other countries such as Côte d'Ivoire, which recently amended the arbitration rules, and also Congo, Democratic Republic of Congo. And we do not have time now, otherwise I would have given you many interesting examples because I had a chance to revise the rules of Congo. And one thing that I would like to mention is that I discussed with the center and they accepted that I introduced in the rules some provisions that will allow for two main things, which I believe will increase diversity in the appointments. The first thing is that now there is a specific provision in the rules allowing for the secretary of the center each year to run statistics, to collect data from the cases, of course, anonymous data, but to ensure that it is possible to determine what's the ratio of appointment, first time appointed, person being appointed, whether women, whether men, and also to understand the ratio of foreign investors that came to the center for cases and many other interesting data. The second feature that was introduced in the rules with regard to fostering or promoting diversity is that you probably heard of the Rooney Rules, which was developed many years ago in the US in the area of football, but then has been introduced by many centers in arbitration. Basically, it means that when you, as a center, or as an appointing authority, you need to appoint someone, or whenever a party to an arbitral case refers to you for the appointment of an arbitrator, instead of saying, okay, the party usually say, we want someone which is very competent, which has a lot of experience, etc., which end up with the result that many people are appointed over and over again, which increases and strengthens the experience, while many people who are very well trained do not have this possibility. So the rule is that whenever you have to appoint yourself, or whenever you need to propose, you select maybe 3 to 5 persons. If you select 3 persons, you need to ensure that you have people from both genders, thank you. So male and female, definitely. You need to ensure that in all categories, you have at least one person who has never been appointed before as an arbitrator. And we split, I created 3 different categories if you want to appoint. If you need to appoint a president, unless it's a very exceptional case, or the parties specifically agree to have someone who has never served as an arbitrator, you cannot appoint someone for the first time as a president of a panel. So if you need to appoint a president, the person needs at least to have served at least one or few times as a co-arbitrator, and ideally at least once as a sole arbitrator, because when you serve as a sole arbitrator, usually you perform all the tasks and it requires a lot of experience. If you need to appoint someone who is a president, so you need to have someone who has already served in that capacity. And if you do that, basically the expected goal is that it will make it easier for people to increase the pool of arbitrators, qualified arbitrators. And of course, everybody has an obligation to be trained and to regularly give evidence of the center of their training and continuous training. So these are some of the good, I think, items that were introduced in the rules in Congo. Now, you also have creation. Another trend is that many countries are setting up arbitration centers, and some of them are considering creating new centers. For instance, Chad, I think they are probably already completed the creation of a center, which I think was done recently last year. You mentioned Guinea-Bissau. I talked with the representative of the country last year, and they had a project of creating a center, which I hope is going on very well now. Then you have some other countries. I will briefly talk in a few minutes about 2 more interesting trends. One is that many countries from the Hada Treaty, they have specific steps toward arbitration. Specifically, for instance, Chad, they have enacted the new rules, which gives an obligation for everybody to insert, whenever there is a contract involving the state or a state entity, that they have to insert an arbitration clause designating the Common Court of Justice and Arbitration. And the last point, which I believe is the most important maybe, that I would like you to go with from what I'm saying, is that recently, the Common Court of Justice and Arbitration has issued an important ruling which will help enforcement of arbitral award. For many years, for the last 15 years, there was a precedent of the court under which if you have a case, a judgment on arbitral award against a state or a state-owned entity, they have enforcement immunity, and you cannot go and enforce your arbitral award or judgment against the state. And in 2020, they changed the rule. They did not change the rule, but they changed the precedent. The precedent before was that even a country, a member state of OHADA, could not change its own internal regulation to allow for a state to waive their enforcement immunity. And now the court, in a very nice, I would say, or very interesting ruling in 2020, decided that a country could waive the enforcement immunity. The way they said it, they said that it has to be expressly stipulated in a contract or whatever agreement is it, so that now it is very interesting to notice if you are drafting a contract involving a state in one of the OHADA countries, now you can insert a provision saying, okay, the state specifically waived their right for enforcement on specific items, or maybe you want to allocate specific assets to this operation. It is possible to do it. And I think it is a very great news for the whole community, specifically for arbitration. Many people don't seem to be aware of that. Even myself, when I discovered it few weeks ago, I was very amazed that nobody talked about it. And I'm preparing a publication which hopefully later in the year will be available. Thank you.
Thank you very much. I think Dr. Muigwa, Mr. Kamau Karori, I'm not sure where you are, but those are very interesting learning experiences on this problem of the diversity gap, how they have used the rules to practicalize mentorship and the experience of the youth and women, the gender perspective. So I thank you again, wonderful panelists. I will hand over to the plenary. I'm looking out for any questions. I know I had asked a few questions of my own, but I would like to subordinate them to what may be coming from plenary. Any hands? There's a hand there. In our defense, timekeeper, when we couldn't see, the spotlight is extremely powerful. So please, we are not able to actually see. So there's a hand there. I think that is yes.
Yeah. I think it's good morning, everyone. My name is Chegen Njoroge. I am from Kenya. And I'm interested from the presentation made by Jonathan in relation to South African experience in relation to BIT. I know that South Africa has taken decision to terminate most of the BITs in favor of an investment act. And the question is whether third decision was arrived at upon reflection that probably these BITs in South Africa, as may indeed be the case in many countries, had outlived their usefulness. I'm also interested to know that under the SADC Treaty, there are obligations for the countries to ensure that the investors have access to international arbitration as a mode of dispute settlement. I'd like to know how that is being dealt with by South Africa under the Investment Act, and whether you view it as a favorable move for other African countries to to do what the South Africa has done in terminating the BITs. Thank you.
Thank you very much, Mr. Njoroge. Any other hands? There's a hand right at the back there. Two questions for you, Jonathan. BITs, what informed that decision? What is its impact? Should it be copied elsewhere?
Okay, good morning. I'm Kelly. I'm from Cameroon, but I work in Rwanda. I dare say that my question goes to Dr. Kodo. I dare say that the arbitration center of the CCJA is striving to become the designated institution for arbitration related to investments in the OADA region. So I wish to know, in order to reach this goal, as an expert, have you identified any other existing shortcomings in the CCJA arbitration rules that would prevent it from actually achieving such goal? Thank you. And what would be the solutions that you could propose? Thank you.
Thank you very much, Kelly. Our last hand, I see there's another hand there, right in the middle. There we are.
Good morning, everyone.
Good morning.
My name is Nyambura Mbatia. I'm the Registrar of the Commercial Court of Justice. And my question goes to Jonathan, I believe, the one that spoke about the region. And of course, I'm interested in this area because we are also a regional court. And I wanted to find out from you whether the disbarment or disbandment of the SADC tribunal is an indication of how member states are unwilling to actually accept regional courts as far as the resolution of disputes within those regions is concerned. And my follow-up question is this. Yes, you've said about, for example, doing arbitration under the tribunal, but what are the shortcomings that you see being evident in that kind of, because as the lady earlier, the judge from the East African Court of Justice mentioned, the ESCJ has arbitral jurisdiction. So does the Commercial Court of Justice. But the question is this: do judges appointed in the way they are appointed to these courts fit to be arbitrators in such courts? And I thank you.
Thank you very much. So those are three questions. And the last one has a capacity link to it when it comes to the judges of this forum. So we'll start off with Jonathan. You can take these two sets of questions from Mr. Njoroge and Madame Nyambura, and then we'll hand over the last one to Jimmy after that. Thank you.
Sure, thank you. If I got it correct, the first question related to the actual decision on the termination of the BITs from South Africa's perspective. The decision, well, the South African government described it as a simple non-renewal upon expiry of certain BITs. It was largely perceived as a decision to terminate the BITs. So either way you spin it, the reality is that the BITs, the majority of them fell away. A lot of criticism was placed on this, and a lot of research was done as to what was considered in taking that decision. And my understanding is that primarily the research evidenced that foreign direct investment was not directly related to the availability of treaty protection. And this was done, quite a broad global survey was done to try and work out the correlation. So that the first step was, is this going to affect FDI? And the decision was taken, probably not. And so that then empowered the government to do what they wanted to do. But the main reason why they decided to take this approach was as a result, we heard yesterday, the Forestry case, which really brought things to a head. South Africa's policy post-1994 has been about transforming the economy, forgiving or getting over the injustices of the past and creating really sustainable reform. And one of the mechanisms of that was the principle of Black economic empowerment. And this underlay the issues that arose in the Forestry case. And it became quite obvious to the government that if they didn't address this immediately, they were going to face a barrage of claims as a result of the consequences of economic empowerment that they were imposing in the country. And so that was from a very subjective South African position, but it was then bolstered by the effect of, or the conclusion that the FTI was not going to be affected as a result of termination, and that essentially led to the decision. The second question, I'm not sure if I got the question entirely right, but it just related to the SADC Treaty and the establishment of the SADC Tribunal and the access to the tribunal that was afforded to all SADC members. And at the same time, well, the tribunal was essentially disbanded at the same time that South Africa took the decision to not renew its BITs. And so that was largely informed by it. And the two big cases that involved South Africa's decision was Mozambique and Lesotho. And so there was regional support. And at the time, there was a lot of skepticism about independent tribunals taking decisions that impact on states, particularly developing states, and the size of some of the awards that have been granted against the states and their ability to actually satisfy those. So there was a little bit of an emotional turmoil at the time, and the decision to disband it happened in two phases. The first was there was simply a decision not to renew the terms of the judges that were appointed to the tribunal. So the tribunal then became de facto defunct. And then there was a decision to amend the protocol, which gave the tribunal the ambit and its jurisdiction. And there was a deliberate effort to remove the investor arbitration and replace it with state-to-state arbitration in those circumstances. So those were two deliberate acts that were taken to actually essentially disband the SADC tribunal, which deprived then the SADC members of an independent court tribunal to take their claims to. And I think that then leads into the second question, is what is the attitude of the region towards regional courts? And this is something that is being discussed under new developments as to whether a court is the answer. My view on that is that I'm not really sure what the attitude actually is. I think that there is always a concern with a person who is not a national or bound by state law taking a decision that impacts the economy of a particular country. And so whilst regional courts may be a slightly more palatable option for states, I still think that there is the sovereignty issue that many states are struggling to get their heads around, that someone else will tell them to do something that will affect their ability to regulate their own policies and procedures. So I think that the proposal of a state court is a step in the right direction. But our South African president has basically confirmed that his attitude or the country's attitude towards investment treaties is not going to change in the short term. So we're not going to see any regional tribunals, I think.
All right, thank you. Jimmy, on Kelly's question. Okay, so thank you, Kelly, for your question. Basically, if I understand well, you were asking what will be done or what should be done. What are first the shortcomings with regard to the CCGA if it is considered as a center for resolution of investor-state disputes, if I understand the right? I would first say that even before the rules were revised in 2017, it was already, at least to a limited extent, possible to have investor-states certain type of dispute resolved by the center. So now when the rules were enacted, it makes it easier, it made it easier to do. Now, some shortcomings, what could I say? The first point I would say, I will mention language issues. You know, OHADA Treaty, we have 4 official languages. Your country, Cameroon, has 2 official languages, English and French. And then we have Portuguese, we have Spanish, and French. So those are the 4 languages. Right now, the main rule that is used for almost everything within the organization is French. And it can be understood because most of the countries, they are French-speaking countries. However, for the institution to work efficiently, and usually if you have, when we consider business around the world, we do many things in English, and it is not right for an organization to claim that, okay, we have 4 official languages, among which you have English. And specifically, 2 years ago, I wrote a book on OHADA arbitration. And when I was writing that book, I noticed that the version, the English version, which was translated and published in some of the official gazette of the organization, did not contain the official translation in English. And I noticed there were many errors, and I had to do almost all my own translation for both the Uniform Act on Arbitration and the CCGA rules. So the first step for me will be to ensure that we have proper, very well drafted rules. And one of the suggestions which I submitted back then to the permanent secretary was that whenever the organization is selecting consultant or expert to draft the new rules, they need to put a clause in the contract saying that, okay, you are going to be submitting us a draft, but we want you to submit a draft in the 4 languages, because we are an organization that have 4 working languages, and we want to have the draft in all the languages, like it is done in many other countries and organizations around the world, so that whenever the rules are adopted, enacted, then you know you have already the official versions in the 4 languages. Unfortunately, it has not been made yet, but I think this is one thing that could be done. Then some other issues I would say, logistical issues. Because if you consider an institution like ICSID or some other major institutional arbitration center in the world, and you compare it with the Common Court of Justice and Arbitration, then there is a lack of people working there. I think they need to increase the number of people who are working, whether judges, whether the arbitration center of the center itself, and many other things that need to be done. And it requires, I would say, logistically, some more means in terms of equipment and some other things like that. Then, very important, political will. You know, if you consider the rules, generally, there are a very good set of rules. And when it comes to many things regarding application of the rules in Africa, the one thing that is usually missing, or the weak link, is the enforcement, how the rules are applied. And usually it is not because the rules are not good, but it is because either you don't have the political will, or you have, for instance, when you are dealing with states, it happens very often that whenever you are at the stage where you are signing a contract with the state, they will assure you everything is fine, don't worry, we are doing business, it is fine. And when there is a dispute, then the state will come to you and say, okay, do you know who I am? I am state so-and-so. Well, I'm doing this, I'm saying this in a very graphic way or very funny way, but basically that's what happens sometimes. And then it has happened sometimes that you see there are some pressures, which is not really because the rules are not good again, but there is something that needs to be done in this with regard to that. Then transparency. Transparency, and I had one regret, or one of the regrets that I had after the rules were revised back in 2017, was that there was not a specific provision regarding transparency regarding investor-state arbitration. And I'm very happy to notice that your country, Cameroon, in my opinion, is maybe the only one country so far which has adopted the Convention on Transparency in Investor-State Arbitration, and that was by law back in 2017, I think. So I think one of the good things would be to do this at the regional level so that the CCGA itself, its arbitration, they could have more transparency, at least regarding investor-state arbitration. Then, with regard to enforcement, something needs to be done, because sometimes, even though when you have a judgment from the CCGA, it is final and binding in all the 17 states, as I said briefly yesterday, sometimes there may be some issues with regard to when you come to the stage of enforcement, because the court is a regional institution. When you have a judgment or an arbitral award with the exequatur order from the president, normally under the rules, you go in any of the 17 countries, you can enforce your judgment or your arbitral award. However, there is one step which should be normally a very minor step. You go before the registrar of the Supreme Court of the country, or in some other countries, depends, this is the Ministry of Justice. They just need to put a stamp on your arbitral award or judgment. This is not a judicial proceeding, it just needs a simple formality. But in some cases it happened, and at least as I mentioned yesterday, there was a case where it could not be done for many years. So there was no enforcement possible. This could be changed, and I had suggestions which I will discuss with you. I put it in the publication, we can talk about it later. And then the last thing I would say is about specific training. Training for judges when they are handling arbitration-related matters. It is very important. It happens sometimes that you have training where they train everybody together, arbitrators. It is not always easy to train judges with arbitrators. It is important to have proper training sessions in place for judges, then for arbitrators. For people who work at arbitration centers, I have a very important example that I could have given you with regard to some of the issues that are caused by the lack of training and creating serious issues in some arbitration proceedings, but again, we can discuss that later.
Ladies and gentlemen, we are way over time. I can see the organizers shadowing me right behind this corner. Please join me in expressing a very sincere appreciation to our rich panelists. We have a lot of side chats after this. Sudan presents an excellent experience on opportunity. I think the closing end of her remarks, Nawal talked about that there is no arbitral institution at the moment in that area. So there's a lot of side discussions we can have. Once again, thank you very much for your participation and your audience. All the best.
Thank you so much, Sarah session. Please appreciate them as they go back to their seat. Next, we have a presentation, and the presentation is from Noela Rubamo, who is a partner at Oraro and Company Advocates in Kenya. You people know they're one of our sponsors. Please, after this honored panelists have taken their photos, let's welcome our next presenter, Ms. Noela Rubamo. You're welcome. Thank you. Let's appreciate her as she comes. Thank you.
Thank you very much, and very happy to be here today. It's always a pleasure to be invited to speak to all you very auspicious people. And I think what we don't appreciate is this forum always provides me with an opportunity to learn something new. So the topic that I've been asked to speak today is about arbitration and technology. And initially I was selected as a moderator. So I prepared 5 to 6 very difficult questions that I was going to ask the panelists until I was told I'm actually the speaker. And therefore I had to answer these 5 or 6 very difficult questions. I must say that I'm not an expert in this area, and the expert is truly my 22-year-old nephew, who I obtained material for this topic, because he's currently at Middlesex University studying a lot about blockchains, cryptos, NFTs, all those kind of things. So this is a perfect example of where passing the baton would have been a really good thing, because I think this is a topic that is best understood by anyone who is under the age of 25 or 30. And that doesn't mean I'm old. I'm actually quite young. I'm just encouraging younger speakers for this kind of topic. And I like to start these discussions with the fundamental question of why does it matter? Why have we gathered here today to hear about arbitration and technology? If I was to ask my nephew, the very same nephew, he'd say it's because it's fun. You know, cryptos, NFTs, all that is fun. But I think for the rest of us, this is an important topic because the world is developing and there are new emerging trends, and great advances have been made in technology in the space of arbitration. And we risk being declared redundant if we don't update ourselves on these new technologies, which will come, must come, and they will replace traditional arbitration as we know it. So I think it's an extremely timely topic, and I'm quite happy to discuss this area with you. And one of the phrases that comes to mind is you innovate or you perish. And I know many people know this phrase has been used to refer to brands that have ended up dying out, like Nokia and any other brand that has been overtaken by events because they failed to innovate. So as arbitrators, I think my challenge to us today as arbitral practitioners is that we must innovate or we perish. And on that very sour note, I will begin by asking a question. This topic will focus on only 3 areas of development. Obviously, there's a lot of areas of technological development in arbitration, but I wish to focus only on blockchains, cryptocurrencies or crypto assets, as well as smart contracts, and also only in the context of arbitration. So by a show of hands, I'd like to know how many of you have invested in crypto? 1, 2, 3, 4, okay. How many of you have had instructions or have obtained questions from clients regarding any of these 3 topics? Crypto, smart contracts, blockchain. And so that's a sizable number, about 7 or 8 people. what is inevitable is in 5 years, or maybe even less, all of us will have had inquiries from clients regarding these 3 things and more. And so it's extremely important that we understand the basics. So the purpose of this presentation, I have 3 objectives. I think even if I achieve just one, we will have done well. And the first one is for us to gain a very basic understanding on what these new technologies are. And I don't propose to give a comprehensive understanding on the technical nature or features of some of these technologies. And then the second thing I wish to do is to flag some of the challenges that these technologies pose within an arbitration context. And then finally, to see how some of these challenges can be addressed and how we can prepare ourselves as lawyers to address some of these challenges. So without further ado, I'll start by talking a little bit about blockchain. And so what is blockchain? From a very basic understanding, it's also known as a distributed ledger technology. In my mind, I simply call it a database. But the legal definition of blockchain is, it's described as technologies that enable a secure validation, recording, and sharing of data in a database. So think of a blockchain as a secure, self-validating database of information where you can record information from a very basic understanding. Some of the distinct features of a blockchain is that it is distributable, which means that it can be kept and maintained simultaneously by many people and many organizations all at the same time. And then it's self-validating, which also means that it doesn't require a third-party intermediary or physical documentation to maintain it. Another feature is that it is incorruptible and immutable, and this becomes important when you start referring to the challenges in arbitration, because the way it is stored, it's encrypted, so it's incapable of being changed or amended or varied once it is recorded and stored on the blockchain. And then it's considered a highly secure method of recording, storing, and validating data. So there are 2 types of blockchain. There is a public blockchain and there is a private blockchain. A public blockchain means that any person can participate and access the information that is stored on that blockchain, while a private blockchain, only invited persons can access or participate in the network database. So it restricts the rights to validate or to store data or transactions on that blockchain to only people that are invited. So just to help us understand blockchains in context, I think one of the things that we can find are the uses for blockchain. So blockchain is normally used for fundraising through digital tokens. It's also commonly used for the issuance and administration of shares. And NASDAQ, which is a US-based trading, clearing, and exchange technology provider, uses this, and it allows private companies to issue tokenized shares, which are recorded then on a blockchain. So think about changes being made in a shareholding of a company that are stored on blockchain. It can be done, and it's immutable, it's incorruptible, and it's permanent. Blockchain is also used for storing KYC information or the personal information and data for verification purposes. So especially personal information that is repeatedly requested for when you're carrying out transactions or when you're doing something. It's also commonly used in insurance contracts. And I know Musk uses blockchain for marine insurance contracts. And then it's used for the administration of IP rights. So you can identify the date of registration of an IP right. It can identify transfers of that right and payment of loyalties. And it can administer IP administration and management. And then it's also being used for electronic patient records. And I know this because I have a cousin who is currently creating a blockchain database for vaccination for babies in Kenya. And so these are one of the uses, just to contextualize blockchain. Finally, it's used as a digital payment service, and Bitcoin was actually implemented on the basis of a blockchain. And then the other one that I really like is blockchain is used in the Internet of Things. And what that means is it refers to smart things like smart washing machines, smart cars, and blockchain is the underlying backbone or infrastructure for some of these devices that you hear are smart. And so that's all you need to know about blockchain from a legal perspective, and quite easy. So let's go to smart contracts. So what are smart contracts? And although smart contracts actually predate blockchain, there's only been increased renewed interest in smart contracts because of the combination of a smart contract and a blockchain and the possibilities that can arise. And this is very recent that it's been discovered that you can combine smart contracts and blockchains to come up with something really unique. And so what is a smart contract? And a smart contract, we tend to think of it in the conventional sense, but we shouldn't really, because it's not in writing, it's not in words, and it's not even in digital communication. A smart contract is basically defined as a code that is programmed to execute predefined and agreed logic automatically in response to an agreed input or a trigger. And so the argument has been made that, smart contracts aren't really contracts because they're not executed by people in the ordinary sense, but they're executed by computers. So you feed code into one computer, and then you prompt it to trigger a certain action when certain conditions exist, and it implements or executes that contract. So there's no human intervention. And some people argue that this is not a contractual transaction. And we'll see how this has become one of the challenges that smart contracts face within the context of enforcement in an arbitration context. Now, a smart contract is self-executing, which is one of its main features. And what that means is that it does not require a human intervention for the contract to perform the function that the contract is supposed to do. And it can be embedded into a blockchain. Like I mentioned, the combination between a smart contract and a blockchain is what makes it really special. And that has given rise to various problems because given you remember the immutable and incorruptible nature of a blockchain, which means it cannot be amended, it cannot be varied, it cannot be modified, is somewhat problematic for a contractual transaction, which will sometimes require these things to happen. And then smart contracts can only carry out what they are programmed to do. They have no capacity to interpret the contract, nor can they provide a reasoned analysis as to whether the performance of the contract is correct or satisfactory. And so what are the uses that have been applied with smart contracts? Some of them include escrow agreements, where the program is coded to release the escrow asset once something happens or it's triggered by certain conditions. Then it's also been used in the settlement of insurance policies. So it is coded to basically understand that if certain conditions exist, then it can trigger an insurance premium or payment to the holder of the insurance policy. And it's also been used for royalty payments in intellectual property settings, and it's been used for the payment of goods. And that is all you need to know about smart contracts. So we now know what blockchains are. It's like a database. We now know what smart contracts are, contracts between computers, which are self-executing and based on triggers. The last thing we need to know is about cryptos. And so what are cryptos? So the word crypto has been used interchangeably. Sometimes you'll hear people say cryptocurrencies. Other times you'll hear crypto assets. Other times you'll hear digital assets. Other times you'll be referred to virtual assets. They're all the same family, but I think we need to understand that crypto assets are much wider than cryptocurrencies. So when you refer to a cryptocurrency, it's very specific, while when you refer to a crypto asset, it's much wider. There is no clear definition of cryptocurrencies. However, it's generally agreed that they are defined as cryptographically secured digital representations of value or rights built on a blockchain that can be transferred, stored, and traded electronically. In short, it's known as a means of exchange in online transfer. Now, it's not issued by central banks or authorities because it is too volatile to be a good store for value. And this is mainly because it does not meet the economic criteria of government-issued money. So the volatility of crypto is what makes it highly unattractive as a government-recognized currency. And so that is why central banks will ordinarily not want to approve or recognize cryptocurrencies. Instead, they will then create their own digital currencies. And we see that happening in various countries like the US, China, among others, where the central banks have indicated that they will come up with a central-backed digital currency. This is a CBDC, which is being introduced by governments to enable global peer-to-peer transactions of digitally represented currencies. So they're trying to go around the volatility of a cryptocurrency by coming up with their own central bank-backed digital currency. So the common feature of crypto is that it's a means of exchange which enables buying and selling of goods and services. It can be used also for investment, and it can be used for capital raising. And that is all you need to know about cryptos for purposes of our discussion. So we've discussed blockchains, which is a database, smart contracts, which are contracts executed by computers. We've talked about cryptos, which is mainly a means of exchange, so money really, or a digital form of assets. Now, the last thing that I just want to touch on is NFTs. Now, NFTs are non-fungible tokens, and basically these are understood as a unique digital certificate registered in a blockchain, and they're mainly used for artwork and collections. I have 5 minutes left to tell you about the interplay between these technologies and arbitration, so I'm going to rush. Now, in terms of arbitration, there are two types of arbitration. Generally, there can be an on-chain arbitration or an off-chain arbitration. An on-chain arbitration is arbitration that is embedded in the technology. So you will have a smart contract that has an arbitration trigger within it. And then you have an off-chain arbitration, which is an arbitration agreement that exists outside the technology we're talking about. So insofar as smart contracts are concerned, they're made up of two components. There is the truly smart component of the smart contract, and then there's the written part of the smart contract that is called a wrapper. So in some cases, your arbitration clause will be in the wrapper. That's the written part of the smart contract. Otherwise, in other cases, you could have a smart contract that is coded to trigger arbitration when certain conditions are satisfied at the option of one or either parties, and during that period, freeze performance of the contract. Now that's an on-chain arbitration. And you can also have on-chain enforcement where an arbitrator is given power to modify the smart contract or its outcomes. So that's how arbitration then comes into play. Now, in terms of cryptos, crypto, remember, is property. It's a digital asset. So you cannot have an arbitration clause on the property. So for practical purposes, you must have a separate contract that provides for arbitration with respect to the crypto. And so there are various types of arbitration mechanisms when it comes to crypto. One of them is where you have signature transactions. And this is basically, cryptos normally have 2 keys or 3 keys, and the keys are what you need to be able to transfer the crypto. So for purposes of arbitration, you can have 3 keys, with 1 key being a neutral operator of that crypto. So that if a dispute arises, to transfer the crypto, you will need 2 keys. But if there's a dispute, one of these people will not transfer it. But if there's a 3rd key, the neutral person will determine in whose favor the dispute lies and assist the other party to transfer the crypto. And so that's a means of resolving crypto disputes, and it's called signature transaction arbitration. And then there is collective agreement arbitration, which is also used in cryptos and blockchains. And this is where the users of the blockchain agree that certain designated persons are allowed to modify the blockchain or amend it or vary it or implement the decision of an arbitrator, so that at the end of the day, the users will then use the modified blockchain once it has been amended or varied by their agreement. Now, there are no rules that govern arbitration for these kind of technologies, but we've seen some coming up. So there are the JAMS rules of 2021, which are in the form of an expert adjudication, and it takes 30 days where an arbitrator is appointed, and then he determines what should happen. And then there's also 2021 digital dispute resolution rules that are formulated by the UK task force. And this is also akin to an expert determination. And I think these are the only two most detailed rules available that are tailored to deal with digital disputes for cryptos and smart contracts. Now, in closing, what are some of the challenges that you should be aware of as an arbitrator, as a practitioner, when you're dealing with cryptos, smart contracts, and blockchains? First of all, you need to understand that the anonymous nature of these technologies, which means that half the time the users are not known to each other, that creates a problem. And then the immutability of the blockchain, the fact that it cannot be varied, cannot be deleted, cannot be modified, is problematic for enforcement. And then also you have the issue of computers contracting with each other rather than human beings. And then you have the intangible nature of these technologies. You also have the problem that these transactions take place in different jurisdictions simultaneously. So it's very difficult to position the transaction or position the parties for purposes of establishing a choice of law or a jurisdictional clause. So these problems make enforcement of these technologies or transactions done on these technologies very difficult. But some of these challenges have been addressed, and we can talk about it. Choice of law issues can be predetermined. So you can agree that for this blockchain, the choice of law and the governing law will be X or Y. And it's very important that when you choose these jurisdictions, you choose jurisdictions that are favorable to enforcement of these technologies. For instance, in Kenya, cryptos are banned. So that if you ask me for an opinion on a transaction concerning crypto, because it's too difficult for me to give you the opinion, basically because I don't know what the answer is, I will tell you, you know, cryptos are banned in Kenya, full stop. I think we should be better. They may be banned in Kenya, but it may be that the governing clause of that crypto transaction isn't even Kenyan law. So there's more than just cryptos are banned in Kenya. Also, there are difficulties with enforcement because the Chinese courts were asked to recently enforce an award that arose from a transaction that was done concerning crypto assets. And they refused to do so on grounds of public policy because cryptos are also banned in China. So these are some of the problems that you will encounter. But I think some of the solutions lie in the choice of law. If you're advising someone who is trying to do transactions or build a transaction on a blockchain or smart contracts. Also, the fact that you remember the on-chain arbitration clauses, the ones that are self-executing. The New York Convention may have a problem with enforcement of that because it's not in writing. Remember, that's a program that is coded to initiate a dispute resolution mechanism when certain data is inputted. So for purposes of enforcement, there are problems with, is this a written arbitration clause? It's the wet ink problem. There isn't a wet ink arbitration clause, and that may be problematic for you. And then we've also talked about the volatility of crypto assets. And we've seen the Chinese courts hand down a damages award in respect of damage or loss that was suffered by someone who had a transaction that was carried out through a crypto arrangement. And the problem with damages is, given the volatility of cryptos, the value keeps, it keeps changing. It is said that it's probably undesirable to have a damages award for crypto disputes. And then also the binary nature of smart contracts means that they cannot, when they're performing whatever they're supposed to perform, they cannot abide by traditional legal concepts of contract, such as reasonable endeavors to do X, Y, and Z, act in good faith. And those are problematic when you're talking about whether the contract was satisfactorily performed or not. And then, of course, I think the US courts are grappling with whether crypto arrangements are actually contracts because of the intangible nature. I think under US law, for you to even qualify for a contractual dispute, you must first of all show that you are property, that whatever the subject matter of the dispute concerns property. Now, the problem with the definition of property, I think under US law, is that intangible assets are sometimes not recognized. So it's posing a lot of problems from that perspective. And I think based on my notes, that seems to be all. I had hoped to take more time than was necessary so that I don't have time for questions. But it seems I may not have achieved that. I already see 2, 3, 4, 5 hands. Can I take these questions offline? Anyway, it's okay, I'll wait till I've finished. I can take one question? Okay, who has a burning question that is easy? I'll take this one.
Yeah, thank you. My name is Gatete Colin from Colin and Colin Legal Solutions in operating from Rwanda. Now, you have a very interesting topic, and I would like to inquire, or even from the audience,
thank you,
to share with me what you think. There's an issue about cryptocurrencies being, first, if you look at the jurisdictions around the world, including Rwanda, let me talk about Rwanda, they tend to be silent. They're not very precise. And the reason is because, from what I understand, that they are not sure about what it is. So they don't want to say no, because it is coming and it is strong, and we definitely is coming. In fact, in Rwanda, they've made they're doing studies to ensure that, to see how they can have cryptocurrency as a legal tender, which actually brings me to my question. How do we transact or engage in agreements or even arbitration in a currency that has yet that is yet to achieve the legal tender status? And the way people are looking at cryptocurrency, especially those who don't understand it very well, they tend to fear it. And I've been in matters whereby even clients being arrested simply because they had, when you have cryptocurrency, you can have it on an app. So you have an e-wallet with, all these kind of currencies. They've been arrested and they're suspected. So, and it is understandable because it's not legal tender anyway. So how do you harmonize the issue about legal tender and cryptocurrency being, not very, how do you harmonize the two? There's a gap there, which I think should be addressed for it to be used and by the public properly.
Yeah, so I think I'll just answer before we get to the next question. I was hoping there isn't any more. The solution that most central banks or governments are taking is to issue their own central backed digital currency, because I think they understand that this development is coming and there's no avoiding it. There is no avoiding people trading in digital currencies. And rather than trade in what is a highly unregulated space, they're trying to come up with their own digital currencies, which they can then regulate to allow for that technology to grow and to develop. So that's my understanding of what's happening. But I think also the bigger problem is that there's a real lack of knowledge. No one quite understands no one understands fully the potential of these technologies. Least of all lawyers, who are then charged with the responsibility of coming up with a regulatory framework for them. And there's a great need for experts in this field, experts that understand both the technology, experts that can code, and experts that can then sit as arbitrators to decide disputes arising from these technologies and also come up with a regulatory framework for these technologies. So it's a new emerging area. I think it's an area that will grow, and I think it's an area that we cannot avoid. And I think it's something we need to start planning for us to remain relevant in the market. There are a few hands at the back. And I think I have time for only one question.
I'm very glad that I'm the one question. My name is Jeffrey Kadu. I'm a lawyer with KTA Advocates from Uganda.
Yeah.
We do a lot of technology related work. So this is an issue that we are faced with. So I think it's going to be a simple question. And I'll use the Ugandan context. In May this year, Bank of Uganda, it's the Central Bank of Uganda, outrightly outlawed cryptocurrencies and crypto transactions. And over the period of time, they have generally shown a bit of reluctancy to go all the way out. It has continued even earlier this week. The Capital Markets Authority also issued another buyer beware sort of statement against one of the companies that is transacting in online transactions. So there's a general reluctance by the government and the regulators to adopt or go or test the water with both feet, let me say, in line with this. So my question really is, understanding that these are many a time multi-jurisdictional transactions. You know, you're transacting with someone in the United States, in Australia, in Russia, in Brazil. So how then do you enter a form of multi-jurisdictional enforcement in light of unfavorable regulatory policies in different jurisdictions where you have two people on different spectrums, but there is an enforcement issue on one side that is hindering or hampering the transaction across the board? So I don't know if you have any suggestions in line with something along those lines, a multi-jurisdictional approach that can help.
Yeah, sure.
Gap these up.
And that's a good question. I was just worried that you were going to disclose me for the fraud that I am, but you have not. So I think the answer to that question really is that you need to advise the creators of these technologies and the implementers of these technologies, be it by an NFT or Bitcoins, to have a very careful understanding of the choice of law and jurisdictional clauses that they embed into these technologies or they apply. So you need to look for favorable jurisdictions. And you've already seen that London, England, UK has a very progressive framework for these digital assets. So that's one thing. And the other layer of complexity that you didn't mention is half the time, the users are anonymous. So you don't even know who the users are. So if you have a dispute with a user, usually you don't even know the identity of that counterparty. And the rules of arbitration for digital enforcement include a requirement that if there's a dispute, the parties must then disclose their identities at the very least to the arbitrator to allow for enforcement to happen. So it's a growing space. There are a few things that can be done, but because these technologies are not fully understood, there is no comprehensive solution to all these issues that arise because of the immutability, the anonymous nature, the intangible nature of these technologies. And thank you, ladies and gentlemen. I think my time is up. I can see the moderator shadowing me. Very grateful, thanks.
Thank you so much. She has educated many of us on this difficult topic, new trends. May I also remind people who have maybe not dashed out for tea or coffee to do so, but we're continuing with the eighth session. And the eighth session is themed on intra-Africa investment treaties and arbitration. And our moderator is Clemla, for sure. Avoka Obaho de Paris, African Arab France. I've tried. Welcome. Thank you.
Good morning, everyone. I'm sorry that you will have to wait before the next break. I will invite my panelists to join me right now. So Elodie Dulac, Dr. Kariekou Muga, and Paul-Jean Le Canu. And I think I would probably sit with you. So I'm very happy to moderate this session, and thank you again to the organizers for having invited me today, and thank you in particular to Agnes, Leyu, and Elodie for the great event that we are all living together. So this 8th session that I'm pleased to moderate focuses on intra-Africa investment treaties and arbitration. And the way we will discuss this theme, we have divided into 3 sub-themes, if you wish, sub-questions that each of the panelists will address through mainly questions and answers. And obviously, you will be very much welcome to ask questions to our panelists. So the first subtopics will deal with intra-African bilateral investment treaties and multilateral investment treaties and intra-Africa investment treaty disputes, the landscape and why so few compared to others. Then we will move to another issue, which is BITs and environmental, social, and governance in Africa. And then we'll close with the developments in exit reform and the impact on Africa. So starting with the first subtopic, and I will introduce my panelists, of course, in a short while before they start speaking. Well, it's interesting to look at the status of intra-African BITs. And as we know, some of those BITs have been signed, concluded back in the 80s and 90s, and still are waiting for ratification. And we'll see what's the landscape and what's the situation here. But some reasons of this situation of non-ratification of many of the BITs. Well, sometimes the political agenda is prioritized over economic diplomacy. That has been probably a trend we have seen. Also, another reason is the relatively weak level of foreign direct investment between African states, which would have the effect of desensitize the ratification processes. Also, and that has been touched upon in the previous panel in session 7, the existence of several Africa regional blocs, which also attract attention of governments and head of states rather than the ratification of those bilateral instruments. And maybe last point I will, and this is an issue we'll probably discuss with the panelists. Obviously, the entry into force of the African Continental Free Trade Area, which was signed, as you all know, in 2019, and which entered into force in May 2019. So this is another sort of area where states have put a lot of efforts and diplomatic time, perhaps at the expense of BITs. So now moving to the topic, and I will start first with you, Elodie. So Elodie, as you all know, is a partner in King & Spalding International Arbitration practice in Singapore. She's based and mainly focused on Asia, with a particular experience in Asia-Africa disputes, with seats of arbitration in either continents. Elodie has a very strong expertise in energy, mining, and joint ventures, joint venture and shareholders disputes, as well as disputes involving states and state-owned entities. And LD is also an arbitrator in the SIAC, in the HKAIC, and among others, and last but not least, in the KIAC in Kigali. So now I will turn to you, Elodie, with a first question, maybe starting if you could please give us an overview of the investment treaty coverage intra-Africa.
Yes, so I'll give an overview. I won't go country by country. But as Clément pointed out, what is striking when looking at the BIT coverage in Africa, and for intra-Africa BIT specifically, is there are few of them, and there are even fewer in force. So when I did the math, I found 180 intra-Africa BIT signed, out of which only 48 are in force, which is a really low number if you compare it to other regions. For instance, if you take Asia, Asia has 367 intra-Asia investment treaties in force. And that's without counting a number of multilateral investment treaties also in force in Asia. So you're looking at a really small pool of investment treaties in force. And Rwanda is not an exception. So I looked at it, I found 14 Rwandan BIT signed, out of which 4 are in force. And out of the 4, there isn't a single intra-Africa BITs. The 4 are with the US, Belgium, Luxembourg, Germany, and Korea. And to take on the other side of the continent, another example, Ghana, 27 BITs signed, 9 in force, out of which only 1 is intra-Africa with Burkina Faso. And that's, look at a number of countries, that's kind of like the theme is like not a large number of BIT signed and a small proportion in force, and an even smaller proportion of intra-BITs in force. So when trying to find explanations and comparing the BITs in force, which was basically essentially with North countries, I mean, historically, the FDI has come from the North countries, which have like had the incentive to push for BITs. There hasn't been the same incentive and the same volume of FDI intra-Africa. And it seems, when looking at some like patterns, it seems signing BITs have been used more as a policy statement by a number of African states without the need to move into ratification. So for instance, to take a couple of illustrations, in 2011, Francophone African countries signed 25 BITs among themselves in a single year, and citing the need to foster economic cooperation. To this day, out of the 25, only 3 have entered into force. Another example, Egypt, which is the country on the continent with the largest number of BITs. In 1998, in 1 year, Egypt signed 10 BITs with African states, out of which, to this day, only 1 is in force, with Mali. And what you see as well is when these countries sign intra-Africa BITs, do not ratify them more often than not. But during the same period, they do ratify BITs with non-African countries. So it's not a policy of like some countries have done, like we don't sign any, we don't ratify any further BITs, we put the brakes on BITs. No, these countries are still ratifying BITs, just not the intra-Africa ones. So that's kind of the landscape, which is quite unusual when you compare it to other regions.
Yeah, that's interesting that you made this comparison with also what was the behavior at the same times with external, I mean, non-African states. I mean, that's kind of a dear conclusion that there is a will or a lack of will on intra-Africa BIT's ratification effort. So then next question would be, are the intra-African multilateral insurance be the way forward?
So yeah, it's good you speak of the way forward, because there isn't any practical one. I mean, Jonathan mentioned SADC earlier, but there isn't any in force. It seems like the focus is shifting, especially to the AFCFTA investment protocol as kind of the way forward. A draft has been leaked last November. It's not me making it up, it's called Zero Draft. So it's really what the ultimate instrument will be is a question mark, but that gives an idea of the direction taken. And the direction taken is not really surprising because it's kind of in the line of newer investment treaties like the Nigeria-Morocco investment treaty, BIT, which is not in force, but which really puts sustainable development at the forefront and balancing the rights of the investor and the host state, the rights and obligations. One interesting feature of this draft protocol, investment protocol, the AFCFTA, is that it provides for the termination of the BITs between the states parties upon entry into force, including the survival clause. So this would seem, because BITs usually have quite a survival sunset clause, which means even when they are terminated, investors which are made before termination are still covered for like 10, 20 years. So it seems here the idea would be once the investment protocol enters in force, all the BITs are terminated, and including the sunset clause, which is pretty drastic. And then the emphasis in it in terms of substance is on preserving the right of the host state to regulate, because I think that has been one of the controversial aspect of investment treaty arbitration, the waves of cases arising out of changes in legislation, regulation. So there are a number of provisions with strong language to preserve a right of the host state to regulate. There is an openly stated goal of balancing the rights and obligations of the investor and state parties. In terms of substantive protection, it really scales back from investment treaties. There is no fair and equitable treatment, only denial of justice, which is a very high threshold. And black and white written that the denial of justice provision cannot be interpreted as equivalent to fair and equitable treatment. And that's a reaction to fair and equitable treatment being the clause most used successfully by investors to challenge state measures, including regulations and new laws. And then there are provisions which from the investor perspective would also be concerning about compensation, providing that, so it wouldn't be fair market value necessarily. It provides for basically also an equitable balance between the public interest and the interest of the investor affected. So there is some uncertainty of what the ultimate compensation would be for expropriation and for breaches of the treatment provisions. And then there is a whole chapter on investor obligations. So it's human rights, labor standards, environment, anti-corruption. So that's also very new, and with a whole chapter dedicated to the investors' obligations. And when it comes to, so there is an annex on investor-state arbitration in it, which, I mean, an interesting feature of it, because we are talking about having more arbitration seated in Africa with African practitioners. The draft treaty provides as one of the arbitration options arbitration under any arbitration rules adopted by African institutions or dispute resolution centers. And that's actually not to the fact that if you want to have investment treaty arbitrations on the continent, you need to provide for it in the treaties. Parties are very likely to agree to it later on, so it needs to be provided for, and that's done here. One of the options, it's not the only option. So we'll see. I mean, obviously, it's a treaty which kind of goes in the line also of the, it's been mentioned, the SADC amended investment protocol, the newer BITs like the Nigeria, Morocco one, a big emphasis on sustainable development and obligations on the part of investors under the treaty.
Thank you, Elodie. So with this landscape and this shift that we have all witnessing with the protocol, but as you rightly said, the protocol was actually the latest stage or step that we have seen on the continent in other jurisdictions, South Africa being one of them. So then what are the options for an African investor? What would be the protection that he could he or she or that investor could seek?
Yes, so I think given how the low number of investment treaties available, if an investor is has in mind having in place investment treaty protection, because it's going to be a large investment in the energy sector, mining, large infrastructure project, it needs to be a bit purposeful about it, which means nationality planning, treaty structuring, treaty shopping, to use a more pejorative term, which means structuring the investment or restructuring the investment to ensure it falls within the scope of an investment treaty. And how do you do that? You look at the investment treaties available, like signed by the host state of the investment, and you find one which is favorable, also which is favorable for tax purposes, because this goes as well with tax planning. And then you incorporate a special purpose vehicle in that country. So you channel your investment, that's done notably through Mauritius, to ensure you fall within a treaty. Only two limits to that exercise: if the treaty expressly precludes it, by requiring notably like real business activities, which a shell company wouldn't fulfill. If the treaty doesn't have this type of language, it's permitted. Second limitation, the timing. If the structuring is done when the dispute is foreseeable, tribunal have considered it an abuse of process and have dismissed the cases as inadmissible. So the structuring, basically the lesson is that the structuring has to be done when making the investment or early on. When the dispute is likely, it's probably too late to do this.
Thank you, Elodie. So we'll now move to our second panel, a second subtopic, which is BITs and environmental, social, and governance in Africa. So first, before giving the floor to Dr. Kariuki Myuga, a few words to sort of set the scene before we jump into that topic. So environmental, social, and corporate governance, as you all probably know, is currently defined as the approach to evaluating and the extent to which a corporation works on behalf of social goals that go beyond the role of a corporation to maximize profits on behalf of its shareholders. Those goals typically encompass environmental goals, as well as a set of goals having to do with supporting social movements and communities, and also goals of diversity, equity, and inclusion. In less than 20 years, the ESG movement has grown from, I would say, a corporate social responsibility initiative launched by the UN into a global phenomenon that no multinational corporations, as well as states, can ignore. And we know that for decades, those concerns, the ESG concerns, were not really taken into account in BITs as well as in arbitral awards. But things are changing, and in particular in Africa. So let's see how ESG concerns are playing out with BIT. And I will now ask Dr. Kariuki Myuga to do his presentation on that topic. Dr. Kariuki Myuga is a law scholar, environmental consultant mediator, and a fellow of Chartered Institute of Arbitrators, Kenya chapter. He's an holder of a PhD in law from the University of Nairobi, with a vast experience in both international and national commercial arbitration and mediation. advocate of the High Court of Kenya for over 26 years, standing and practicing at Kariuki Myuga and Co. Advocates, a firm that specializes in environmental law and natural resources. I think he's just the perfect person to talk about the ECG matters. So Dr. Kariuki Myuga, the floor is yours. We'll ask maybe if...
how many minutes do I have? I know it's not 3 hours. It is 10 minutes, right?
Yeah.
And the slide is running.
Is it on? Yes.
Honorable judges, fellow arbitrators, I am going to spend a few minutes reflecting on this topic on bilateral investment treaties and ESG in Africa. But before I do so, there was one group of people who were not introduced this morning. I'm in a government delegation of the National Environment Tribunal. All of them are here. If they could stand up, we recognize them. There is Mohamed Balala, Christine Kipsang, Bahati Mwamuye, they could stand up, Waithaka Garoya, and Belinda Okello, and myself. I sit in the tribunal. And the reason they're here is because the Environment Management and Coordination Act in Kenya was amended to reflect the position that in every dispute that you decide, including all the disputes in net, we must take into account sustainable development. And we must give orders, even if they've not been asked for. Even if it's sua motu, we must give orders that promote sustainable development. So they heard I was coming here, and they followed me. And they promised to buy lunch. I hope they can keep their word. We also have in the house Duncan Bagshaw. Him and I have been going around Africa and other places talking about ESG. And people ask us, what is it? So let me begin there. ESG is environment and social governance. It doesn't look like very good English. Environment and social governance issues, if you wish. A friend of mine has been communicating with me about ESGs. And finally, he asked me, what are they? Took me to a corner, what are they? We've been running a series, it's online, for the last 6 weeks on ESGs. So there's a very detailed account on what ESGs are, what impact they have, and what is the place of ESG in bilateral investment treaties, BITs. Don't be like me who went to a class where the professor was talking about BITs. For about 3 months, we didn't understand what that was. He didn't bother to define it. He thought we knew what BITs were. But they have found a place now, a central place in investments. The investment law regime has become a regime that recognizes ESG. It is part of the international investment law regime. So that if you are doing a contract, and I saw a contract the other day, an extractives contract, there was a clause just before the dispute resolution clause on environment, social, and governance. And what's that? Basically, they were saying this red carpet, or whatever color it is in a boardroom, must meet the green carpet. So that greening the environment and talking about the environment is part of what the corporation does. And that is a growing debate. And we are moving then from corporate social responsibility in a general sense to something that is enforceable. Mohammed and I were discussing last night, and he asked me, this ESG thing, is it going to be part of the law? I didn't answer you. It is going to be, because if you look at South Africa, they have it in their investment code. In Kenya, the Nairobi Stock Exchange, we have it already. There's a whole code going up to over 150 pages saying this is what you must do if you are an investor. And the main aim is to incorporate environmental, social, and governance issues. Clement has already told you what the environmental ones would be. The social ones are human rights. How are you trading? It's no longer relevant to say we made so many $1 million. We want to know, did you observe human rights? Did you degrade the environment? And how did you govern both your company and the environment? We want to know, what is your relationship with environmental governance? And the BITs of old did not really care about that. The emphasis was on investment. And the African countries were looking for investments and more investment. But with the debate on sustainable development goals from 2016 onwards, the focus has been, what is your footprint on the environment? We live in this space called the environment. There is climate change. What can corporations do as a matter of voluntary compliance, as a matter of law, to take care of the environment? And you begin to see that debate going very formal. You know about ISO 14,000. ISO 14,000 is a standard, and you're able to tell the whole world, we are ISO certified. We take care of the environment, buy our goods because they are environmentally friendly. It becomes part of that debate. ESG seeks to promote and achieve socially responsible investments, and the BIT that are coming up, the new ones, have it. They don't ignore it. It cannot be ignored. There is also an emphasis on sustainable and ethical investments under BITs. And the aim here is to shape the economic behavior of multinational corporations under BIT. Yesterday, the Honorable Attorney General, who is here, mentioned the case of Save Lamu, which was decided by the National Environment Tribunal. And despite the fact that there was a contract between that company and government, the case turned on environmental concerns of the residents, and the license was cancelled. And I don't think it's been reinstated. There's also another case, the Kotek mining case. We are doing well because the two people who argued the Kotek mining case are in this room. Karori Kamau, the Honorable Attorney General, Professor Gedhu Muigai. I get very happy when people call me Muigai. I hide behind your name. But they argued that if a company does not comply with national environmental law, it will not be protected. Very novel argument. And it prevailed. And under Professor Muigai, we began to see Africa winning its case in ICSID, the International Center for the Settlement of Investment Disputes. So, and it's an argument that is environmental, completely strange to the contract and to the BIT that is relevant. So we are talking about sustainable development. You've heard about the concerns under BITs in Africa. I did hear South Africa is walking out, but that was amended. It's waiting for them to expire. So that non-compliance with domestic laws is a problem, and a big one. Human rights are a big issue, and pure bad governance by the multinational corporations. Do I have a solution? Yes, we must incorporate ESG as an essential component of BITs. We must go on promoting sustainable and socially responsible investments as a matter of law, not choice. National laws must be complied with. We had BITs that were to the effect that if you change your national laws to their disadvantage, you're in breach. That must go. We must protect the environment. We live here. Human rights must be protected across the world. And good governance is something we must go by. Sustainable development from 2016 is a concern for the whole world. So there is also another suggestion I had recently, that we need well-negotiated EPAs, economic partnership agreements, so that we negotiate and put into that agreement an economic relationship, a mutually beneficial economic relationship between the host country and the other countries. We must guard against climate change. We must form global partnerships in accordance with the goal number 17 of the Sustainable Development Goals. We must achieve sustainable goals and sustainable development itself. So in conclusion, I say that resetting for a new age of international arbitration is possible, and we are part of it. Thank you.
Thank you very much for the very clear presentation. If I may, we can have a follow-up question for you. Then you have presented, I would say, both what are the sort of the current shortcomings and what would be the potential measures. Then if we get into a bit the details, what kind of measure can be adopted to ensure that the ESG concerns and goals are actually addressed in Africa?
I am for what is called positive law. Instead of talking about it, let us write it into law. Law might not be a very effective tool of social engineering, but it does work. If we could just move away from begging companies to give us the crumbs, whatever they have left after exploiting the environment, and actually make it as a matter of law to take care of the environment in several ways. We could force them, for example, to do what is called environmental economics. Show us how much you extracted from the air. Show us your environmental management plans as a matter of law. So it's a question of putting in regulations across all countries that address ESG as a matter of not just voluntary compliance, but mandatory compliance. And if we move that direction, we may get somewhere in the long run. But I don't have the answer about what will happen. But let's begin with awareness. Then we move on to law, codifying it, and then we see where we can go. I've also mentioned about the renegotiation into economic partnership agreements rather than just BITs that are handed on to the countries. So you negotiate and put in the clauses about communities, about human rights, about how much are you getting from that investment. I was telling Professor last night that in future, communities might want to ask, what is it that we can get in terms of a percentage if we are to participate in this project? It's not just a meeting. So there is hope, but there's a lot of work to do. Thank you.
And maybe following that remark, you said that regulation would be obviously the key point to regulate and adopt actually a scheme to protect those concerns. Then there's a question of harmonization at the continent level, because obviously the risk is the social and environmental dumping that can be also attractive for some regions. Then the question I would have is, what is the best instrument to achieve this regulation and to take your words, to be mandatory? I mean,
we already have, the law doesn't just prescribe generally. We have tools that can be used. One of them is environmental impact assessments. And these can be used. The downside with this is that in a lot of legislations that I've seen, the proponent of the project is the one who carries out the environmental impact assessment. But there's also strategic environmental impact assessment, where we are looking at policies, plans, and programs by government and all the stakeholders well in advance. So we're asking ourselves, is this project going to help to harm the environment 5 years down the line? And it's not the proponent who is asking, it is everybody. It is the scientists, because it is not lawyers who will save the world. Scientists have a role to play. So we have those tools, and we have many, many other tools for environmental governance, including public participation, but real public participation that can be built into the law. In the Kenyan context, we already have it in the Constitution, Article 69, Article 42, and Article 70 of the Kenyan Constitution. But we can move forward across Africa to ensure that this is done across the board. And we have tools of the ones I have talked about, and other tools like environmental monitoring over time and space. So you get scientific data about climate change, scientific data about biodiversity degradation, and you also have biodiversity impact assessments. That's quite deep. If you build that into the law, it will be done. And we can protect the environment in a practical way, and there'll be a way of checking empirically if we have done so.
Thank you. Thank you, Dr. Kariuki Muga. Yeah, and I fully agree. When you have set the regime, then at the dispute stage, later on down the road, arbitral tribunals will actually implement those elements, those obligations upon investors. And that's, I guess, the practical way that we may see a difference. So thanks again. So having discussed, I will now move to our third and last subtopic before opening questions to the floor. Having discussed the landscape of BITs and MITs, having looked at the issue of ECG, we'll now move to the more specific developments we have seen regarding the ICSID reform or arbitration rules reform and its impact on Africa. As you are all aware, in 14 days, actually in two weeks' time, the 2022 version of the ICSID arbitration rules will enter into force. And we have Paul-Jean Lecanu with us today, who will discuss the latest development on that. Paul-Jean is a team leader, legal counsel on one of the management teams at ICSID Secretariat. He joined ICSID in November 2010. And Paul-Jean has a vast experience in handling disputes, investment disputes, in particular in the African continent. He's also, and prior to joining ICSID, Paul-Jean has worked at the law firm Sherman Sterling in Paris, as well as in the PCA in The Hague. So Paul-Jean, I think you have also slides. So if we can have Paul-Jean's slides on.
Yeah. I understand that someone will be kind enough to help me go through the slides. Very grateful for that.
Maybe I can ask you first question to sort of follow the presentation. Can you put things into a context and give us an idea of African participation in the ICSID proceedings, first of all?
Yes. No, I think to assess the impact of the 2022 new rules, new ICSID rules, it's helpful to contextualize a little bit and to see what's been the place of and the role of especially African states within the ICSID system. On the next slide, I've put a bit of information on that. As some of you may be aware, African states have been important participants in the ICSID dispute resolution system right from the beginning. Actually, they were particularly active in the negotiations of the convention. 15 of the 20 necessary ratifications were provided by African state as well. And then because there were quite a few African member states, they were involved in some of the foundational cases in ICSID jurisprudence. So many of the firsts happened in cases involving African states. And in addition to those firsts, which you could consider as innovations, African states have shown that they were prepared also to try new things. We've seen that recently in the field of transparency. Jimmy, I don't know if he's still in the room, but was talking about the convention on transparency in investment arbitration, and the first ICSID case in which those were applied involved the state of Guinea. Now, today we have a significant African membership, 46 states, so close to 30% of the 157 member states. And that means also that they have 30% of the vote on the Administrative Council. That's the governing body of ICSID, and I'm mentioning that because that's the body that decide whether new rules should be adopted. If we look at the cases now on the next slide, you'll see, well, you have a graph here that shows you the evolution, the growth of the number of cases throughout ICSID's history. At the end of last year, there had been 869 cases registered under the ICSID Convention and the additional facility. And 22% of those cases were cases involving African states. Elodie talked a little bit about, quite a bit about intra-African arbitration. If you look at the ICSID caseload, about 50 cases are intra-African cases. And I would put an asterisk to that because these cases also include cases involving locally incorporated companies, which in turn may be controlled by foreign investors, so not necessarily African investors. But there have been cases, intra-African cases, or also high-profile cases of African investors initiating proceedings against other states. We had Global Telecoms, for example, versus Canada. And we're seeing a regular influx of cases, still not particularly important, but cases, for example, coming from Mauritius. You were mentioning Mauritius earlier, and the first case we registered this year was a case between Mauritian claimants and Senegal. If we move on to the last slide, so I apologize. There's a lot. No, you could move back one step. Yes, thank you. There's quite a bit of information here, but it's quite helpful in the sense that it helps identifying the specificities of the African case. So when you look at all of the ICSID cases, the primary basis for jurisdiction are treaties, investment treaties. If you look at cases involving African states, you go down from 77% to 50% of the cases, and a rather significant share of cases, 36%, are based on contracts and 40% on investment laws. And then if you look at the intra-African cases, then 32% only of the cases are based on treaties. And that has probably to do with the fact that many of the treaties that Elodie talked about have been signed but have not entered into force. And so the bigger share of cases is based on contracts in intra-African cases. So that's a quick and broad picture of the.
Thank you, Paul-Jean. I find very interesting the statistics that actually regarding contracts, based on contracts or based on laws of the whole state, it's actually double than the sort of global average. That's very, very telling. So we have put in that sort of the context. So now let's discuss about the rules and the new rules. What are the objectives of those new rules, and above all, what could be the impact regarding the continent?
Yes. So if we could put up the slides again. So there are two things essentially that I wanted to mention about the new rules briefly and the objectives behind them.
That's the next slide.
Yes, sorry, following slide. The next one. First, just the overriding goal was really to modernize the process, modernize the rules, so that they stay fit for purpose now and in years to come. So that meant incorporating best practices and lessons that have been learned in case administration, whether involving African states or other states. And that also meant that the effort was also designed to respond to some of the concerns that have been expressed in the context in the discussion on reform on ISDS. And so the idea, the method was to first to place the emphasis both on participation and on transparency. And so we had multiple meetings with African states. We gave opportunities, and all of the member states. The public members of the public had opportunities to comment. We produced proposals with comments on those proposals, and everything was put on the ICSID website. So as to really achieve the broadest possible discussion in an open forum. Now, if we look at the ways in which we were hoping to achieve this modernization, there were essentially four objectives and structuring principles. The first one was to offer a broader range of dispute resolution methods for users, just to take into account the diversity of both of the types of disputes and participants in the system, and to give the appropriate tools to do that. And so just to give two examples, the new rules make what we call the additional facility more widely available. So the additional facility was designed after the ICSID convention, and it allowed an investor from a non-contracting state to be in a dispute with a contracting state, or the opposite, a non-contracting state with an investor from a contracting state. Now that's even wider, and you can have a state that is not a contracting state and an investor whose home state is not a contracting state. And it's also open to REIOs, so Regional Economic International Organizations, who are now free to participate. You may have seen that the European Union, for example, has been very active entering into investment treaties. And so that option is now open to all REIOs. And we've also proposed a new set of mediation rules. African states have been those who have been the most involved in conciliation cases at ICSID. There have been a few of these, but the most experienced states in that area are African states. And we've seen also in treaties, we've mentioned a few of them, but express references to mediation as an additional tool to resolve disputes. So that's the first point. The rules also try to achieve greater efficiency while at the same time maintaining a procedural balance between the disputing parties. Elodie was mentioning that this was the balance was a concern and a priority for African states in their new treaties. That's also been at the center of the design of the ICSID convention, which allows both states and investors to initiate claims or to file counterclaims. And so the new proposals, the new rules, are also designed to combine efficiency and and balance. So, for example, there are new rules about coordination and consolidation, based on the idea that you should ensure that like cases are ruled upon in a like manner. There's also a rule on security for costs, which weighs the benefits of having access to the ICSID system, while at the same time making sure that a party will honor a cost award that's rendered against it. Finally, two additional things. The amendments try to strengthen provisions on the avoidance of conflict. in several ways, including one which was important to states, which was to provide specific provisions for third-party funding, and in particular, the identification of third-party funders for conflict check purposes. And finally, increasing transparency in proceedings. And here, really, what was targeted was the fact that in order to achieve a more stable and consistent legal framework in investment arbitration, decisions, orders, and awards should be published. So that's what the rules go after, and that's in a nutshell.
Thank you, Jean.
That's a lot of information, but
those really structuring principles as you label them, it's very clear. So maybe stepping back a little bit from exit word. And also taking into perspective what has been said by earlier, do you see that any trends that can be seen in recent interactions, and do those trends echoes with the principle we just mentioned? Can we join the dots here?
Yeah, I think there are definitely several intersection between the different treaty initiatives and what's been of the amendments, LOD's emphasis on balance. So I think that's very clear, and that's also even though it's just an initial draft. As you said, zero draft, so we don't necessarily know how this is going to evolve. But that's definitely something that you see right from the get-go. I think it's in the preamble, this necessity to achieve a better balance between the rights and obligations of investors and state. When you look at some of the treaties that the negotiators of the CFTA have said were a source of inspiration, we also see that. We see this desire to achieve balance. We see also a desire to have perhaps more detailed and circumscribed obligations for states, and also obligations for investors. Now, if you look at the CFTA itself, what's interesting in terms of if we focus on dispute resolution, on the procedural aspects, you see that there is an emphasis not just on dispute resolution, but also on dispute prevention. Mm-hmm. There's a clause, there's a provision addressing that. And that's interesting also because in the World Bank Group, that's something that the World Bank Group has worked on as well with, for example, the what's called the SIRM, the Systemic Investment Response Mechanism, which is designed to address disputes at a very early stage. When I looked at those provisions, I also saw that there was a provision on third-party funding, whose wording was very similar to what you find in the new exit rules. There's also a provision on transparency, which I think is worded in terms of encouraging perhaps the parties to adopt more transparency in proceedings, if I'm not mistaken. And also perhaps a point which I think has been addressed earlier, an emphasis on the benefits of capacity building and how arbitral institutions can be involved in that process.
Thank you. So definitely common trends that you have managed to identify. So I will now turn to the room if we have any questions. I think we have still some time. We try to keep for an hour. So please raise your hands and speak up. Yes, in the front row.
Okay.
Thank you very much. So my question is for Elodie. Elodie touched the point about the BITs inter-Africa, that they are signed, but do not get into force, or even sometimes there is the intention, but they don't advance. But what we can see is that outside the region, there is still being other BITs being signed. And I want to ask you, what are your views regarding the importance or the role of the Africa Continental Trade Agreement in this in the promotion of these intra-Africa BITs? Because if we want to have a continental trade agreement that works, the BITs within the continent needs to work as well. I want to know your views about that. Thank you.
Well, I mean, it looks like now the focus is shifting on the AFCFTA investment protocol, and most African countries haven't been very active in entering into BITs lately. So I would think, like, I mean, the investment treaties are for investment, so not for trade. But if you talk about the investment part, it seems really the path forward adopted, it appears to be the AFCFTA investment protocol. Which, according to the draft, again, it's just a draft, would terminate the BITs between the states parties. So that's also, like, I think would also be probably a chilling effect. Why enter into investment treaties, intra-African investment treaties now, if actually at the same time you're planning to terminate them? So, I mean, these are policy choices, but the two at this point are not really compatible. And it seems it will be, whatever the final draft, the final instrument is, if an agreement can be reached, it would be the AFCFTA. And it will be interesting to see whether the provision on the termination of the BITs is kept.
Other questions? Yes, here.
Hi, Tim. Jacko.
Oh, okay. So just after that will be for you. Sorry. Yes, Jacko.
So a question on the issue of intra-Africa BITs. Obviously, we have the AFCFTA investment protocol that has been leaked, the first draft, beginning of this year, and there's version 4. That's not yet been leaked, but there might not be fundamental changes. My question is more so we know, and we look, if we have a view in terms of history, and you look at the SADC model BIT, and we talk about ESG also. So the SADC model BIT is actually a very impressive model BIT that contains all the ESG principles that we talk about today: human rights, environmental protection, all of those principles. Then we look at the Morocco, Nigeria BIT, also a very prominent in terms of drafting, having all of these prominent principles in terms of environmental impact assessment, sustainability, and so on. Now the question is, and on the point of terminating the BIT, so that is in the draft protocol. So all intra-Africa BITs will be terminated once the investment protocol comes into effect, going through each country's constitutional processes. Now the problem I have is we have all these foreign BITs, not intra-Africa BITs, that have standards. It's old generation BITs, they don't incorporate these principles. So there will be a double standard where African investors, so because we're talking about intra-Africa trade and investment. So it's a South African investor going to Kenya, or a Kenyan investor going to Nigeria. There's a higher standard for you to comply with, as opposed to an investor coming from the US or the UK. And making an example of Europe. So Namibia has several BITs that are in force. They're busy with massive projects or future projects in terms of hydrogen. All of those BITs are 1994. They don't contain all of these rights. As we know, it's more rights of investors as opposed to any rights that states have. So it's just a concern in terms of how do we deal with those things, and that's a question to the panel, where we have creating double standards in respect of treaty protection intra-Africa, where African investors, which African investors should comply with, have higher standards to comply with, as opposed to foreign investors and the particular BITs which are still old generation? Should states renegotiate those treaties to ensure it's aligned to what's currently happening on the continent? Thank you.
Thank you, Jacquel. It's interesting because we are actually witnessing a similar situation in Europe, with a double standard being coming, with the fact that there's no anymore intra-EU BITs. They have been terminated or they are in course to be terminated, although non-EU investors will still benefit from the protection of the BITs, the extra EU BITs. So I turn to my panelists. I don't know who want to give a go on that. Yeah, Paul-Jean?
I can start. Maybe what we might, I think all the treaties that you mentioned, point in a particular direction, and it may be also that when you look at some of the more recent modal BITs of individual states, which they are prepared to use in their negotiations, including with third states, could also trigger a progressive reorientation of those treaties. Now, the question is how fast a phenomenon of alignment could take place. I think that's a bit difficult to determine, and at the same time very relevant to the question you raise.
Yeah, Dr. Kari Kimuga.
I would like to just add one or two things. Is that within Africa and elsewhere, we must look at conflict and conflict management and how to deal with it, because we are dealing with resources here, and whenever there are resources, conflicts are there. So what is it we can do about conflict management itself, conflict avoidance itself, the sustainability, peace, and quiet over time and space? And that conversation must go on. It must be a real conversation. There must be a real engagement with the people that we find there, especially in Africa. It's populated. And our own conceptions, especially about land, are very different. If you ask an African what is land, he will tell you this is the place of abode of my ancestors. How do we take care of the rights of the unborn people? And we had this discussion in Nigeria, Duncan Bagshaw, if you remember, that in Africa, we are asking very different questions. So it's not just a question of public participation. We are asking who is to take care of the lizard, the snake, the animals. And they have, so we are talking about formal law versus informal law. And formal law has just come in, but 100 years ago, Africa was clean and not degraded. 100 years, 100 laws later, it's degraded. So those conversations must be there. They must be real. We must engage one way or the other instead of just throwing platitudes into documents. Platitudes like public participation. You have two farmers, each one of them owns 1,000 acres. So the public in that space is only two people, but they are hurting lizards, they are hurting everyone, they are hurting biodiversity. Farmers do the same thing. So they're doing criminal things that are not criminal in law. So those real conversations must be there. We must look at the earth as a place we live in. We must have what is called ecocentric views, because they seem to have been swept under the carpet in favor of anthropocentric approaches. And that is the way I see it as part of the conversation. Thank you.
Thank you. Elodie, any comments? No? Regarding Jacquel's
nothing
points.
to add. I fully agree with Jean that there may be a dynamic on the continent, which is already a work in progress, but then for each state of the continent to take the initiative of, in addition to having third-party BITs, it remains to be seen whether there will be even a willingness to do that, and if so, or renegotiate, and if so, the timing. So I think it's not an immediate phenomenon.
I think we had a question, the gentleman, yes, here. And then lady in the back.
Thank you for what has been a brilliant session. I just wanted to ask Dr. Muigwa, against the background that there's a conversation between hard law and soft law when it comes to ESG and compliance, all right? And what we are seeing increasingly is that investors are really not putting their money or investing in companies that are not ESG compliant. And when you look at all the BITs, and you will also find that a lot of investors are to comply with local laws and regulations. And a lot of these local laws and regulations have laws or specific laws on, for instance, environmental impact assessment, which you mentioned, such that if there is a violation by an investor, I mean, there are already domestic routes to deal with such issues. And what you want from the companies are more transparency, more disclosure. So against this background, I'm wondering, when you advocated for hard law, you want to see hard law passed with respect to ESG. My question is, in what area and what sort of hard law do you want to see? Because I believe that local legislation already addresses a lot of these issues. And so the question really is more of soft laws that mandate compliance and disclosure and full transparency on the part of companies. Thank you.
Thank you very much. What I would like to see is a combination of tools applied in Africa, especially in the African context. I would like to see environmental ethics being applied. I would like to see ISO 14,000 and other standards applied on those companies. I would like to see market forces saying something about the environment. Nobody wants to look bad. And I did begin by saying at one point that law is a tool of social engineering, but it doesn't solve everything. I would like to see more science going into it. I would like to see the precautionary principle being applied more often. And I would like to see environmental bonds, companies saying we shall safeguard the environment, and if we don't, this is what we shall pay you. And I would like to see that in the law. And I would also like to see a promise by companies who give us an EMP, an environmental management plan that is comprehensive, that is acceptable, that has been agreed on by a lot of stakeholders. So I am thinking of a combination of things, because environmental governance deals with many things. There's a political part of it, economic, the social, the discussions, technological, environmental, and legal. Legal is just part of it. So I would like to see a push where we are using all the tools and see how far we go. And it will vary from context to context. Not all the countries are equal, and not all the countries are in the same. And I would also like to see formal law and informal law moving together towards environmental conservation in these debates. Thank you.
Thank you. And I think the lady, yeah.
Hello, I'm Dr. Nudit Piraja from Pakistan. So I have a comment followed by a question. The comment is, I have practiced in the area of investment arbitrations for about 20 years now. And I was very interested with the backlash in the past 10 years against investment arbitrations. So my SAD was based on whether or not investor-state arbitrations are an infringement of sovereignty. I spent about 5 years studying just that. So what I discovered essentially is, statistically, if you look at the cases before exit, the investors that benefited from bilateral investment treaties are the investors who are relatively small sized. The investors that we fear, the ones who are going to manipulate the environment, who are going to be violating the human rights, these are the investors who are powerful enough, who can even today negotiate exit clauses in the contracts. And as you were showing from the statistics, a good bulk of cases in exit that have arisen from Africa were through the contracts. So these corporations that you fear, they are still going to have contracts in which they are going to have exit clauses. So what you're really shutting out by getting rid of bilateral investment treaties would be these small investors who have benefited from the BITs predominantly. So my question is, Africa seems to be no exception. There is a trend of moving towards nationalized solutions. And I do know, having acted for states, investors, acting as an arbitrator at ICSID, that dispute resolution clauses do matter. It is something that investors do consider. The nationalized solutions that are being considered throughout the world at the moment, are they capable of providing the investors the comfort that is needed when investing in countries like Africa or Pakistan? Thank you.
Thank you. I don't know who want to answer that one or comments.
Yeah, no comment. One thing I didn't mention about the draft ACFTA protocol, which is also, goes to your point, is that in the definition of investment, there is a requirement that it be a substantial investment. And that goes, I say, one of the cases I worked on many years ago, like the debate was, it was MHS Malaysia. And the debate was whether there was a threshold in the ICSID Convention, whether a smaller investment could qualify. And the outcome was by the Adamant Committee. So yes, there is no threshold for the investment, but that threshold is introduced at least in the draft ACFTA, and would, as you say, probably, it depends how it would play out in practice, but presumably it is meant to exclude from the scope smaller or even mid-sized investments.
Maybe we have time for one last question. No? No? Okay, so we stop here. Thank you. Please join me to congratulate our panel.
Thank you very much, Clément, Jean, Paul, Elodie, and Dr. Kariuki. I can see the look in your faces. I know we are very, very behind time. I just going to suggest one thing. We can take the next presentation. It's going to only take about 15 minutes. Or if you're really hungry, we can go off for lunch. Can I see by show of hands? Do you want to have lunch now for just an hour? And great. So we have lunch for one hour, and then we come back for the afternoon session. And before we go, may I recognize the presence of our Attorney General. Thank you, Dr. Emmanuel, for coming back, and also the presence of all the dignitaries here. Please enjoy your lunch and be back by 2:30. Does that sound right? 2:30. We can continue networking. We still have a program ahead of us. We have networking break. We also have the gala dinner. So there is a lot of time for networking, but also engaging with great speakers. Well, I know there are lots of questions and we haven't had enough time to engage, but thank you.
happening for this? It's not serious. We should sit all of us. Take us the three of us. Solution of the world. Yeah. Please take the picture. No, I'm saying. No, yes. Okay. Am I supposed to remove this anymore?
Let me try and run those. They've gone. They've gone for lunch. Hey. We can take after lunch.
You know, we're waiting for you. For me.
Yeah. Ah, katutu kuatra kumis super beau.
That's the whole point.
Okay.
How's it going?
Hi, how are you?
Very well.
Yeah, going well?
Yes,
Yeah, enjoying?
Yes.
Perfect.
Tonight, what is the plan? I mean, for the coming back, is people going to be partying late or?
No, so we have booked calls who, so leaving here 7-ish and then leaving there, I think around 9:30.
Okay. All right.
Yeah.
So it's not.
Yeah. I mean, if you want to stay later, of course.
Yeah, but yeah.
And it's also going to be in a hotel, so
okay.
The hotel I'm sure can arrange taxis if people want
Yeah.
to stay.
Okay. Okay.
It's going to be. I think it's going to be a good night with PJ.
Yeah. That's right.
Yeah.
No, I'm thinking that I was thinking if people have to just like tomorrow, leaving like 4:30 in the morning and getting it. So I was thinking, is it going to be is there going to be transport coming back? But I think it's a hotel. I mean, if I want to skip out, then I can get up.
Yeah, and if you want to stay there,
yeah, that's right.
Yeah, it does give you the option. How are you going?
Zambia is quiet.
Somebody asked me for a mediator recommendation, and I had actually sent them through your name. And I remember I have your CV as well. So I forwarded that. So I don't know if they ever got in touch with you.
From Addis?
It was from it was from Kenya.
From Kenya.
Yeah.
Okay.
So they're looking for mediators, and then I guess they're looking for mediation trainer.
Yeah. You're done. You're not staying.
Are you off?
I thought you were staying tonight for.
No.
Well, she hasn't told me yet, so.
There's no need to say, but you have to pay.
You have to pay. I mean, I can't just like, there's no ceremony.
What kind of nonsense is that? It's very disrespectful.
Yeah. I'm going to be so sad. But no, so
Did I introduce you? Please, you introduced me. Thank you very much. This is we used to sit down. You can decide. Me, I bring my seat.
yeah.
Do we keep our badges or we are leaving the badges? Oh, yes. Photographs are important. Oh, thanks.
Did I take your place? No, you're fine. I think it's just, yes.
So we're running it again. this year, starting August, October, online, yeah.
Well, exactly.
I hear you. I know that was directed at me.
Done?
To them and then to also.
Again?
You have
Okay.
And I'm sure that the judicial partners we have for that next.
Thank you. Thank you very much.
We did one study.
Oh, yes, yes, yes.
I'm going to give the certificate. Bless it, yes. Yes. Do the blessing and everything. Yes, so that was. But then we said the commercial meeting, like people can do this commercially, like not as court annex, like the lawyers should be talking to their clients to consider this. I mean, like this is one of the tools, like why not do it? So we had our first contingent 10. We're going to train another 12 this year. So, but that's so, but like wanting to run for the court But you don't have that chart to do that. People will do the training and get the persona and never really That's a matter of
Okay.
let me just get the lady. The lady was here. I think maybe she's gone out to call people. She was here.
and some are in principle laid out in the core laws of the different host countries. But then what happens when it is found during a proceeding that there is a certain law that the investor breached? So these are some of the improprieties that we're looking at. And in coming to such decisions, the arbitration tribunal or the arbitrator dealing with this matter has to consider such principles or such rules when they come in. The third one, sorry, I just want to rush through this so I can keep the time. So there's also some awards. So there are strict adherences to what the host countries or the domestic laws of that country provide for. So violations of those principles of good faith by way of corruption, of fraud, deceitful conduct, misuse of the protection clauses that are there, depending on which treaties that you're using, then those can be used to negate or cause for claims to be made against the investor. The third one, please move the slides so we can run through this. Of course, the third one, the burden of proof. This is an evidentiary burden. We all know as legal practitioners the burden of proof, which I briefly hinted on. What is the burden of proof? What is the standard of proof that is required for one to make such claims against an investor that they can easily lose their claim in arbitration proceedings? So, you can see that the burden of proof most of the times will shift to the person who is alleging such misconduct. But again, when you shift from the burden, what is the standard? What is the standard that you need to ensure that this claim or this allegation that is being made, whether it's written or it has come out in evidence, that it is strictly looked at in a way that can be able to provide the remedies or what is being brought before the arbitration tribunal. Then lastly, the consequences. When you look at the consequences that arise from such allegations of misconduct, they are quite strict as well. You can move to the last one. I think I have like a minute left. The last slide, which talks about the consequences. So again, there is this award that was given in Metal Tech versus Uzbekistan, which says that the law is clear and rightly so, that in such a situation of investment tainted by corruption and the investor is deprived of protection and consequently, the host state avoids any potential liability. That does not mean, however, that the state has not participated in creating the situation that leads to the dismissal of the claims. Because of this participation, which is implicit, in the very nature of corruption, it appears fair that the parties share in the cost. So there's so many awards that have been given where claims have been brought, and the consequence of such claims is that you lose or the liability on the state stops when such claims of misconduct or fraud or allegation on the investor side. So by and large, I think dealing with such claims, it's of course a very sticky issue, but very alive. When you look at investments being done in Africa, we all know, or we've all seen these things play out. The World Duty Free Company Limited case, a president actually being named as someone who participated or nurtured this bribery to happen. The investor actually, the consequences are very dire because you can lose your claim, you can lose on any investor protection treaties or whatever it is that you would actually lean on to see that you are protected against state liabilities or state issues that arise from disputes. So I'll just end it there and hopefully take a few questions if they're there, so I can close out on my time. Yes, there's a question there. I hope we still have the time. Okay, thank you.
Good afternoon, everybody. Yes, my name is Mary. I'm very happy for the topic that you have just presented to us. I'm very interested in anything that touches on corruption. I'm wondering whether you've come, maybe this might not be relevant, but whether you could comment on the Bangalore principle of judicial conduct and should it apply to arbitrators?
Oh,
shall I repeat it?
No. I maybe can take another question. So, okay. So the Bangalore principle, judicial misconduct. Well, I think generally I would speak on maybe Uganda and I don't know what the other jurisdictions in terms of the arbitration law state, but we still in Uganda, unfortunately, arbitrators are not, they do not have the immunity against claims that can arise from, the whole process. However, generally, when you look at judicial misconduct in Uganda, there are avenues in which you can make claims against a judicial officer and his conduct during the process in which you have brought disputes before them. And again, like I said, it all comes down to the standard or the burden of proof, you who is alleging. And once it is found that there was any form of misconduct, then that is dealt with within our judiciary system. In terms of arbitrators, yes, there've been claims against arbitrators, against tribunals for certain conduct. But again, sometimes it depends on the rules that you're using during your arbitration process, the governing laws that you're using. From Uganda's perspective, of course, there are those exceptional cases if it's allegations of bribes or of corruption. But if it's conduct that is in the usual proceedings or what is taken to be business as usual, then I think it's really one of those things that can really have a long haul to prove either way when it comes to arbitration, especially from Uganda's perspective. Yes, ma'am. There's a question there. Yeah.
My question relates to investment arbitrations that in some countries, investors invest in those countries because there are certain benefits that can be by paying bribes. And that is the very reason those investors are there. But is it really fair to leave the burden of corruption on either the investor or the state? Because at the time, both of them are participants and voluntary participants. So is it fair to make the investor bear the full burden or to make the state bear the full burden for that corruption?
I think my opinion is it's not fair. But when you look at the burden of proof or the standard, it's usually he who alleges, you know, he who is bringing in this allegation of claim that there was an act of corruption or there was an act of fraud, and sometimes, especially sometimes, you know, if it's out of the contractual agreement, maybe if it's the state or in the investor, sometimes, especially in Uganda, you have third parties or out of contract parties come in, communities or certain interest groups that will come and go straight for litigation and lay out all these issues, you know, and provide certain evidence that they have witnessed. But out of that, ideally, whether it's the investor or it's the state that, you know, has committed such an act, it is the burden of the other party that is alleging to prove. Is it fair? My opinion is maybe, maybe not, but depending on what you want to come out of from a claim.
Because the problem is at the time, both of them are participating. So should the states be left with the defense that, okay, we are very corrupt, so you cannot bring a claim against us. There was corruption and we were corrupt. Or the investor basically gets away with it saying the state was corrupt, so you cannot come after us. So leaving the burden on one or the other. And I think that is why where the arbitrators and investment arbitrations have moved is only to take away the benefit that has been acquired through corruption. I think that is the balance they are trying to create. So if the investor could not have got the contract without corruption, the investor will not be able to benefit from that corruption because they would not have been able to get the contract. But if it is something relatively minor, along the way, they have paid bribes, the tribunal would deprive them only of the benefit that was acquired through corruption.
Yeah, I think that's interesting because when you look at this, the World Duty Free Company Limited case, the conduct or the corruption that happened, it came in evidence, but it was never an issue for the claim. But at the end of the day, the tribunal used that as one of the issues to you know, for the investor to lose his claim against the Republic of Kenya. So again, I think this topic is very interesting because the burden here is being now placed on how you as an arbitrator or how you as a tribunal, you're going to look into this matter and use it. And I think the standard is being raised that if such issues come and they're brought before you, whether in evidence or allegation, are you ready to deep dive and look into these issues, despite of who benefited, but just because an impropriety act happened, what is the duty of the tribunal? What is the duty of you as an international arbitrator to dig into these issues? Time up, thank you. Thank you very much.
Hello, hello. Just one question before you go, if you don't mind.
My bosses are giving me a.
Oh, okay.
No, but it's okay. I think we can.
I shall abide.
Oh.
Yeah, just a short question, really. Are arbitrators not confined to the terms of their appointment and the adjudication of a dispute as presented before them? Because I would have thought that is what an arbitrator ought to do. Once you start veering away from your terms of appointment, your terms of reference, then it becomes a problem when the matter is taken on appeal, if there's an appeal, or on review.
Okay, yeah, yes. I think, again, like I said, it could be an like I said, sometimes it's an allegation that will come up for either the investor or the state to get out of the claim because they know it is an impropriety act. It was not meant to happen. Sometimes there is evidence that will be brought. So this is where the role of the arbitrator or the tribunal or whatever institution or rules that they're using will come in. Because when you look at the ICSID rules, you know, there is strict regard to such allegations when they come in, especially for state investor disputes. And then the standard of proof, if there's an allegation, do you go ahead and take that as part of the issues you resolve, or do you just ignore it and just go strictly by what has been brought before you as the arbitral issues? So again, I think it really depends, but I think the topic here was to look at this critically and ask ourselves, if you're faced with such a scenario, what do you do as a tribunal, as an arbitrator, whether or not it has been alleged or in the claim, or if it is coming out in evidence and it's right there before you. Yeah, thank you.
Hello, good afternoon, ladies and gentlemen. My name is Swale Kanyeki, and just a small correction that I'm named in the program Swale Kanyeki, a partner in a company called Mawala Advocates Tanzania. Just a point of correction that I am not a partner in that firm. My practice is in Kenya, Nairobi. And actually it states that I am a partner in Swale Mwangi and Company Advocates. That's actually the company that I work for or I'm a partner in. But having listened to the previous presenter, Asmahan, she told us a little bit about that company, Mawala and Company Mawala Advocates, and I think you know, I must say that I'm proud to be associated with it, given the great presentation that you've made. I was looking forward to seeing the other gentleman called Malima, but I think having seen you, I've seen Malima and seen more. My presentation is about international arbitration in Islamic finance, the opportunities and trends. And even as I was preparing for this presentation, and I realized there is little time, you cannot do justice to a paper like this in 15 minutes, but I'll try as much as possible to do what I can to reflect general ideas, and then maybe take a question or two which may elucidate or give further, throw some further light to the topic at hand. I have divided this into six slides. I want to go through them very quickly. The first slide, I'll try to give a background on Islamic finance and its growth. I'll also, in the second slide, try to talk about compare between Islamic finance and conventional finance or conventional banking. I will look at compliance problem and Sharia risks. And then after that, I'll try to look at the governing law factor in Islamic finance and disputes. And then I will finish this up with a conclusion or a way forward. So without much ado, maybe I should go straight into the background, setting the background for this. And I want to say that, When I was seated there during the proceedings, I had a lot about growth in international trade and investments. And I had a lot about, infrastructure development, especially in Uganda. And the National Oil Company looking for funding as far as the projects that it's handling are concerned. And I say to myself, well, look, it's true, there is a lot of growth in trade, a lot of growth in investments, a lot of growth in infrastructure development. And all these needs financing. And basically, when these projects need financing, then naturally there is an increase in the, in agreements or the drawing of agreements to take care of this growth in the investment. So lawyers are busy also. When there is a lot of these activities, lawyers get busy in drawing up the documents to make sure that they reflect the needs of their clients in as far as capturing what they have agreed upon is concerned. And of course, with the agreements growing, then there is also that potential of disputes also, piling up and growing up. And therefore, with the increase of, disputes arising, then parties, of course, have got to deal with the issue of, how to resolve those disputes. And as we know, there are two ways of doing it. Either by going the litigation way or going by, the ADR way. And, litigation has its own issues. And I'm in for, I must state that having listened to the Honorable Minister for Justice, who said that litigation and arbitration are not necessarily, things that act against each other. And according to the minister, and I agree, they are complementary to each other. But that differs from one country to another. In some countries, actually, if you talk about litigation, then basically, the parties really don't want to go that way of litigation. And their preferred choice of resolving their disputes is by way of, alternative dispute resolution. And of course, in alternative dispute resolution, we know that, there are many. I don't want to go through all that, but our concern in this conference is about arbitration. And, arbitration for me, of course, and for many arbitrators, is a process which is chosen because of mainly the flexibility that you have in arbitration. The flexibility to choose the arbitrators, to choose the law applicable, and all those other things that we know. And of course, there is also the question, and I'll talk a little bit more about the governing law or the governance or the substantive law that is applicable to these to Islamic finance agreements. A little bit more later in the slides, the other thing, of course, and we've sat here listening to issues of enforcement. People choose arbitration because of enforcement issues. You are better off dealing with countries, all these countries that are, or states that are signatories to the New York Convention, rather than dealing with individual courts in individual countries when you want to enforce the judgment. I will talk a little bit now about Islamic finance as compared to conventional finance or conventional banking. And according to Standard & Poor Global Islamic Finance Outlook for the year 2022, Islamic finance is a 2.2 trillion US dollar industry, and it will continue to grow. In fact, the projection is that it will continue to grow by about 10 to 12% this year. And therefore, when you're talking about Islamic finance, then you are talking about quite a chunk of financing that maybe many people, do not know about and do not know how to, access to the same. And maybe at this point also talk about what is it? What is Islamic finance? I'm talking about Islamic finance. And a simple definition for Islamic finance is a financial intermediation accomplished in a manner that is rooted in fundamental Islamic principle of what we call Sharia. Okay, so this intermediation is viewed actually as a partnership whereby the participants take risk and share the profits and losses. So maybe, a differentiation here between Islamic finance and, conventional banking, where, the banks only want to look at, the profits or rather the interest, if you want, and they don't want to look anything about the losses. So you make losses in your business, then that's your loss. We still want our money and we want the interest that is payable. So basically, that's a departure of what we know about conventional law. And Islamic finance is therefore an alternative to conventional banking because really it's based on Sharia, and Sharia really means that you want to facilitate social justice. You don't want to knock on somebody's door who has not been able to repay a loan or to repay the interest. Time is up. 5 minutes. Oh my God. Okay. So basically, I think I've mentioned that there is that axiom. Islamic products have got to be halal and not haram. Halal essentially just means permissible, and haram means that they're not permissible. Some products that are Islamic, include what we call murabaha, which is cost plus financing, and then there is mudaraba, and there is ijara. I don't want to go into all these. These are just terminologies, and maybe if we have time, we can explain a little bit of that. Now, the cornerstone, and I've moved now to slide number 3. I think you are ahead of me. The cornerstone of Sharia, of Islamic finance, is compliance with the Sharia. So that if there is no compliance of Sharia, then that is not Islamic finance. And the challenge that is posed in Islamic finance is basically it has got to comply with the Sharia, and it also has got to comply with conventional law, especially issues of dispute resolution. You find that, and I say that I'll talk a little bit about governing law. You find that people want a governing law that they are familiar with, a legal system that they are familiar with, and therefore they want to choose English law or the laws of England to apply on Islamic finance. And there are 2 cases that I want to mention here that will demonstrate how important it is to choose arbitration in the dispute resolution clause rather than choosing English law per se. 2 very familiar cases, and maybe we all know about them. There is Shamil Bank of Bahrain versus Beximico Pharmaceutical, where there was a murabaha. Remember, I spoke about murabaha. There was a murabaha financing. It's an Islamic finance product where the law, according to the dispute resolution clause, provided that subject to the principles of glorious Sharia, this agreement will be governed and construed in accordance with the laws of England. And when this matter was taken to court, the English court ruled that no, we are not going to apply Sharia because that is too general, and they gave a number of other and other reasons. Therefore, they said, no, we are not going to apply Sharia, and English law was applicable there. There is the second case actually demonstrates the importance of this arbitration. The parties, yes, chose English law as the governing law, but then they stated that dispute resolution will be by way of arbitration, and the wording was that this dispute shall be governed by the laws of England, except to the extent that it may conflict with Sharia, Islamic Sharia. And the judge who listened to that case gave effect to the application of Islamic Sharia because the parties had decided that yes, this dispute will be subject to English law, but it will go through arbitration and not through litigation as such. So that shows you that when you are drawing your agreements. And this has led actually many practitioners in Islamic finance to choose arbitration. In fact, concentrate more on arbitration rather than litigation, because according to those two cases, you can see that Islamic finance was given recognition, or rather Sharia was given recognition in arbitration more than it was given in litigation. I want to talk just a little bit about when we talk about Islamic or rather glorious Sharia or Islamic Sharia, what do we mean? There is one thing, an unfortunate thing, that there is the Sharia or Islamic Sharia is not codified. So when you're talking about Sharia, which Sharia are you talking about? It's not codified, as I say, and Sharia actually depends a lot on interpretations, at least for the Sunni Muslims, because there is Sunni and Shia. I don't want to go into that. But as far as the Sunni Muslims are concerned, and they're the majority, they go by interpretations of different Sharia edicts in the Quran and in the tradition of the Prophet, Hadith. These schools of thought are the ones that kind of, give interpretation. So each school has its own interpretation. And therefore, when you're talking about just Islamic law, then I'll finish in a minute. When you're talking about Islamic Sharia, then you have to be specific. And if you're not specific, even the other party that you're dealing with may not be very comfortable agreeing to very wide wording of Sharia without you specifying. And that's when that's where I come to, the standards that have been set by AOFI, or Accounting and Auditing Organization. This is an Islamic organization based in Bahrain that tries to set up standards. There is another one called IFSB, or Islamic Financial Services. They're doing a great work in terms of, laying down or putting down the standards, so that when you are even doing your dispute resolution, you specify which, Sharia you're talking about. If you don't do that, then basically it can be thrown out, or it can create disputes in the dispute that you're trying to resolve. Finally, the opportunity for lawyers is that according to that report, the report by ICC, there is this Islamic finance arbitration is untapped, really untapped. And therefore there is a lot of opportunity for you guys here to, tap this arbitration in Islamic finance. And the way to do it is, of course, to create a lot of awareness to the parties to the agreement, retraining of professionals, and investing more time in selecting and crafting arbitration clauses. Of course, I spoke about the standardization and integration of the Islamic finance industry, and I think I will stop at that because of the time. Thank you. Yes.
We'll just take one question because we have to move on to the next panel. So are there any questions on the Islamic finance presentation that we just heard? Quite elaborate. I'm sorry, there's a huge light, so I don't know if anybody's raising their hands.
Understood everything.
Yes, we understood everything. That's how great your presentation was. So a round of applause for our two presenters, please, ladies and gentlemen. Thank you very much. Thank you very much. Can you please take a picture, if I may, in the meantime? Yep, they'll take a picture. Yes, so as they do their panel picture, we have the SHE panel that's going to be coming right after this, which is, we only have 2 more sessions. So we have the SHE panel, and then we have an Oxford style debate to close it all off, which shall be on a very interesting topic related to arbitration in Africa. So let me kindly invite the moderator for the SHE panel, Elodie, who I'm sure all of you know already, so needs no introduction.
Everyone is running away from me. No, but you can
Oh, huh? Thank you. So yes, so now we have the SHE panel about like fostering female leader in international arbitration and probably beyond in Africa. So this will be a Chatham House rule discussion because we want it to be really a candid and open discussion with the panel and with the audience. We welcome your comments, sharing experience, advice. I'm going to introduce my panel. You know some of the panelists you've seen earlier today, but I'm going to start just to my right with Justice Mary Ongawa, who's a former judge in Kenya, who was a career magistrate and rising to the High Court in Kenya. And Mary is now an arbitrator and a fellow arbitrator with CIR. And then we have Itweva Nogueira, who you've heard earlier today, who's a partner with Dentals in Angola. And then Noala Lubano, who's a partner with Owaro Company Advocates in Nairobi. And then finally, Majida Garib, who's a regional manager with Al Garib Associate Advocates and Legal Consultants in the UAE. And Majida is based in Abu Dhabi, where she's a regional manager for her firm. So I'll start, I'll ask the first question, and whoever wants to jump in on it, and we hear your views. Could you let us know what you view as the greatest highlights or turning points in your career? There are probably many, but the ones you view as the key ones. Wants to start? Maybe Mary. You're picking on you. You're next to me.
Is this on?
Yes.
I'd like to take this opportunity to thank the organizers for having me being part of this panel and to participate in this conference. I've been very thrilled to be here, and I've recognized so many people from Kenya who appeared to me with me when I was on the bench, like Mr. Kanyiki, who's just off, who came off just now, and so many of you. I really appreciate you in a very incredible way. We haven't had time to talk, but I hope we will still find time to do that. The question before me is very exciting because my career has been really checkered with so many things, but the three things that have been a highlight in my past career The first one is in the first year of my being appointed as a magistrate, I influenced 10 women to come onto the bench. Basically, it was a time when Kenya, this is a long time ago, about 40 years ago, was saying that we don't want any more women. And the whole of the judiciary only had 2 women or 3 women magistrates. There were no judges or judges of Court of Appeal. So they decided to use me as a guinea pig. And for one whole year, I really worked hard. And as a result, the following year, 10 women were appointed onto the bench, and it has never stopped since then. As I moved on to become a judge of the High Court, the maximum judges then were only 50. Out of those 50, only 5 were women. I then, as the chair of the Kenya Women Judges Association, influenced another 18 women to come onto the bench. And then, of course, we had the new constitution. We had the new constitution, which required that we must have equal representation in all these aspects that are there. The second aspect is that of being a justice of the peace or magistrate visitor to prisons. For many years, when I first came onto the bench, they put me on the criminal bench. And I used to wonder, where do these people go to after I jail them? So I decided to go and find out. And I would visit, and I found out I had a clause known as the Justice of the Peace, where you are permitted to go into prison as a magistrate to see how the prisoners are. So I spent 8 years doing that 3 times a year with very little success, because you'd make recommendation and very little changes will come. You visit the prison and they bring out the clean blankets, the white uniforms, and the minute you go, of course, they fold them up and things go back to where they are. But I'm sure nowadays that things are much, much better. But through that influence, I met a lady in prison. And this particular lady asked me, I've been here for so long. Could you find out what's happening to my matter? I've been jailed. I've appealed. I said, okay. So I went back to the office and I asked them about her file. And they traced it to the secretary's drawer. And this secretary had put it in her drawer, locked the drawer, and forgot about it. So the visiting of the prison actually would bring out these little tiny things that are there that you needed to sort of highlight. The other aspect that I would say was a very good influence in my life was the appointments. Every 2 years, I would get a different appointment. So I became the first woman chairman of the Rent Restriction Tribunal. I also became the first secretary to inquire into the insurance industry, the advocates, a commissioner of the Advocates Complaints Commission, the first woman in that particular position. By being the first in this position, it actually means it opened up the door for other women to say, yes, if she can do it, we too can be able to do it. I think those are my highlights.
Thank you. Itueva? Yes.
Thank you, very inspiring. And well, I have to thank to show my gratitude to the organization to be in such an honorable panel, and the diversity of experience here, you know, and geography as well. It shows that we are, well, we still keep saying that we are so few, but if we can identify ourselves in different places and with different levels of experience, it really makes a difference. So 3 highlights in my career. I think my career is so childish that it's difficult for me to identify them. But for sure, it's one of them was when I went back to Angola because I studied outside of Angola in Portugal and started my career there, and didn't have any desire, although I was born in Angola, I'm Angolan, my family is Angolan, but it never came to mind because I grew up there when so little, there was so much parts of that society that It never came to my idea, go back to Angola to be a practitioner there. But, you know, in conversation with, I remember my father, he was the one that was, you know, he was very nationalist. And he was like, you need to come back. You need to come back. You need to come. You need to be part of this, the reconstruction, you know, and the work that is being done. You need to build, you need to give your contribution to the country. And he challenged me for quite a long time. He didn't convince me, but he managed to convince my husband. So I went back to Angola and then started practicing in Angola. And that was my turning point, you know. Sometimes we are looking so much outside of the continent, but the challenging work, you know, and I think the bright work is really on the continent. And that perception I could only have once I went back to Angola, you know. And that's why, you know, many law firms, many foreign law firms have substantial part of their work coming from the continent, you know, because of everything, because of the development, because of so many differences between the continent. You know, you have Francophone, Lusophone, you know, English speakers, and the civil law system. You have Islamic, you have civil law, you have Anglo-Saxon. So you have so much diversity in terms of knowledge and in terms of experience, in terms of things to do, that it really was worth going back. So that was one of my turning points. I don't think I have gone to the second or third, so I will pass the ball now.
Thank you. And, you know, compared to my colleagues' achievements, it's very hard for me to kind of explain that what I have done is an achievement. And I give this analogy of a man who says he trains people, professionals, on how to market themselves. And he says if there's John and Mary, and both of them have been involved in a very successful event, and the media came to interview John, and they asked John, so are you able to give a sound bite about the event? He'll say, you know, it took the great skill of my firm and my expertise and my team's expertise. And that's what he'll say. But if you ask Mary, she'll say, I had a great team with me. John helped a lot. He contributed a lot. The point I'm trying to make is that women find it very hard to speak about their achievements, and even harder to identify what those achievements are. And that is true for me. And so what I think my achievements are, if any, are basically my career path and my academic achievements. And so for me, the fact that from a pretty normal background, not privileged in any way, I was able to get a law degree from Nairobi University and then go on to get my advocates, pass my bar exam, and then get into the Tier 1 firms in Kenya. I started off at Hamilton, Harrison and Matthews, which is a Tier 1 firm, and then went on to Anjawala and Kana, which is another Tier 1 firm, and then ended up as a partner in Oraro and Company Advocates, which is a Tier 1 firm. And I ended up being a partner very young, at around 33, and then an equity partner at around 35. And at the same time, I helped manage the firm at that age. And for me, these seem to be very normal achievements for many of us seated in this room. But for me, this took a lot of hard work, you know, blood and tears to get to that level. And you know, I didn't actually recognize these are achievements until I started getting global recognitions in the directories. And I remember for me, maybe the best recognition that I got was African Arbitration, 50 most promising arbitrators in Africa.
Yeah.
And I think
yes, yes, we are both there.
So I think
yeah, congratulations to us.
So she was there as well. So that's probably one of my greatest achievements. But I think I always tell people the best recognition that I got, and it's something very flimsy, is I think Chambers once recognized me as good at whatever, insolvency, arbitration, and said, very witty. And I recognize that as a really great achievement because I don't consider myself funny or interesting. So for me to get that reputation globally was an extremely good achievement for me. And I know it sounds like a small thing, but for me, it was really important. So I don't want to say much more, but those are what I consider my achievements.
Very impressive. Majida?
First, I'd like to thank the organizers for inviting me and honoring me with by sitting here beside astonished females in their field. And I just wanted to say that I don't have much experience as the ladies here. I would say I don't have achievements yet, but I have highlights in my career. The first one that I would consider the most important one is working in opening the second branch of the firm, which opened before 4 years in Abu Dhabi. I worked on it from A to Z with minimum supervision from the partners, but by their guide, of course, they guided me through everything. And the second one was opening the third branch, which I can announce for the first time ever. We opened the third branch in Sana'a in Yemen, and we opened it this year. And I would say the last one would be that we have implemented a company-wide working from home policy before the pandemic. We started that in 2018, which resulted in a great increase in employee satisfaction and a big decrease in paid time leave, which was good for the company. Yeah. That's all.
So Noela, you mentioned it took a lot of tears to get where you are. So if each of you, and starting with you, could tell us a bit about the challenges you had to, I guess you overcame them, if you are where you are, and whether these challenges were due to the fact of being a woman or others.
Is that for me?
Noela, maybe,
No.
because you spoke about tears, so I'm starting with you.
Okay, so I think the climb in my career has always had some challenges. So if I look at the beginning of my career, I think a lot of the challenges that come about when you're young and starting is just being confident enough to know you're a good lawyer. And I think that's for all the young lawyers here, that is one of the biggest challenges. You keep asking yourself, am I a good lawyer? And that requires a lot of self-belief. So it took a lot of time for me to believe in myself and know, actually, you are a good lawyer. And the more you start believing it, the more you become it. So I'd say that is my first challenge. And then now later on at this stage of my life, I think my biggest challenge is balance. It's where to draw the lines. And I think this is true for many women with families and children. Where do you draw the line between the big brief that requires you to work 24 hours, 7 days a week, and going home and spending time with your family and actually sitting down and having a meal? So for me, that work-life balance, and they say you don't call it work-life balance, you call it life-work balance these days, is the biggest challenge. And I think I'll put it out there because it's a very candid conversation. I think there's debate as to whether women can have it all. Can you have a great career and a great family life and a great all that at once? And my personal experience has been you can have it all, but not all at the same time. I think you can have it all one after the other, but if you try, as I have tried to have it all at once, I find that I'm failing in some of them. So I think I've accepted now that the challenge is to try and have it all, but one at a time.
Okay. Of course, there is. I won't deny there is a lot of tears during all the process. In Angola, I started at a great law firm, then I changed because of this issue of life-work balance. I had my first child, and I was in love of what I was doing at work, but then I would leave her at 7 a.m. and then sometimes come back at 8. But because the traffic in Angola is so intense, it was just have a quick meal and go to bed. And I couldn't have time to, to play with her, to pay attention. And at some point that hit me, and then I decided, okay, this is a great law firm. I was very good there, with great prospects of growth. But then I decided, no, I will move, I will give a step back. From that step back, some things changed, and then I opened my own law firm, which, one thing led to another. I became a Scrivener scholar, and then went to London and left my family. So this that you are saying, it's very difficult. You cry all the time, but I found blessings in those cryings because it really alleviates a lot of stress. It takes off a lot of things, and you don't pile up that much. But sometimes, at some point, you have to find someone to talk with. You need to have a great support, a family support, your partner support, all of that needs to be in place. And of course, I will disagree a little bit with you that you can have it all, but not at the same time, just one after the other. I would say that you can have it all at the same time, but not with the intensity that it requires. You will be successful in a bit of it. And I started, or I learned to value those bits, step by step. I didn't know the importance of celebrating small achievements. I always had in mind the big achievements, and I would never celebrate. It was never enough, and until this day, a lot of people look at me and think, wow, how did you get to become a partner at Denton's? For me, it's not a big deal. It was just so much work and doing so many things around my career to get there, to create my plan where I wanted to be in 5, 10, or 15 years. And when it happened, I didn't realize that it happened because I didn't know how to celebrate. So this is one of the
efforts. And there's always a next step, I guess. It never ends.
No, never ends.
Do you think it's become easier now that you're a partner to have this balance than when you were younger associates and may not have the same flexibility with how you organize your time?
It's not easier. Especially because, when we were younger, we were all the time, how can I say, insecure. We were never, sure of what we were, what we knew, always doubting. But at this point, I have gone through that phase of so many doubts. I still have them. And I learned so much from my younger daughter. She's 6, turning 7. And she has mornings that she wakes up and she says, I'm the best. I'm amazing. I'm fantastic. I'm this and that. And so at the beginning, I was looking at her like, let me pull her down a little bit. I don't want you to be arrogant. But then I stopped and I said, no, I have to learn from her. I look at her and I said, she will never need to wait, for someday to have someone to tell her that, And I started to say, yes, you are. And I would repeat to myself, yes, you are amazing. Yes, you are fantastic. And I said to myself, I have to be like her. I don't have to wait for no one to tell us that, So it is difficult in the sense that now with the responsibility, when you are passing the work to, a junior or even a senior associate, but normally juniors, whenever they don't know what to do. When I was younger, I would go until the end, I will do my best. But the feeling that I have now is that they don't know, they just throw the ball and you deal with it because you are a partner. You should know, And sometimes it's last minute. So it's not easy at the end of the day.
Yeah, there seems to be a generation, I think I have younger people in my team would go to the gym on a filing day when the partners are in the office. I'm like, I don't have a work-life balance.
Exactly.
So I think they are like, I don't know, they seem to get it. Like,
yeah, but at least now you can choose, okay, on my birthday, I won't work. On my family's birthday, I won't do this or that, You do your own calendar and it's okay.
And Mary, if you can share with us some of the challenge the achievement culture, then how you overcame them to rise to the career you've had?
I'd like to start off by saying, I've always called myself the 3D judge. 3D means if the work is dangerous, if the work is difficult, if the work is dirty, send Mary. And I always would find myself in that kind of a situation where I would be taken to certain stations to deal with those 3D's issues. Recognizing my ability to combat corruption, I was made the judge in charge of one station called Mombasa, and there were also other stations where obviously the advocates went on strike on me. And this is because it was what was known as change management. There are 3 C's you have to deal with. You have to change people to stop doing what they have been doing and to follow the law. Then from there, they rebel. Then from there, they will conform. So I had those kind of challenges. And one thing that was so interesting at that particular station, an emissary was sent to me to ask, why was I not married? This too was the question sought on my interview, my very first interview when I was being interviewed to come on the bench. Why aren't you married? What will happen to prisoners who would need to have, would require you to hear their cases? And if you become expectant with child, for 9 months, the prisoners will have to wait for you to come back to hear their cases. So I told them I'm not going to get married for 10 years. And I kept my word, but after that, there was nobody left. So I'm still missed and I'm still here. But the concept is that I had an ability to get through to the advocates and even the staff by using my emissary, by using the male colleagues, and to try and get them there. I also want to tell you about another challenge I had. I was doing an election petition. I was allocated a case where the first judge heard the case and she was threatened. She stopped dealing with the case. The case was passed on to a second judge. He too was threatened. His life was threatened and he stopped doing the case. Then of course they called the 3D judge. They didn't tell me. So I got this case on my table and I started it and I said, I wonder why they stopped hearing this case, only to find out that it was a hot cake. So it was an election petition and my life too had been threatened. I finished the case within 4 months. And on top of that, I made sure to remain focused until the task was finished. Then the other one that I had a challenge on is the breakdown of the system on the rule of law. There were times when Kenya failed to produce law reporting. You know, we are a Commonwealth country, and a Commonwealth country relies on reported cases. There were times there were no reported cases at all. But I must say, I'm very happy today. We have got reported cases. I'm very happy that today that we are electronic. And if you deliver a decision today, tomorrow it will be on the shelf, not the way it was during those days. And I used to visit far off magistrates' courts when I was a judge. If they posted me to a place, I wouldn't sit on my bench. I'd look around and see where are my magistrates who are working underneath me. And you go to a magistrate's court, there's not a single book on the shelf. So their decision would be common sense. We just use common sense. How would I turn that round? In one station, I held a golf tournament. We raised 70,000 shillings. I said, I'm going to use this 70,000 shillings to buy law books. But one set of the law of Kenya was 70,000 shillings. So I gave up. But nowadays, it's very good because everything is electronic. Those are just a few of my challenges.
Matilda?
I would say that I haven't had a challenge that I couldn't overcome with the help of the team. I have a very supportive team of lawyers, consultants, and I would attribute the big role would be to my country, because my country is relatively small, 50 years old, but they have many initiatives supporting women, especially the late president has directed the Federal Council to make Emirati women occupy around 50% of the whole council, which is quite great for a small country. And we don't have a salary gap between women and men, which is another bonus thing for us. So that's pretty much it. No challenge for me.
And so what advice would you give to women who want to try and enter the profession, whether arbitration, the judiciary, and then if they do, not to give up along the way?
I would say listen more and talk less, because I think by listening to other people and taking advices as well, you would know which advice suits you more than the other, because not all the advices suit your situation or yourself. And I would say be assertive, if not aggressive. Men would consider us being aggressive, but we're assertive. I'm 100% sure of that. And embrace challenge and change. Everything is changing constantly. Law reforms and many other things.
Nora, what about you?
So some of my proposals would be similar to hers, but maybe the most important one for me is be adaptable to change. I think it's extremely important as a woman in the legal profession to look ahead, see where emerging issues are growing and try and adapt to that change. And also read up. If you have time, as much as possible, increase your knowledge bank. Try and learn more. Let the law experience be a learning experience for you. Identify mentors if you can. My career progression has been, it's mentors that held my hand, and surprisingly, all of them men. Yeah, they were not women. In Hamilton, Harrison, and Matthews, Kirago Kimani taught me how to be a good lawyer. In Anjawala and Kana, I had Karim Anjawala, who taught me how to be a business lawyer. And then in Oraro and Company, I have Mr. Oraro, who's taught me just about building relationships with people. And that at the core of every business are the relationships that you build. So my last piece of advice is, do not underestimate the relationships that you build. Even in this conference, the relationships in this room, I look around and I know maybe a third of the people in this room, and I have relationships with them, all that have translated to benefit me in one way or another, not necessarily even commercially, but in very many ways. So I think as a young woman, as an old woman, as a middle-aged woman in the legal profession, these things hold true. Innovate, embrace knowledge, and build networks and look for mentors as far as possible. So I'd say that would be my advice.
Me? Well, I would say, following to them, invest in yourself the maximum that you can. Investment in knowledge is never too much, never. Sometimes you will feel like, oh, what else? Or someone will tell you, what else do you need to learn? You always need to learn by reading a book, by reading a case, an article. Being on social media is not just posting photos. There is a lot of good content on social media where you can learn, and from one thing go to the other. The other thing that I will say, the other advice would be listen to your body, listen to your mind. We don't pay enough attention, especially when we are under 40 or under 35. We think the world is ours. We have all the energy, and we do have. But if we don't take good care of our mind and of our bodies, we won't handle. So at this time of my life, for instance, when I'm feeling, when I'm struggling, when I'm more difficult to deal with, and I know myself, I know it's a matter of resting, simply resting sometimes. And resting is just finding time. I have a good one that is, I force my family every Sunday. I love to cook for them. And every Sunday after lunch, I force them to see a movie that I choose. Then I lay down in the sofa and I'm the first one to fall asleep. You know, that is my quality moments with them, you know. And I wake up in the middle of the movie and I start making a lot of questions and saying, all these movies are the same. You always see the same type of movies. And they just say, Mommy, you are the one that choose. But for me, that time is essential to have a very good week, a very strong week, and a very successful week.
Eric?
Yes, I'd like to just agree with all my three sisters. I mean, you just took the words out of my mouth, and I would actually totally agree with that. First and foremost, what I would like to say is today we have got the first woman Chief Justice in Kenya and the first woman, second woman, third woman Deputy Chief Justice, 2 women in our High Court, in our Supreme Court. I think that is really, really a wonderful achievement that has been done. And the possibility of that to happen is the Constitution of Kenya of 2010, where the people of Kenya really struggled with this constitution, and it gives equality to both men and women. We just don't say this is a woman's world. No, it is an equal world for both men and women. And as a result, from when I was on the bench, 50% of women were in the magistrate courts, but when you go up to the High Court, there were only 5 ladies, and then you go up to the Court of Appeal, which was then the highest court, there was no lady at all. But now, today, we have got 2-3 ladies on the Supreme Court, which is more than we've ever had in the history of Kenya. So I think the Constitution of Kenya is really, really one that gives an opportunity which the ladies and the men should take advantage of and make sure that they are there. I would like to just add in a very short way and to agree with my sisters here, education is very, very key. When I first was appointed High Court judge, I told the Chief Justice as we rode in the car from State House after being sworn, I said, oh, and now I'd like to go and do my master's. I've already got a scholarship. He said, what? You can never educate a judge. A judge never goes to the classroom. So we started what was known as a colloquium. So I started quietly educating myself. I did my master's program. Mr. Karaoke Mwiga was our class representative. Professor Mugai was our lecturer then. And it was, I had a burnout, I must say, because doing your court work and then quietly trying to do your master's degree, it was really very, very difficult. Then I became a fellow of the Chartered Institute of Arbitration, actually before I did my master's. And there were 20 of us who sat for the exam. Only 4 passed. Of those 4, 2 are ladies and 2 men. And I was one of the ladies who passed. But because I was on the bench, I was not allowed to practice arbitration. So I just put it in my pocket, forgot about it. And when I retired, there it was. I've got my fellow and I didn't need to work very, very hard. So I'd really, really say to all the women and the men here too, please, please, please continue on with your education, but beware of the burnout, which you can easily get. What can we do to help the men? Because nowadays everything is women-oriented, women-oriented. I would say we need to involve men. And I'd like to give you an example of one judge. It was during the post-election violence in Kenya. And he gave a report that was very, very good during that time. And how did he do it? It's because when I was on the bench, I was the chair of the Jurisprudence of Equality program ran by the International Association of Women Judges. Then when I became the woman head of Kenya on all the women judges, we set up this program where we were training men and women in the judiciary on human rights. At times I'll take this program to the advocates to run, because I think we're talking about matrix management, where it's not only us being trained, but also the lawyers also should be trained on these laws so that we are together on one page. So when the sexual offenses occurred during the post-election violence, because I had trained this judge, he gave a very positive report because he was able to recognize the human rights problem that occurred. And he was one of my best ambassadors when it came to bringing out issues that needed to be paid attention and to have laws changed to that particular aspect. So I find very important, if you just give me a minute, that we started what was known in 1985, the Women Conference came to Nairobi and then they went to Beijing. When they came to Nairobi, they introduced FIDA, the Federation of Women Lawyers, who do a wonderful work, the women getting together. But the problem was that when we formed that organization, all the women rushed to FIDA and they left the Law Society. So they never were part of the piece of cake that needed to be in the Law Society. So I'd like to say to all the women, please join the various organizations, International Association of Women Judges, FIDA, but don't forget the main body. The main body for Kenya is the Law Society. Get into position there together with your FIDA. The main body for the Women Judges Association is the Magistrate and Judges Association. Get yourself in that. Don't just have a cocoon and be on your own. We need to be able to participate equally in all this sphere. Thank you.
So thank you. So following up, you mentioned the role of men. So may I ask Noella, what you think the role of men has been in your career, or what you think it can be to foster female leaders?
Yeah, so I think and it's not a deliberate, I don't think it was a deliberate action by my bosses in mentoring me, just taking time to teach me everything that they possibly could. And also, I think they didn't even distinguish the fact that I was a woman. I think for them, I was just a student that was eager to learn and they were willing to teach. So I think mentorship goes a very, very long way in building up careers. My career, where I am, I attribute it 100% to the bosses who I've had in the past so many years, and they've all been male. And Kamal Shah is also seated here, and he's part of that group of people that I call mentors, because I did my secondment in Stevenson Howard, and he held my hand throughout that time, and all my contacts in London are because of him. Kamal Karori, who has been here, held my hand when my boss died. He literally called me and told me, I know there's a gap now and you're expected to handle all these big cases without a senior lawyer assisting you. I give you my unconditional support. If you come across a difficult question, call me, don't tell me the parties. You can check if there's a conflict and I will hold your hand and guide you on how you can make your arguments. And for me, that was incredible. So I think I would like to ask most men, the men seated here, to continue playing that role of mentorship without distinguishing whether it's a woman or a man. I think the fact that you have an eager student, someone that wants to learn, someone that wants to grow, the fact that you show interest in them and you're willing to teach them builds them the confidence to become whatever it is they want to be.
Itweba, do you want to add anything on the?
No, I think it's what was said. It's enough. You know, we will never have 100% of men, you know, supporting or helping. But you know, even if the one shows up, you know, you can learn just by observing. You know, and there is an advantage in the way men run the world. Their objectivity, you know, they don't put so much emotions. We put many emotions, too much emotions sometimes into things, and we need to put a little bit less. Not to take it off completely. No, I don't believe in a word like that. But even if you know, no one shows up and says, I want to be your mentor, or you can see from the act that that man is being your mentor, you still will be working close to other men, and you can be inspired, and you can look and you can see how they behave, you know. I keep saying that, you know, we can sit at the same table, and sometimes people will say, oh, you are trying to copy men. No, I will still have my high heels, my nails and whatever. And, you know, it's essential, but also I need to look to things in a very objective way. And this, we can learn a lot from men, you know, just by observing them, for sure.
Machida?
Could you repeat the question, please?
How men can
so
help.
what has been the role of like male in your career, or what do you think it should be to foster female leaders?
Oh, okay. I would say that men and women need to work side by side. I think that would help like to break the harmful cultural norms, which benefits both parties, men and women. And I can't add more to the points that they have said, yeah.
Thanks. So now I'll open it to the floor if you have any question for amazing panel, or if you want to share any thoughts or...
Online there was also some comments.
Oh, okay.
I saw
don't know, maybe we'll wait for Steve to feed the comments, but in the meantime, if anyone in the room like has so questions or thoughts or experiences to share, please do.
Thank you. Ladies, that was so inspiring. Really proud of you. So my question, as a working mom, you definitely had a kind of conflict or overlap or clash between your duties as a lawyer and your duty as a mother. So what are the key recipes when it comes to such kind of conflict? What would be your advice to all of those women who face such situation? When it clashes, when things get conflict?
I would say that, of course, having a good system of support, you know, rather family, parents, your partner, it's essential. It needs to be someone that really understands and that sees your potential and not gets into the way, you know, and don't feel like a competition, you know. It's essential that your partner doesn't feel like you are competing and you are trying to be the boss at house. Otherwise it will really be a struggle, you know. Exactly. But also I have a mentor. She's the vice president of a big corporation, and she once told me, look, children are the best to make you feel guilty. You know, they will always make you feel guilty. And I was like, my children are so innocent. How can you say that about them? And she said, look, they have a lot of activities, you know, and of course you want to put them in ballet, in piano and whatever, but you have to negotiate with them, you know. Mommy will attend this one. The others, I can't. You know, the others you have to invite your grandmother, your uncles. You know, you have to make them responsible to bring other people into the table. It's not just mom or dad. You know, but at the end of the day, you know, it's even for them it's very difficult. You know, dad might be here, seated here, and if they want something from dad, you know, they will also, well, if it's a partner, if it's a mom, it won't happen. But if it's a male, they will ask you about something they want from him, exactly. For instance, you know, and you just need to laugh at those things, you know, and to be proud of it. I keep saying, you know, I will just be their mommy for this time. They will grow. I see what I do with my mom, you know. She doesn't she doesn't have a say in a lot of things I do now, you know, because I've grown up so much and I became so much independent, you know. And I look at them and I say, this is my time now. It will end soon. You know, they won't ask my opinion. They will start hating me soon. They will start with those kind of breathing, like I said, why are you breathing like that? Is there any problem? And no, it's everything okay. And I know that the things are changing. So I'm just taking advantage of it, you know. But mainly is that negotiate with them, tell them to ask other people from family and close friends to be at their presentations and things like that. And of course, schools and everything, well, it's part of the investment. Hire people if you can.
And you know what? It's good that you get out of their sight as you're working, because this was the tough part of the virtual life, where we were working in front of them. So we were double hatting, and that was so tough, but we were upskilling at that time. So find where you can be replaced, set your priorities. There are situations where it's only mom that can step in and there are situations where someone else can replace you, and the support system here is very much essential.
Yeah.
And
there are fevers that only go away with mommy's kiss. You know, there's no medicine that will help. You know, and now you know if you own your work and you can work from home, you can do that. You know, I found out very useful to do it, and I'm not. You know, I was afraid in the beginning when I tried to do it once or twice, but then I said no, I don't care. At the end of the day, my email will go out. You know. So no one will has to blame me about anything, and I will do both things that I adore to do: being a mom, a wife, and a professional.
And so, that comes with skills.
It comes with the time. You get used to it.
Skills as well.
You just shoot the ball.
Yeah, I don't know.
Anyone else like?
Yeah, so I think I agree with my colleagues, but I think at some point in time, you will face hard choices, and you might need to draw a graph of a list of priorities. I've had to do that sometimes, where I have to sit down and remind myself, in this situation, what is the priority? And both things are important. Being a mom, being a wife, being a partner, and being a good professional, they are all important. And I tend to make my decisions on a case-by-case basis. I don't draw a broad brush. I think if this is important to my daughter today, that opinion will have to wait till tomorrow, and I manage the client and I'm there for my daughter. If I think today I can't wash you, I can't tuck you in today because this case is extremely important, it's got very tight deadlines, I take that decision. But you have to be very intentional and deliberate.
Yes.
And you need to know where to draw a line in the sand for some things, but you also need to be deliberate about making time for the things that matter. So that's, I'm pretty new at this, so I don't know if that's the answer, but
it is. Yeah. And they will recognize that. What I see is that they will recognize that you are doing your best, and they will admire you so much. You know, they look at you, oh, you are powerful, I want to be like you.
Yeah.
So they will see that.
And that's what we've been doing by nature, but listening for that. So having this coming out from different ladies who's been in such situation, it's really inspiring, and at least we're sure that we are doing the right thing. So thank you for that.
You're welcome.
Thank you. Is there
a question for a man, please? From a man, please.
My question goes on challenges. You've all spoken about the challenges you've gone through. I haven't heard anyone talk about the unwanted sexual advances. Have you gone through that, or it's just a myth? Has any of you gone through that?
Mary, you want to start?
Yes, you know, I actually had it on my notes to talk about it. But when I was referring, I was told, well, you know, you gave me a look that said, don't really talk about it. I was saying that we as women should belong to associations, the Kenya Women Judges Association, whatever associations that you have there. When I was mentoring the ladies, the women ladies to become judges, I'd like to just divert and just talk about that. I would use these associations, doing so very much in the background, how they would be groomed, how they would look at various laws. So when they go for their interviews, because we never used to have interviews before, we used to be just appointed. When you go to the interviews, you would be able to be taken. And actually, out of 28 judges, 14 were women who were taken. And I was very pleased about that. But I was stationed in a station where the judge was molesting the staff and was also molesting another lady judge who was there, sexually harassing them so much. Where do you go? You can't take him to the police because the police won't arrest a judge. Mm-hmm. And the system was like, we can't believe that this is happening. And people are not reporting. So what I did is I went to the association, and it was called Something Action, which is a women's association looking at sexual offenses and all this. And this association were able to investigate very quietly. Then I went to one retired judge, one of our first woman judge in Kenya, and also notified her. And she said she would quietly go to the Chief Justice and see whether she could be able to deal with it. And the judge agreed to take retirement and go home. You know, but sexual harassment is there. I mentor university students, and I met one of them, and I said, oh, how's your law coming on? And she said, I used to be in litigation, I'm not there anymore. I said, why? She wouldn't tell me. I said, were you sexually harassed? And she says, yes, I don't want to go there anymore. I'm into NGO world. So it is there and it is alive, but there are policies. I think anybody here from the Law Society of Kenya that have put down policies on how to deal with sexual harassment. Young state counsel going into a judge's chambers are sexually harassed. What do you do? Because the judge, instead of going to open court, says, you must come and present your case in the chambers. They go there and they are pounced upon. So the policies should be working. Now we've got a lady Chief Justice who's aware and sensitized to this. We really hope that this will be turned around, but the problem is alive. It is there. And thank you for bringing it up.
Does anyone else want to react on it? Or?
No. It takes a lot of courage to act, and to, and to feel like you are losing something, but to act, to separate your emotions from that situation, you will find someone to help you, and the right way, because the right way should just be go to the police, or to someone senior, but you, in this situation, you had someone that is sensitive and could understand behind the words what was happening. It needs to be taking the emotions and all the hurt that is in place, to know how to act, and know how to bring it to light, because these things need to be, need to be in light. Yes.
Thank you. We have time for one more question, and there was, yes, one on the back.
So, good afternoon, Kelly. My question stems from my professional experience. So I started my career in 2017 as an intern in a top tier law firm in Cameroon. And on the first week of my internship, the company had to work on the deal on the transformation of a microfinance into a bank. And my mentors had the choice between me and a male. The boss, which one of my mentors was a man, so he was pushing for a man. And the other person, the other mentor was a female, and she was pushing for me. Well, lucky me, I was picked up, and I was given the opportunity to work on this huge deal, something I never thought in 1,000 years that I could have done, like on the first week of my internship, just after my undergraduate degree. So this woman was really an inspiration for me because she not only gave me a chance, but she equally empowered me and kind of created the basis for the skills I have today. So I want to know, to the women on the panel today, how open are you to empower other women when they come to you for guidance, whether in the context of the company in which you're working or during meetings or on social media? Thank you.
Wants to go first? Okay.
Yes.
At the moment, we have 3 female trainees in Abu Dhabi. And I think the best thing that we're doing, I think, in my opinion, right now is like paying for their courses not the university courses, like what about legal courses, other legal courses that help them in gaining more knowledge or gaining more experience, and mentoring them with male lawyers and female lawyers, just to have the full experience of the whole thing.
Yeah, so I mean, this is a topic that is really close to my heart, and it's very easy to be caught up in practice and to forget to hold hands of the people below you and to bring them up to where you are. So I think the starting point is to make that commitment to do that. And I don't think it's important to do it for everyone that you supervise and everyone that you work for, that you work with, but especially for the women on your team, because sometimes there can be a tendency to overlook them. And I think one of the problems I see among us is sometimes we doubt ourselves, and we feel that if I lift up these people, they will be better than me and replace me. I feel that is a problem, but it's a perception. That can never happen. If you lift someone else up and you give opportunities to other young women around you, it can only be for the better. But I think it's something that as a woman, it's a personal decision, and you must make that commitment. And you won't anticipate it, but you will face some resistance. You may, in the context of your workplace, face accusations of favoritism. Or you're building a small clique of lawyers that are like you. So you need to find a way of doing that, lifting the people around you in a way that will also be acceptable, because sometimes people misinterpret it. They interpret it as you being, choosing favorites, or you're always working with these 2 women or these 2 girls, and you're always taking them to conferences. You're always exposing them to big cases. You're always introducing them to big clients. So you need to find a way that is acceptable to do that, but you must do it. We owe it to the people that did that for us to do the same.
As for me, what have I done? Well, I have a habit that I don't like to work alone, never. So whether it is a man or a woman, I will always bring someone to do something with me, something great. So it is, on my personal nature to always try to invite people. Sometimes I might fail, I might choose, I might not choose the right people. Sometimes I might choose a right person, but it's not the right moment for that person. And I need to understand that. But the way that I commit myself, and it's naturally, very naturally, is not something that I had to put a lot of effort in, is whatever I have to do, just involve other people, just involve young practitioners with you, treat them with respect. You can be mad at some nonsense or some things, but please treat them with respect. And even if sometimes you lose your temper a little bit or even too much, don't be ashamed to say, I'm sorry. I was really nervous. I shouldn't have told you what I said, the way I did. The most important thing that I want you to keep is this, and that. Also, for me, it's very important to recognize when someone does something good. Yes. I'm not ashamed of saying publicly. I've recognize it through a message, or through an email to all the firm. You know, I'm not ashamed of that, and it's so important for me to do that. You know, especially for people not to feel used. Oh, she used me to get where she wants. And everyone likes to be recognized.
That's true.
Yeah. Even for us.
What I'd like to say, my policy has always been never ever leave someone whom you have met or whom you're working with the way they were. You must make a difference in their lives. You must do something different. So let me give you an example of one lady. She was an arbitrator and she came to me and says, do you think I should apply to be a judge? I said, yes, go ahead. And she applied to be a judge and they refused to take her because they assumed that she was too young. So she said to herself, why don't I try to be the chair of the Chartered Institute of Arbitrators? And she became the chair of the Chartered Institute of Arbitrators. When the Judicial Service Commission realized, they quickly called and says, come back and be a judge. So she came back and she was a judge and she relinquished her post as the Chartered Institute of Arbitrators, the first woman Chartered Institute of Arbitrators. So never ever leave someone the way they will found them. You must make a difference in their lives. And to me, it's not women, it is both men and women. It doesn't matter which gender you are, make a difference.
Thank you. Thank you. And so I think we've run out of time, but this was a great panel and very inspiring. So please join me in thanking our amazing panel.
Ladies and gentlemen, please applaud the ladies. I think it's been a very interesting panel. The She panel has really been inspiring and very much interesting. I think let's go to our last session, the 10th session, Oxford style debate. I hope you're ready. Please, Lee. You're welcome.
All right, we are at the very last end of this wonderful event, and we are going to treat you with one very interesting debate before we let you go on so that you just don't forget what you've heard here. I think this is a great amuse-bouche, and we have amazing debaters coming. So let me introduce them. Jacqueline Lule. She's not a new face to the IAC space, and we're happy to have her. So please welcome Jacqueline Lule. And we also, yes, welcome Jacqueline. It's going to be a very hard debate, as you can see. They're ready to fight. And our second debater is Kimati Kioneha. As you can see, with the kente clothing, you can't miss that he's a Ghanaian man. He's ready to show out that Ghana is ready to make its points. So this is where we are. This house believes it's time for Africa. A case for the use of African seats, arbitrators, and counsel for African-related disputes. Now, before we start this debate, I want to see where the House really stands. So how many of you agree that it is time for Africa? By a show of hands, please. Let's see. Okay. All right. Jacqueline, the floor is yours.
Ladies and gentlemen, thank you very much for staying on for this debate. Thank you for inviting me. It's a pleasure to be with you again, to see so many old friends, and obviously to see Kimathi, of course. Despite his colorful nature, I can assure you that by the end of this, you will be persuaded to my position. And that he too will be persuaded to my position. I think, ladies and gentlemen, when I was preparing this debate, I thought of it in this way. I feel as though it's not even a question of, is it time? In my view, it's late. It's late. We are already ready. We have been ready. And really the question, to my mind, is the how. How do we persuade other people, not ourselves, how do we persuade other people that it is time for Africa, that it is time for the instruction of African lawyers, for the African disputes, for African seats of arbitration and the like? As far as I'm concerned, it's time, it's long overdue. It's not even a debate. So why do I say that? Well, ladies and gentlemen, the first thing I'm going to say one academic sort of thing only, because it's late. But reading through the survey by Dr. Amelia Onyema, she said in 2020 that 83%, in fact, 83% of respondents to a survey done by SOAS were people who had actually used African arbitration centers, and 88% of them said that they would recommend them. Now, of course, those are the centers, not the seats, but I'm coming. The arguments that we normally see about seats of arbitration in Africa not being appropriate tend to be well, there's political instability, there's delay, we don't know what their law is like, things of that nature. Do they have capacity to deal with arbitration? Is there neutrality? And in any case, it must be difficult to enforce arbitration awards. Well, if I take them very quickly, because I know that time is short, if they say, well, the law is not always very clear, and sometimes, they've got problems in their, the legal statuses in their countries. Well, hold on a moment. Every single country in Africa has some sort of arbitration law. Even the ones that came from the colonial times that are being amended and changed are present. Secondly, most African countries have either adopted the ancestral model law approach or, for example, in a sort of regional group like OHADA, the Uniform Arbitration Act. Most countries have got arbitration rules that look very similar to those that you find in arbitral institutions all over the world. We have the arbitration centers. Most countries now have more than one. Some of them have been there for over 40 years, and that's why I say all of this is rather late. We have people, and I say we have people because I include myself amongst those, but if you look around the room, I don't think I need to say anything about whether Africa has the capacity to deal with arbitration. I think that's a given. I don't think we need to spend a lot of time on that. Often it is said, well, these legal systems are unclear to us. Well, most of them are either common law systems or civil law systems that are akin to those that you see all around the world. Oh, but they take so long. Show me a country that doesn't have a long waiting list for court cases. Show me one. They say, well, we're not sure what they're going to do. Well, rather than say that you're not sure what they're going to do, just have a look all around the world. Who is certain of what a court is going to do? You only have to look at recent decisions of courts all over the world and see that actually no one is ever certain. It is said, well, there's a lot of delay. What I say about that is that that shouldn't stop us from using African seats. Sort out what is causing the delay. If it is a case of having to give more power to the appointing authorities or to the arbitration tribunals themselves, well, then do that. They say, well, but hold on, we don't know what they mean when they say public policy or arbitrability. Well, I have to say that if you look whether it is in global north or indeed in Africa, public policy has never been defined, has it? There's a sort of a thing where attempts are made to define that thing, but it's still a thing. You know, is it about domestic public policy? Is it about international public policy? Is it about international public policy seen through the lens of the seat of that particular arbitration? No one is clear. So if no one is clear, then Africa shouldn't have to pay the penalty for that. If it is there is delay, reduce the ability to cause delay. Arbitral parties are in a position where they can say, you know what, we're going to agree that once an award is made, it is final, and we're not going to permit appeals in terms of set aside. It's done all the time, and it has been upheld as a possible way of reducing time. There is concern about court intervention. What will the court do? Well, again, if we give the power to the arbitral tribunals, then even that doesn't need to take too much time. So what I'm saying in short is that there is no surprise left. We have taken time to grow capacity. We have all manner of arbitrators, fellows, chartered arbitrators. We have chapters of SIAB and branches of SIAB all over Africa. Allow me to mention Uganda, where we have recently become a chapter with the assistance and support of the Kenya branch. So we have done all those things. So if we have done all those things, then why is it that we're still not there? Why is it that African seats are not being chosen? We have the facilities. I mean, just look around you. We have good weather, good food, good hospitality. So why not? Because of course, often the seat and the venue might be the same. So we shouldn't lose the ability to grow Africa simply by essentially contracting out the ability to resolve these disputes. Why should you take a dispute elsewhere when you know that issues of interpretation of that contract law are generally known better locally? The local lawyers will be able to assist you as to what public policy is, what's likely to be arbitrable and what's not likely to be arbitrable. Why do you need to do that? And you may also agree with me that actually one of the reasons why there is a loss of confidence sometimes in arbitration is because there is no buy-in for Africans. They think it is a justice that is delivered from somewhere else, and then it is come and placed upon them. And if you look at other systems, whether it's international criminal courts or other international systems that haven't got buy-in and by participation, there is that sense of, but you know what? How did that happen? We don't understand that. And then people lose support for it. And then you find that sometimes people will say, well, actually, why do we need to be in all this international arbitration? We're going to arbitrate in the local court, and we're going to deal with it in our country on a mandatory basis, as some jurisdictions like Tanzania have done. So what I'm saying to you, and I'm hoping to keep it short, is simply this, the debate about whether we are ready is over, long over. The debate is now about the how. And so next year, perhaps, I talk now to my big 4 stars, you know, LOD, Warimu, Agnes, Leu. Perhaps we now need to invite the companies and the clients of these who take part in these arbitrations, for them to see and understand the capacity that is within Africa and the benefits of coming to Africa. It's even, the weather's good and it's even cheaper. So come here, deal with it here. And if the legal system is not well understood by you, well, find out. If I may give an example, you have a lot of cases where Chinese companies are involved. They say arbitration in China, the seat of arbitration is China. Nobody ever says no. It's okay for them. So why can't it be okay for us? And often people don't understand what that actually means, but they're okay to do business on that basis. So we too, if there's something you don't understand, there's local counsel. They can tell you what things mean. They can tell you about the law. They can tell you about the procedure. And in that way, they are also engaged in this process. So if I may conclude by saying that really it's about trying to persuade others to see the capacity that is already here. And I'm sure, and I'll stop here, when my learned friend Kimathi gets up, or when even he sits down, he will agree that I'm right. Thank you very much.
Thank you very much, Jacqueline. Now, Kimathi, let's see what Ghana has to put forward.
Thank you very much. Very happy to be here. And I'm very happy to see my very good friend Kamasha here as well. And Luke. You know, I'll make 3.5 points because I think the answer is obvious. The first point is that we Africans, we have an exaggerated opinion of ourselves. Sometimes we have to be honest. Even this meeting, I'm supposed to start at 4, but we're starting at 5. We can't even get an arbitration conference going on well. How can we then say that we want to do big arbitration? It's not true. We have to be honest. One of the ways in which we can be great is to be honest with ourselves. We can't, the conference is starting late. So how can we even do big arbitrations? I mean, Kamal's firm and my firm were enforcing a very big arbitration against one of the governments in Africa, starting with one of the alphabets. But he knows how difficult it is to do these kind of things. So first, we ought to be honest. We operate below expectation in Africa. I mean, I have the many statistics, but we have to be honest with ourselves. Most of us came here late. Most of us don't go to court early. Most of us don't do things very well. So we have to be first honest with ourselves that the conditions which we have created does not inspire confidence for the people who pay the piper to allow themselves to come to Africa to go on arbitration. The first one, most of the investment agreement, most of the financing, they don't come from Africa. I mean, in Africa, Forbes magazine in Africa always says that there are rich men in Africa, etc. All of them are debt. And most of the debt comes from abroad. I mean, you want to clap, go ahead, feel free. Feel free. I mean, be honest with your colleagues is always difficult, but I will do it anyway. Most of the rich men we say are in Africa or doing great business, all of them are debt provided not by African banks, but debt provided by international banks. Now, if I give you money, you want me to come to your country to arbitrate, or actually you are not even paying, and they always don't pay. Usually they don't pay. So there's always enforcement. I mean, Kamasha is here. He can always attest to that. They don't pay. The African countries who receive the debt, they don't pay. We are always restructuring, re-innovating, refining different ways of doing that. If I give you my money, you want, and you don't even pay, you want me to come to your country to come and arbitrate the matter? I mean, let's be serious. I mean, let's try and be serious. So that's the first point. The second point is, let's be honest. We don't have independent and courageous lawyers in Africa. Oh, wait, let me explain. How many practices, proper law practices have been developed, say, in Rwanda, where they are more than 10 lawyers? I mean, let's be honest. In Uganda, for example, I mean, how many proper law firms are there? Yes, Kenya, but Kenya, the big proper law firms, one is managed by an Indian companies who are Kenyan, and one is by a South African company, and then the other small ones. Let's be honest with ourselves. Out of those ones, how many are proper arbitrators who have had a consistent experience in arbitration? And how many of those law firms don't do government work? To the extent that if you have a big arbitration against the government, you are going to try and be courageous. You are worried that they are going to take the job from the Electoral Commission from you. So we're not independent. We're not there. How many law firms can say confidently that they don't do government work? No. All of, I mean, the people are in Abuja, trying to look for work. People are in Pretoria, people are trying to look for work from government. If you have a challenge with government, how are you going to manage it? It's very difficult. So that is why the people who want the arbitration, they are our clients, that's why they won't come. And the statistics bear me out. They will never come unless we are prepared and focused to develop ourselves. You don't have a bedroom, and yet you want to go and find a wife. I mean, where have we heard that before? It's not going to work. And so you would be asking Luke and Godwin for their car keys in order to go and do things in their cars. It's not going to work. Jacqueline, it's not going to work. The third point is that there is too much corruption in this Africa. There's so much corruption. So, first, arbitration is life and death, is war, I call it. Unless people have confidence in the space in which they come to arbitrate, they are not going to come. You can argue that it's perception. You can argue whatever that you want. But perception is fact. If our client says they don't, this place, government is, doing things, things are not good. And they go online and they say the index, the last index they did, only 3 countries were under 50. Most of us were at the back there. And it is true. We are all witnesses to it. So without the confidence within the system, they are not going to come. The question is whether Africa is prepared to change. But we all know that we're not prepared to change. I mean, recently over West Africa, over the world, there is both of them. The arbitrators don't want to change, the governments don't want to change.
While there are competent African arbitrators, okay, they can do it. They can do it. You're talking about the lack of confidence.
Yeah, we will take your.
No, it's okay. I like that. That is what I wanted to provoke.
We will take your question.
Usually, when I'm speaking, I like to provoke. Yes.
Tired. I think we'll take the question. We'll take your question later.
Which was referred by Dr. Emily. regarding the arbitration and arbitrators in Africa. That's
I agree with you that sometimes wishful thinking is beautiful. Exactly what you are doing. I mean, if you are an arbitrator, first, what's the track record? How many big transactions have you done? The last time me and Kamasha we're dealing with millions of dollars of that. What's your track record? So the first one is I'm not going to appoint you for a $150 million arbitration when the last time you did was $20,000 US. I'm not going to appoint you. First, we don't have the track record. But the problem with Africa is that we don't want to accept the reality. We are so romanticized about these things. We're very romantic. We take everything emotional. Look at it. But it's not true. You cannot. They will not appoint you because they will not appoint you for many reasons. The first one is that you don't even have the track record of doing those kind of arbitration. Some of the arbitration, they are very technical. The most recent one we did was power. How many power transactions in Africa?
Why you don't have that track? Ask yourself, why we don't have that track of...
Taib, I'm going to call order. I'm sorry, I'm going to call order, Taib. Let him finish his point.
You
yes.
played a role in Africa arbitration.
Yes, I do.
What is written in that?
Yes, but
about Africanization of African districts.
Yes, let's let him finish his point and you will make your point. Okay, move on to the third point, Kimathi. The third point, Kimathi, so that we can
actually I try to answer his question by the third point.
Yes.
Now you need a track record.
Yes.
First, you need a track record, you need training, you need facilities, you need a great environment, which we don't have. I know Kigali has been doing very well. I know that Accra has been doing very well, Lagos has been doing very well, Egypt, etc. I know they've been doing very well. But they don't have the track record. If you look at the data, they don't have a track record of doing great, and I have the data. I can give it to my dear colleague. But anyway, this is the debate. We have to agree to disagree, and then I'll buy you a drink after I finish. Thank you very much.
Thank you, Kimathi. Jacqueline, you have 1 minute.
1 minute. Okay. Kimathi says, well, the finance comes from elsewhere, so why will investors come here and insist on using African seats? But they don't finance for nothing. They don't go away with nothing, do they? You come here to do business. You get something for the business that you do. Whether it's in minerals, whether it's in extractives, whatever it is, you get something for what you give. If it's money, you also get the fact that you charge interest. So it's not for nothing. Okay, number one, he says that we don't have independent and courageous lawyers. I'm going to answer you in 2 sentences. First of all, I'm sure everybody disagrees with that. Secondly, how many governments that you see in global north have ever, for example, overturned an election? That's courage, isn't it? Isn't that courage? It's happened twice in Africa in the last 5 years. So don't say that we don't have courage. We have courage. Then he says, well, the arbitrators don't have a track record. Well, if you don't give me the opportunity to get a track record, how will I get a track record? Okay? So that's the first most important thing. And not only that, there are sometimes that people are appointed, even when they've never done arbitrations, simply because they have book knowledge. But I can guarantee you that a lot of African arbitrators who are sitting in this room and elsewhere do domestic arbitrations all the time. And is arbitration not the same thing? Isn't it the principles that we are concerned with? Whether it's $1 billion, but aren't the principles the same? They're not different. Whether it's separability, validity, enforcement, all of those principles that you all know well, isn't it the same thing? It's the same thing. And then he says, well, you're all corrupt and, Africa, they don't, you don't want to grow, you don't have the capacity. Rubbish. Rubbish. And he knows it. Rubbish. Look where we are. Look at the facilities we have. This is just one country. Look at the facilities we have. Look at the facilities in other countries. I think all these arguments are intended only to do one thing, which is to deter us, but we will not be deterred, Kimathi. We will not be deterred.
Very well done, Jacqueline.
Yes.
I would like to get a few remarks, keep them short. We have to wrap up the session. So I will start with you, Tayeb. You had a lot to say earlier, so I'll start with you.
I have a question to you.
Yes.
Again, you played a role in the Africa Free Trade Treaty. What is in that treaty regarding Africanization of African dispute?
Okay, I'll take that question. We'll go to the next one. Kamal, did you have a, yeah.
I think, thank you for a very colorful debate. A lot of thought-provoking and a lot of provoking remarks, which we expect, Kimathi, thank you. But on a serious note, if there is one word I have found which describes the way we should be doing things, it begins with C, and that is confidence. If we just have that one thing in our minds, I think we can transform ourselves. How many foreign companies have sponsored this conference? How many foreign companies come here for investment? How many foreign companies support African students and have all these training programs? Currently, there's one going on, the AYA, Africa Arbitration Academy, sponsored by 12 of the leading firms in the City of London. So we just must have a lot more confidence in what we do, because they will come and they will agree to our terms. There will be compromise, but we need to have the confidence when we're negotiating with the rest of the world. That's it. Thank you.
Thank you.
I don't know if I have permission to make some comments.
Yes, please. Keep them short, but you may.
I'm afraid it might be a lengthy one. And that's as a result of the very, very colorful debate that has taken place. But this is a very serious matter. And I have reason to respond because of my old age in this business. And as colorful as the comments that have been made have turned out to be, there needs to be a form of rebuttal. And I make the rebuttal on behalf of arbitration in Africa. I start by making the observation, which must be taken seriously, that we must recall and remember that arbitration as a means of resolving disputes is highly private and confidential. Therefore, you will find that a lot of African distinguished and accomplished practitioners are not about to be broadcasting what they've achieved in arbitration willy-nilly just to be recognized. Arbitration doesn't work that way. Having given that caveat, I'm here to make the point that a lot of African nationals have been involved in complex arbitrations, multi-billion-dollar arbitrations, and there is no lack of track record. And with all sense of modesty, I make bold to state that I started arbitrating in the year 1989, domestic disputes, and then gradually made my way to international disputes. I can assure you, without being immodest, I've had my fair share of international complex disputes from quite a good number of international arbitral institutions, and most of those disputes have had a connection with Africa. Yes, those who know me will say I'm based in London, but what I say is that I'm based in London, and I use London as what I call a flag of convenience, because it enables me to attract appointments from all parts of the world, in particular for disputes that have a connection with Africa. And I'm quite happy to announce that some of those who have been so gracious to appoint me are in this very room. I'm also happy to announce that there are a good number of other arbitrators of distinction from Africa who are also in this very room sitting behind me. So on behalf of those arbitrators, old, young, new, of any gender, who might feel concerned that the comment is being made in the year 2022 that there is no track record for African arbitrators, I say there is no substance in that assertion whatsoever. Having said that, it is of utmost importance that we do not rest on our oars. Yes, the speaker who debated in favor of arbitrations taking place in Africa made the observation that it is late. Indeed, it is late. And we must continue to hold this kind of events to showcase what Africa has to show to the whole world. What Africa can do in terms of manpower, in terms of organizing a conference of this nature, in terms of bringing together well-informed, well-educated, and well-experienced practitioners to debate topical issues that pertain to international arbitration. This must continue, and we must not give up. But it's important that we hear what the counter-argument is and ensure that we take necessary steps to counter those arguments. A point was made about lateness, and I smiled. The good thing about arbitration and other forms of ADR is an inherent attribute of flexibility. That's what arbitration is all about. If you can't catch your flight at 10 o'clock to Kigali, the panel will understand and rearrange. That's flexibility. That's the beauty of arbitration, the beauty of ADR. So how dare anyone suggest that that one disadvantage of conducting arbitration in Africa or through African arbitrators or African lawyers? Again, there's no basis whatsoever for such an assertion. Now, I'll keep it there short for now.
Yeah, 30 seconds.
Sorry.
30 seconds.
Okay,
yes.
Thank you very much. But that's all I have to say in support. And I said this because I felt a degree of, should I say, disappointment that those eminent arbitrators of my age, you can see my beard and my white hair, will be giving this kind of description when we are still alive. I thought I should rise to give them that defense now that I'm still alive and I'm not dead. Thank you very much.
Thank you. Thank you. All right, we'll take one more comment. One more comment. Okay.
Well, thank you very much. This is an issue that evokes a lot of passion, a lot of sentiments, and will continue to do so for a long time. And it's an issue that I am personally very passionate about, and every African should be passionate about. And I think that's why we had the debate this evening. But one point I wanted to point out, which I think perhaps we have glossed over, is look, nobody is going to cook soup and give you the soup to eat. All right? What do I mean by that? Very simple. A lot of times we hear about the midnight clause, where it's been negotiated, where it's been drafted. Where's Africa at that time? That's where the problem starts from. And like Kamal said, it's a confidence issue. Because at the time the arbitration clause is being drafted, at the time negotiations are ongoing, foreign investors, they have lawyers, foreign counsel, all the big law firms in UK, Paris, Singapore, wherever they are, those guys are going to protect their jobs. They're going to protect their investment. So when they draft that clause, they're going to tell the client several reasons why the seat cannot be Africa. Because they have an eye for the future. They anticipate a dispute. And when that dispute comes, it comes back to them. Because don't forget, they were there. They cooked the soup. So we need to understand that, and that as much as we are passionate about this, it's about us getting our economy right. It's about us getting Muslim investment. It's about us building confidence in these people to be able to appoint us. We have capacity, no doubt about it. Don't let anybody fool you. We have capacity. Both within and outside Africa. I mean, Africans in the diaspora, we have capacity. But the point is we need to keep our eye on the ball and say, for instance, if I'm a UK company and I want to invest in Nigeria, why would I want to use the Nigerian courts? Why? If I'm sure that at the end of the day, I can have my dispute resolved in the UK and I can have all the law firms in UK represent me. So it's an important issue and we need to find a way to address that. Nobody's going to tell you this, but I tell you that the truth. The bigger law firms, they protect their interests. Thank you.
Thank you. All right, I'll take one comment. We haven't had a woman. So yes, ma'am.
Thank you very much. Actually, yes, I'm going to make a small comment from my experience. First of all, I agree on what is the difficulty and what we need to promote Africa as a hub of arbitration is to work very hard on the infrastructure. So we will not be able to have an arbitration away of developing our countries. This is number one. While I was working in DIAC, Dubai Arbitration Center, in a long time ago, 94, yeah, at that time, what happened, there was no experience, and it was the fairest arbitration center in the Gulf. The fairest one. The only center in Bahrain is for GCC, that's for academic and training purposes. So they focus on having an arbitration which is capable to train and bring and accommodate all arbitration cases that related to contracts within Dubai. You know that the volume of projects at that time, construction, development, and these things. I remember very clearly the fairest arbitrations come to DIAC. All the arbitrators selected by the parties are Sudanese, African. They are not Arab, they are not British, they are not. They were capable, they delivered, and because they start making the record. And when they have 2 or 3 cases within the center, then the companies and investors start asking them to come back and manage the next arbitration. So then afterwards, it become very open. Many arbitrators come and the list become very wide and we register arbitration. I think what we need to do here for arbitrators, definitely we have a competency on arbitrator side and the lawyers. We need more exposure to the world. So engage with the law firm, the Western law firm in doing the business, doing the transactions, starting from the beginning, show them we are there. And then when there is a dispute, the dispute can be managed in our arbitration centers. Only and if we have the infrastructure. I don't imagine to have a big arbitration while one flight not coming on time. Yeah, this is a very serious. If you don't have accurate, punctual flight traffic, this is an issue. If you don't have internet connection, it's high speed, it is an issue. Yesterday, I do respect the organization 100%. My feedback was excellent. But yesterday, the Zoom discussion, it was disconnected so many times. So this is in arbitration, in the concept of arbitration, it is a cost for the parties. This is why one of the reasons that the investor, they always hesitant. They are not reluctant, they are hesitant. Unless we prove them, we are capable to host the arbitration, our arbitration institution, we will not be able to bring arbitration here. Thank you.
Thank you. Thank you very much. Thank you. That's great feedback. Okay, I'm going to give my debaters
No, I
90-second maximum each to respond.
No, I think you can go. I would, my point is very strong. I mean, because most of the contribution essentially supports what I have said. The good prof himself has indicated that he's in London. His appointments are in London. No. He doesn't, he has indicated. So the question is, why is he not in Nigeria? Why is he in London? Let's not. So he's, as for the good prof, it's, he's already contradicted himself just by the fact that he said, despite that I am in London, that already kills the argument. My good friend Kamal, of course, he confirmed what I'm saying, that we don't really have, and confidence is a big word he's used, and I agree with him. Confidence goes with what my dear lady had said, infrastructure, facilities, and what Godwin also said at the time of drafting the agreement, etc., etc. So all the contributions I agree with. But in our heart of hearts, we know that even we are the ones to suggest to our clients that go to London, go to Stockholm, we are the people who suggest to our clients. So we know that. So I would give my rest of the time to her. And I know that I'll win the debate. I'm so confident.
It's only because we are friends. Otherwise, I'll destroy you. And that is his concession speech, by the way. That is his concession speech. Ladies and gentlemen, thank you so much. My final comments were only going to be essentially two things. That remember that Africa is 53 states. It's very important. Those are 53 seats. So if you hear something about one seat, it doesn't mean it's the same for another seat. I think it's very important that we acknowledge that, because there are some governments in Africa that have given so much support to arbitration, arbitral institutions, and learning for their country that their seats are ready. They are ready, they are competent, they have capacity, they have rules, they can do everything. So we must be very careful to say there are 53 seats. Let's assess each one individually. I will then say that I agree, sir, with what you said, which is, by the way, it's about our governments giving that support. It's about saying, an attorney general, for example, comes to an event like this as we had today. It shows a support for the process. But it's also about them saying, well, actually, I want all arbitrations to be dealt with, for example, at KIAC or at NCIA.
Or they stop taking foreign lawyers to deal with the agreement initially. There's $100 million Africa spent on legal fees.
And
most of them goes to the British law firms and American law firms. So Attorney General comes here, comes to see all these nice things. But he's going to give the next arbitration to somebody in London. So all these things, that is why we are not ready. That's why we are not ready.
That's why, Kimathi, we want to say that actually they don't need to spend that money. That's the whole point. They don't need to spend that money because the competent people are even some of the people who are sitting here. That's what I'm saying. So just another couple of things. I think the conversation must be about persuading others to see the capacity. We are not in doubt about it. It's about persuading others to see it. Commercial concerns that are coming to invest. We need to find a way to reach them. We need to find a way to reach trade and investment ministers who are making these deals and who are deciding where these seats should be, and for them to understand it. There are sometimes when you even wonder, at the time an agreement was made, did that African government actually understand the import of choosing a seat?
Some of the time, the attorney generals are our own people. Like next year, you become an attorney general of Uganda. You are not going to make it.
I will not do that.
They are our people.
Point of order, Kimathi.
Oh,
so I think the debate will go on, but thank you very much.
Thank you.
All right. We actually have to go to our vote. I'm sorry, Taib. We have to go to a vote. No, we have to go to a vote. I'm sorry. After this provocative debate, and based on what you have heard now and what you were feeling before, does the House still believe that Africa is ready? Please, a show of hands.
Oh, I won.
I mean, the numbers haven't changed, so I don't know. It does not look like the numbers have changed. Huh? Based on what you've heard, do you feel that Africa is ready? I'm going to need you to raise your hands so I can be clear. Raise your hands. Is Africa ready? Is that what you believe?
Yes.
No, it looks like Kimathi had a tough run, but unfortunately Jackie might have taken this one. Ladies and gentlemen, please thank my debaters, and they've done a fantastic job. Thank you very much. Thank you. Oh. People, I think let's appreciate these debaters. It's been provocative, interesting. In my own opinion, Kimathi has some points. Of course, not popular, but thank you so much for the debate. Ladies and gentlemen, we are coming to the very close of our sessions. I thank you so much for allowing me to moderate the sessions. Thank you for being patient, for staying interested in the discussions and the sessions. And so I will invite the Secretary General for KIAC, for Kigali International Arbitration Center, for closing remarks, and also for the recap of the 2 days. There is a dinner gala, and I'm informed by the organizers that a bus will be here at 7 for those who registered for the gala. So be prepared for the dinner and the program that will follow. Yeah, with that, I thank you very much for your participation and for your active engagement. Thank you. SG, over to you.
Your Lordship, President of the East African Court of Justice, distinguished delegates, ladies and gentlemen, all protocol observed. We've come to the end of our 2-day workshop or conference. Most of you have been here since yesterday. We discussed about what topics, and we thank you for your contribution. We had here different categories of our speakers and participants. You have all contributed to the acquisition of fruitful and useful recommendations, insightful ideas that constitute our take home as we move back to our respective jurisdictions. Before reading the summary of the discussions that we have had during the last 2 days, I would like again to thank and recognize the role of each and everyone here present, starting by our chief guest who spent a lot of time with us yesterday. Chief guest, His Lordship, Dr. Nteziryayo, the President of the Supreme Court of Rwanda and the Chief Justice. The Attorney General of Rwanda, Dr. Ugira Shebuja Emmanuel. As my sister from Uganda was saying, the presence of these two dignitaries of this country show that some governments, some countries really do provide support to arbitration. And we believe it's not only here in Rwanda, but in some other jurisdictions. So my sister explained it very well, that we do have very safe and good arbitration seats on our African continent. And thanks very much to Professor Ike that really provides some clarification on that. We do thank our keynote speakers, moderators, our MC. Thank you very much, Marklin. Kindly stand up for recognition. You did a great job. We also thank the hotel management. I don't know whether their representatives are here. So I think we attend our conference in really the appropriate comfort that we expected here. So thank very much to the hotel management, the cameraman here, Agnes, Leyu, and Elodie. You deserve a big recognition, please. But you have time to speak on behalf of the entire team, but I would really leave this stage without really expressing my gratitude to you. You spent lots of sleepless nights organizing this, and Stephen, who is there, hiding himself there, but I know that he did a lot of things to make this. Thanks a lot, Stephen. So delegation from more than 20 nationalities. So this really shows the importance of this conference. From Africa, Europe, Asia, US, so everywhere. So in this morning I listed, but I can go very quickly among the list of delegation here represent from France, Switzerland, UK, USA, Pakistan, Singapore, United Arab Emirates, Angola, Gambia, Ivory Coast, Kenya, Tanzania, Uganda, Sudan, Ethiopia, Djibouti, Nigeria, Ghana, Egypt, Mauritius, South Africa, Zambia, and the host, Rwanda. So you understand really the caliber of the representation here present in Rwanda. So I think really that shows the relevance of this conference. And I will kindly request a round of applause for all the delegations here present. Thank you very much. Now, without taking much of your time, I think you have delayed a lot. So let me go through the summary of the discussion that we had in our last 2 days. So you allow me to read carefully as a student that is reading the reports. So to avoid that, I may jump any important element. So here I'm going to read the notes given to me by my professor, like Professor Ike and the other professors here, Dr. Kariuki and the others. So allow me to read as the report is. So in the last 2 days, we have been privileged to have heard from our distinguished speakers who have done justice to the various topics allocated to them. These discussions kicked off yesterday with an address from the Chief Justice and President of the Supreme Court of Rwanda, who delved into growth of arbitration in Rwanda and the positive approach taken by the Rwandan courts on matters of arbitration. We then heard from the Attorney General and the Minister of Justice of Rwanda, who shifted focus on provide an introduction to the theme of this conference. He spoke about the effects of climate change and the rise of climate change litigation setting out various scenarios that would give rise to claims falling under this topic. The topics have been diverse in the sense that we have engaged in: 1, government-related arbitration disputes on infrastructure development, where we discuss issues present in Africa, and particularly South Africa, and the EACO project to be undertaken by Uganda and Tanzania. 2, the effects of the pandemic and the current global uncertainty surrounding the Ukraine-Russia war on contracts, where we discussed, among other topics, disruptions in the global supply chain and potential for disputes, where consideration was given to disputes arising from the price variation, reduced demand, and so forth. We further heard about the implication of the pandemic on arbitration hearings, where we've seen a shift to virtual hearing, and here we discuss the advantages and the disadvantages of the same. 3, the ESG-related claims, where we learned that far away from buzzword that is ESG, we as practitioners are likely to have been engaged in matters relating to the various components of the ESG. We also heard about the balance that investors have to take into consideration when marrying investment and meeting ESG requirements. 4, we had an interesting panel of general counsel who shared the perspectives in relation to the including arbitration in the dispute arbitration clauses at the contract stages, the considerations given to negotiating the dispute resolution clauses, and the attitude towards appointment of counsel and consideration given to the same. 5, the process of enforcement of foreign arbitral awards in Africa, and there was heavy discussion surrounding Article 5E of the New York Convention and the principle of double exequatur. 6, we received insights from seasoned lawyers in the ADR community regarding the attributes that one needs to bear in order to grow in the ADR profession, and such attributes involved mentorship, training, and increasing knowledge in the topical issues. 7, we got a glimpse on state of investment protection in different regional blocks in Africa, where discussions surrounded revocation on BITs, amendments to investment laws, incorporation of ESG standards into the current laws vis-a-vis investment protection in BITs, incorporation of virtual hearings, and so forth. 8, we discussed intra-Africa investment treaties and arbitration, where we discussed the need to come alive to current issues affecting the globe, such as ESG, and to incorporate ESG standards into our laws to ensure compliance across the board and overall modernized rules so that they stay fit for purpose. 9, we have heard from for an all-lady panel that discussed fostering female leaders in African international arbitration scene, and the Oxford-style debates on whether or not to promote African seats, arbitrators, and counsel, seeing that presently many international arbitration proceedings are referred to the foreign arbitration institutional rules, such as ICC, LCIA, Singapore, Malaysia, and elsewhere, with tribunal appointment given to foreigners. So that was the brief summary of the discussion that we've had during the last 2 days. But I believe that a detailed report will be shared with participants in due course. So without further ado, I'd like to thank you again for your participation, while I hand over now the floor to the organizer, Leyu, and your team, just to deliver your final remarks for as we conclude this event. So thank you very much, and stay safe, stay comfortable in Kigali, and enjoy Kigali to the maximum. As I said yesterday, we love you, and karibu tena Rwanda. Thank you.
Ladies and gentlemen, we're not going to take any more time from your day. We are just here to say thank you so much for having faith in us, for supporting us, for being here 9 years ongoing. We would like to thank all of our sponsors, Aston Law, O'Rara and Company, Advocates, Al-Harib, Reed Smith, CDH, Laliv, White and Case, Tark Air, BLC, Robert, Mawalia, AB Patel and Patel, ALN, and of course, our platinum sponsor, Stevenson Hardwood. This is really an honor that we get to bring this together every single year for the past 9 years. We can't wait to do it again, although we're going to take a little of a hiatus for the next month or so and sleep. But I have the great fortune of having, Werimu's not here, unfortunately, so we miss her. I have the great pleasure of doing this with women that I now consider my sisters. So thank you, and we look forward to seeing you this evening. Put your dancing shoes on. We have a great DJ. We have the awards. We have winners in this house. Let's get ready to celebrate them and celebrate African arbitration and celebrate each other. So thank you very much, and Godspeed, and see you in about an hour. Don't be late.
We didn't forget, we really are grateful to Victor and the team from KIAC. We are grateful to the Rwanda Bar Association, all our strategic partners, and every one of you. We couldn't do this without you. Everybody was commenting about the quality of the program, and I was saying the program is made possible because of all your contributions. So Victor, thank you so much for hosting us, working with us, and the rest of your team. And also thank you to Steve, Faye, Winnie, Harrison, and everybody working behind the scenes to make this a great success. Thank you.